Police powers concerning public and private meetings are governed by a legal framework that balances the constitutional right to assembly with the state's responsibility to maintain public order and security. And if the police have any powers, then these powers must be derived from a legal framework. And therefore, before we get into the powers in relation to public and private meetings, we are first of all going to discuss the legal framework. Legal framework. Legal framework. Now, the primary laws and the constitutional provisions that define police, and if the police have a police powers. Hello and welcome to the lesson. The subject is meetings. We are still on the first topic, introduction to meetings. Today we are focusing on the powers that the police have in relation to public and private meetings. Police powers in relation to public and private meetings. And here in Kenya, police powers concerning public and private meetings are governed by a legal framework that balances the constitutional right to assembly with the state's responsibility to maintain public order and security. And if the police have any powers, then these powers must be derived from a legal framework. And therefore, before we get into the powers in relation to public and private meetings, we are first of all going to discuss the legal framework. Legal framework. Legal framework. Now, the primary laws and the constitutional provisions that define police powers can be derived from, firstly, the Constitution. So, the first legal framework is the Constitution. The Constitution of Kenya. What does the Constitution say in relation to private and public meetings? Now, Article 37 guarantees every person the right peaceably and unarmed to assemble, to demonstrate, to picket, and to present petitions to public authorities. And this is a fundamental right, but though it's a fundamental right, it is not an absolute right. Because Article 24 of the same Constitution provides that a right may be limited by law, but only if the limitation is reasonable and there is a justifiable reason in an open and democratic society. So that's the first framework. Every person has the right to assemble. Every person has a right to hold meetings as long as the meetings are, as long as those who are assembling or those who are meeting are not armed. You understand? Yes. Now the second part is the Public Order Act. The Public Order Act. The Public Order Act. This act is the main piece of legislation that regulates public gatherings. It outlines the procedures for holding the public meetings and also gives police powers to manage such meetings. So the Public Order Act, that is chapter 56. Number 3, we have the National Police Service Act. Service Act. The National Police Service Act outlines the general functions and powers of the police, including maintaining law and order, protecting life and property, preventing and detecting crime. It also emphasizes that police actions must be in line with the Bill of Rights. That is number 3. Candidates, we are discussing the legal framework that governs police powers in relation to public and private meetings. Number 4, there is a penal code. The penal code. The penal code defines offenses related to public order, such as unlawful assembly, such as riot, and so on. So this is the legal framework that governs police powers in relation to public and private meetings. Now let's get into the powers. Let's begin with the powers that the police have in relation to public meetings. Police powers. Police powers in relation to public meetings. Candidates, first of all, what is a public meeting? We must first define a public meeting, which is defined by the Public Order Act as any gathering of people in a public place where the public or any section of the public is permitted to attend. So a public meeting, by definition, according to the Public Order Act, is just any gathering of people in a public place where the public or any section of the public is permitted to attend. It also includes gatherings of 10 or more people in a public place. So police powers in this context are primarily focused on regulation and ensuring peace. So where such people are meeting, the role of the police is to ensure that peace is maintained. You understand? So the first power here is the power to regulate and facilitate. Power to regulate the meeting and facilitate. The police have the power to regulate and facilitate. The police have a duty to facilitate peaceful assembly, and the Public Order Act as amended outlines a notification process. There has to be a notification. The police must be notified. The organizers of the public meetings or procession must notify the police in charge of the area at least 3 days, but not more than 14 days before the event. And this notification is not a request or a permission to hold the meeting. It's just to inform the police that the members of the public will be assembling or holding a meeting at a certain place. Then we also have the notification. Then there is also the duty of regulating officer. What is the duty of the regulating officer? Now, upon receiving a notice, the regulating officer has the power to respond with recommendations on time, venue, or route to ensure the meeting does not disrupt public order or traffic or other activities. However, if they cannot, the police cannot ban the meeting outright unless there is a clear, present, and imminent danger of breach of peace or public order. So the police have the power to regulate and facilitate. The organizers of the meeting have the duty to notify the police of that area. What we are referring to as the regulating, that is the police in charge of that area. So the organizers of the meeting have notified the police, and the duty of the regulating officer is to ensure that there is order, is to provide security and also to respond to the notice. They may respond by giving recommendations and so on and so on, but the police have no power to ban such a meeting unless there is an outright reason to do so, unless there is a clear and present or imminent danger of breach of peace or public order. Then there is, of course, the organizers. Organizers, what is the duty of those organizing the meeting? Now, organizers are required to assist the police in maintaining peace and also order during the meeting. So, power number one of the police in relation to public meetings is to regulate and facilitate. Then the second power is to disperse or to disperse, not disperse, but to disperse or prohibit. Power to prohibit. Power, disperse, or power to prohibit. Now, police can take action to stop or even disperse a public meeting under specific circumstances. And their powers are not absolute. And these powers must be exercised reasonably and proportionately. Where or what circumstances can lead to prohibition of such meeting? 1. Unlawful assembly. Unlawful assembly. Now, a police officer can order the dispersal of a meeting if it is deemed an unlawful assembly under the penal code. And this occurs where 3 or more people assemble with the intent to commit an offense or cause a breach of peace or cause others to fear such. So, unlawful assembly. Number 2, of peace. Breach of peace. Now, the police have the power to stop a meeting or even a procession when there is a clear, present and imminent danger of breach of peace or public order. And this is a key provision under the Public Order Act, which also provides a legal justification for the dispersal. Breach of peace. Then, of course, we need to talk about use of force. Use of force. The police are permitted to use force to disperse or an unlawful or a riotous assembly, but the force used must be proportional to the objective and seriousness of the situation. And the National Police Service Act emphasizes using non-violent means first. The use of firearms is only permissible in very specific or life-threatening situations under strict regulations. Understand? Yes. So that is, candidates, the power that the police have in relation to public meeting. Then number 3, we are going to discuss the police powers in relation to private meeting. Police powers in relation to private meetings. Now, the legal framework for private meeting is very different from that of public meetings. Because first of all, what is a private meeting? We here first define the public meeting. But what is a private meeting? A private meeting is a gathering held on private property. It could be the company's office or even a private residence that is not open to the public. And generally, the police have limited powers to intervene in a private meeting unless there is a credible reason to suspect criminal activity. Because here we say that notification is required to hold a public meeting, but in a private meeting, no notification. If you are to hold a private meeting, you don't need to notify the police. There is no legal requirement to notify the police about a private meeting, such as a company run a general meeting or a private social gathering. Number 2, the police have limited right of entry. Limited right of entry. In a public meeting, we saw that the police have the duty to regulate the meeting. They have the duty to facilitate the meeting. In a private meeting, police have limited right of entry. The police do not have any automatic right to enter a private meeting or private premises to stop or even monitor a meeting. They have a legal basis for entry, such as a valid search warrant issued by a court or reasonable suspicion that a serious crime is being committed or is about to be committed on the premises. And at times the police have to request from the property owner or an authorized person to intervene where there is disturbance. So the police have limited right of entry into a private meeting. Unlawful acts. Now, if a private meeting turns into an unlawful assembly or a riot, for example, where participants start causing damage to property or assaulting people, then police powers to intervene are then triggered. The meeting's location becomes secondary to the criminal acts that are being committed. For example, if a company's AGM descends into violence, the police have a duty and a right to enter and restore order and to arrest those committing criminal offenses. So the police can only intervene or interfere in a private meeting if there are unlawful acts that are being committed in that private meeting. So that's all candidates for police powers in relation to public and private meetings. We began this lesson by outlining the legal framework for police powers. One, the Constitution, Article 37, the Constitution. Then you have Article 24. Okay. Article 37 guarantees every person the right to peaceably and to assemble or to demonstrate or to picket and to present petitions. But Article 24 of the same Constitution provides that a right may be limited by law. Okay. Then there is the Public Order Act, the National Police Service Act, and the Penal Code. We've discussed the powers of the police in relation to public meetings and also in relation to private meetings. And it's important to note that while the police have a significant role in regulating and managing public meetings to ensure peace and order, their powers concerning private meetings are much more restricted and generally limited to responding to specific criminal acts or threats to the public safety. And the constitutional right to peaceful assembly, coupled with the distinction between public and private spaces, provides a strong basis for those limitations on police power. So that's all for today's lesson on police powers in relation to public and private meetings. Bye-bye. Hello and a warm welcome to the lesson. The subject is meetings. Today we are going to the second chapter, which is professional framework of the corporate secretarial profession. This chapter has 12 sub-chapters. One is evolution of the corporate secretarial profession. Number 2, legal and regulatory framework. Number 3, role and mandate of corporate secretarial professional bodies. Number 4, procedures on registration and deregistration of a member. Number 5, professional qualifications and qualities of a secretary. Number 6, required knowledge, skills, and competencies. Number 7, appointment and vacation of office of the secretary. Number 8, professional engagement and clearance of a corporate secretary. Number 9, rights, statutory and contractual obligations of a corporate secretary. Number 10, role of a corporate secretary. Number 11, continuous professional development, and number 12, disciplinary procedures of corporate secretary. So these are 12 subchapters under the chapter professional framework of the corporate secretarial profession. In this lesson, we begin with the first subtopic, which is the evolution of the corporate secretarial profession. And in studying the evolution of the corporate secretarial profession, we will first of all focus on the global perspective. Global perspective. Global perspective. Then we'll move to case study of Kenya. Global perspective. Global perspective. Now, candidates, the evolution of the corporate secretarial profession marks a shift from a humble clerical role or to a high-level strategic position. Initially, that is to mean that the corporate secretary played clerical duties, but today the corporate secretary sits at the board of a company. The modern company secretaries are now seen as the chief governance officers, or to put it in another way, they are now seen as the guardians of integrity. But traditionally, the corporate secretary performed clerical duties. They had a clerical role. So let's first of all begin with a global perspective of a corporate secretary, beginning with the scribes to strategies. Okay? They were initially scribes, or just individuals in organizations who performed clerical duties, but today they are now strategists because they sit at the board of companies. So the profession has evolved through three distinct historical phases. The first phase is the ancient origins and the scribes. Initially, these were just scribes. So we have the ancient civilization where the secretaries were merely scribes, right? So the first phase, let me put it in phases. Phase 1, the first phase is the ancient origins, all right? Now, candidates, don't forget we want to look at the evolution, how the corporate secretary has evolved from ancient origins and the scribes origins and scribes to the modern day strategies. That's phase 1. And in phase 1, candidates, we have the ancient origins or the ancient civilizations. So we have to first of all identify ancient civilizations, because we are studying the evolution. So we are going into the history of the corporate secretary from the ancient civilizations. Candidates, the term first of all secretary comes from the Latin secretarius, which means a person who is entrusted with secrets. The word secretary is derived from the word secrets. So initially, the corporate secretary was an individual who was entrusted with the secrets of an organization. You understand? The word secretary is derived from the Latin word secretarius, meaning a person that is entrusted with the secrets. And in ancient Egypt and even Rome, secretaries were highly educated men who served as confidants to rulers, and they recorded private state matters. You understand? That is ancient Egypt. Ancient Egypt and Rome. These were men. It's important to note that, because later on we'll be seeing how there was a shift in gender. Initially, it's only men who performed this role of the secretary. In ancient Egypt and Rome, these were highly educated men as the male gender. They served as confidants to rulers, and they recorded secret state matters. Important to know that is in ancient civilizations. Then we have the Middle Ages. When we fast forward to the Middle Ages, in the Middle Ages, the role was largely clerical. All right, the role was largely clerical. The role was largely clerical. The role of the secretary was largely clerical and conducted by the clergy and conducted by the clergy. The role of the secretary was highly or largely clerical, and it was conducted by the clergy. It was conducted in the Middle Ages by the clergy. It was conducted by the clergy, and they were responsible for record keeping and bookkeeping for the church and the nobility. Largely clerical and conducted by the clergy. That's where we get the origin of the word clerk. The word clerk is derived from the word clergy. So in the Middle Ages, the secretary duties were highly clerical, and they were conducted by the clergy. They were conducted by the clergy. They were responsible for record keeping and bookkeeping for the church and nobility. So that is phase one. This is phase one. Then moving to phase two. Phase two. Candidates, are you following? We are describing the evolution of the corporate secretarial practice. So we analyzed phase one. We are moving to phase two, which comprises the Industrial Revolution era. Industrial Revolution. This is the Industrial Revolution. During the Industrial Revolution, this is around towards the end of the 17th or 18th century. Industrial Revolution. Industrial Revolution. Most of you have studied history. If you are a Kenyan, you must have studied history. You must have come across the era we refer to as the Industrial Revolution, which began in the United Kingdom in the 19th century. All right, so here we have the 19th century. After the Middle Ages, we move to the 19th century. We want to see what was the role of the corporate secretary. Now, as we know very well that during the Industrial Revolution, there was the emergence of many factories, many companies that were jointly owned. The joint stock companies, right? As joint stock companies emerged, the Joint Stock Companies Act in the United Kingdom introduced the need of formal records. There was formal need for records. And that is when the company secretary was born. Though primarily as a servant of the board, the corporate secretary was tasked with organizing meetings. The company secretary was tasked with filing records and so on. You can see the role has now shifted during the Industrial Revolution, where many joint stock companies were introduced. In the United Kingdom, the United Kingdom had to enact an act of parliament known as the Joint Stock Companies Act in 1844. In 1844, the United Kingdom enacted an act known as the Joint Stock Companies Act. And through the act, there was formal need for records. The act insisted on a company having formal records. And these formal records were to be kept by the company secretary. The act stated that the company secretary's role, one of the roles was to organize meetings of the board and also to file records. That is the 19th century. Right? You understand? Yes. The Industrial Revolution and legal reforms. That is 19th century. 19th century in UK. United Kingdom. Then it's important at this point to note the shift from the role that was played by men. There was a gender shift. In phase 2, there is now the gender shift. Initially, it was only men that were entrusted with secrets of the state. But with the emergence of industries in the UK, then the role shifted not only to, it was not restricted to men, but also the women. Now, until the late 1880s, the role was male-dominated. But with the invention of the typewriter and the telephone, women entered the workforce, and the role became increasingly associated with administrative support. Before 1880s, it was male-dominated. After 1880s, the field was now open. Women also joined the workforce with the introduction of the typewriter and the phone, and the role of the corporate secretary became largely administrative. That is phase 2. Now moving to phase 3. Phase 3, this is phase 1, then there is phase 3. Now phase 3 is now the current phase, the 21st century. All right, this is the 21st century. In phase 3, we are now in the 21st century, and this is the century of governance professional. In this phase, this is the phase of the governance. This is the phase of governance professional. Governance profession. the governance professional. This is the post-financial crisis, right? The post-financial crisis. Following major corporate scandals like the one witnessed with the two companies, the Enron and the WorldCom, global governance codes like the Cadbury, the Sarbanes-Oxley, they redefined the secretary's role. I know you understand what I mean by governance codes. Global codes of governance. Post-financial crisis. Let me put here an S. Post-financial crisis. After the Industrial Revolution later on, the world experienced crisis in major companies. And to address those the crisis and the financial crisis that was that happened, there was need to put in place global governance codes, which then guided on how companies are to be managed and run. The governance professional phase. Understand? That's when now we have at this moment what we call strategic advisory. Today, the secretary is a board level officer. Strategic advisory. Strategic at the moment, the company secretary is a board level officer. They are no longer just note takers or just taking minutes. No, they advise the board on matters to do with law, matters to do with ethics. They advise the board on sustainability issues. They advise the board on strategic matters and so on. That is the 21st century. So candidates, in a nutshell, this is the global perspective of the evolution of the corporate secretarial practice. Now we shift gears to the case study of Kenya. This is global perspective. We move to the case study of Kenya. Case study of Kenya. We are studying Kenya in relation to the evolution of the corporate secretarial practice. Case study of Kenya. Case study of Kenya. What is the Kenya's professional journey? Now, Kenya's secretarial profession has followed a path of rigorous professionalization and legislative reform, and we have had various milestones. Now let's discuss the milestones that Kenya has undergone in relation to the evolution of the corporate secretarial practice. So milestone number 1. We study here the milestones. Milestones. Milestone 1. Milestone 1. The evolution of corporate secretarial practice case study of Kenya. Milestone 1 is pre-1988. That is the pre-1988, the colonial legacy. That's the first milestone, pre-1988. Number 1, pre-1988, the colonial legacy. Colonial legacy. Now, under the old Companies Act that was based on English law, the company secretary was largely a clerical role. There were no strict professional qualifications, and the person was often a lawyer or an accountant performing secretarial duties on the side. This is pre-colonial era. This era, the colonial era, happened up to 1988. Before 1988, which we are referring to as the colonial legacy, under the old Companies Act, because the Companies Act was changed in 2015. Okay, so before then, the company secretary played largely a clerical role. Understand? Then you have milestone 2. Milestone 2. Milestone, the second milestone. Milestone 2, the second milestone, is professionalization. Professionalization. This is the milestone, we can call it professionalization. And this came about with the enactment of the Certified Public Secretaries of Kenya Act in 1988 that turned things around. The enactment of the Certified Public Secretaries Act in 1988 was a turning point because it established the Institute of Certified Public Secretaries of Kenya. Understand? The enactment of the Certified Public Secretaries of Kenya Act. Right? Let me put it down. The enactment of the Certified Public Secretaries Act 1988 established, this act established the Institute of Certified Secretaries, the Institute of Certified Public Secretaries of Kenya, which now is known as the Institute of Certified Secretaries. Okay, it established, which we now know it as the Institute of Certified Secretaries. Because you cannot have professionalism without an institute, without a professional body that regulates the conduct of these professionals. So this act established the formation of the Institute of Certified Public Secretaries, which is now known as the Institute of Certified Secretaries. It created a professional body to regulate, to examine, and also license secretaries, ensuring that only qualified individuals could act as secretaries for public companies. That's a very big milestone. Before 1988, the role of the company secretary, we've said, was largely clerical. It was largely clerical. That is the pre-colonial era, colonial legacy. But there is that milestone of professionalism. Then the third milestone is the Companies Act, which is the modern era. The Companies Act. The Companies Act. This is the third, 2015. This is the modern era. In the modern era, we now have the Companies Act. The current Companies Act significantly modernized the role of the company secretary. The company secretary is now has what we call an officer status. The Act explicitly recognizes the secretary as an officer of the company. The company secretary is now recognized by the Act as the officer of the company, right? Carrying legal liability for non-compliance. the company secretary now carries a legal liability for the company for non-compliance. The Act introduced a threshold where only private companies with a paid-up capital of, say, 5 million or more are mandated to have a secretary. That is the threshold. For companies, for private companies, there's a threshold. Understand? But all public companies must have a company secretary. That is the law. All public companies, number one, this is the schedule. All companies, public companies, are required by law to have a company secretary. But for private companies, there is a threshold of 5 million Kenya shillings or more. A company with 5 million shillings or more paid up capital is also required to have a company secretary. You understand? Yes. That is a big milestone. The third milestone. The third milestone, the Companies Act, the modern era. You understand? So there is, first of all, official status. I've mentioned official status. The company secretary now has an official status. Is recognized as an officer of the company. Officer status. Officer status. The company secretary now has officer status. That is number one. Number two, the second thing that the Act did was to introduce thresholds. It introduces thresholds. Then the third important thing here is the strategic shift. There's a strategic shift. Because here we've seen pre-colonial era, the company secretary largely played clerical role, but here is playing strategic roles. So there is a shift during the third milestone. So these are three important points that we draw from the Companies Act of 2015. That is during the modern era, and we are discussing today. This is 2026. In 2026, after the enactment of the Companies Act of 2015, during the modern era, 2016, we are referring to the modern era. In the 21st century, the company secretary is recognized as the officer of the company, is explicitly recognized as a secretary, as an officer of the company, carrying legal liability for non-compliance. There is also thresholds where all public companies are required to have a company secretary, and all private companies with paid up capital of 5 million or more are also required to have a company secretary. So that is the modern era. Then there is the last milestone, which is the fourth milestone. Milestone number 4. Milestone number 4. Now, milestone number 4 is the milestone of the governance codes. Here we have governance codes. Governance codes. For example, now that we are discussing case study of Kenya, we have the Mwongozo Code. For example, the Mwongozo Corporate Governance Code. The Mwongozo Code for state companies. The Mwongozo Code for state companies. Code for state companies. Then we have the Capital Markets Authority, right? The introduction of Mwongozo Code for state corporations and the CMA Corporate Governance Code. CMA Corporate Governance Code. The fourth milestone is a milestone of governance codes. And candidates forget we are studying the evolution of the corporate secretary practice, a Kenyan case study. So we have the fourth milestone, which is the governance codes era. We have two codes that we can cite, the Mongozo Code for state corporations, then we have the Capital Markets Authority Corporate Governance Code for listed companies. Right? This code is for, let me be specific, for listed companies. For listed companies, which has placed the certified secretary at the center of institutional integrity. Which has placed the company secretary at the center of institutions integrity. We are talking about governance codes, the code of governance. How these are guidelines that govern how companies ought to operate. And the certified secretary has been placed at the center of institutional integrity. They are now tasked with conducting governance audits, and they are also tasked with the responsibility to ensure that the companies are run ethically. They are to ensure organizations are ethically sound. So that is the evolution candidates of the secretarial practice. Global perspective and Kenyan case study. That's the end of the lesson on evolution. And in studying the global, just to do a recap, the global perspective, there are how many phases? 3 phases. The first phase is the ancient origins and scribes. This is the era of ancient origins and scribe, which we did indicate that during the ancient civilization, number one, we have ancient civilization. During ancient civilizations, particularly in Egypt and in Rome, the profession, I mean, the term secretary, we've said, is derived from the term secretarius, meaning a person entrusted with the secrets. And these persons were entrusted with the secrets of the state, the ancient Egypt and Rome. And these persons were men during that time. Men. That is ancient civilization. Then there is the Middle Ages. During the Middle Ages, the role was largely clerical, and it was conducted by clergy. That's where we get the word clerk. They were conducted by the clergy for the church. They were conducted by the clergy for the church. They were responsible for record keeping and bookkeeping for the church and for the nobility. That is during the Middle Ages. So during phase 1, we have 2 things: ancient civilizations and the Middle Ages. Then in phase 2, global perspective, we have the Industrial Revolution, with the emergence of many factories and farms which were jointly owned, the joint stock companies. Then there was a gender shift with the introduction of the typewriter and the telephone. The women joined the workforce, and at this point, the role of the secretary was largely administrative. During the 19th century, particularly in the UK, the Industrial Revolution happened in the UK, where we had so many joint stock companies that were formed. Understand? Yes. Then phase three is the governance profession. We have the post-financial crisis. We had many companies experiencing financial crisis, like the Enron and the Welcome. Many of them experienced crisis because there was no experience on how to manage companies. Before Industrial Revolution, there were no industries before towards the 18th, end of the 18th century. So there was no experience on how to manage companies. And we know companies are run by human beings. And human beings, they have the tendency to be corrupt. So because of corruption and fraud, many companies experience financial crisis. And as a result of that, then there was as a result of this crisis that happened, following major corporate scandals, global governance course like the Cadbury redefined the secretary's role. There was need to have governance or how to manage companies. So there were roles that were introduced. There was now the strategic advisory role that was to be played by the company secretary. Understand? Yes. Today, the secretary is a board level officer. They are no longer just take notes or take meetings. They advise the board in law, in sustainability strategy, and so many areas. That's it for the global perspective. Then we've gone through the case study of Kenya. There are 4 milestones. Milestone 1 is a pre-1988 colonial legacy era, which the company secretary role was largely clerical. Then there's milestone 2, the era of professionalism. That was the enactment of the Certified Public Secretaries Act, which introduced the Institute of Certified Secretaries. With this institute, then this institute regulates the conduct of these professionals. That is milestone 2. Milestone 3, there is the Companies Act. All right, this is the modern era. In the modern era, under the Companies Act, the company secretary is recognized as the officer of the company. There are also thresholds in the Companies Act where all public companies are required to have a company secretary, and the private companies that have paid up capital of 5 million and above are also required to have a company secretary. The role now again shifts here to strategic. There is a shift. Kenyan perspective, the law gives now given that the officer of the company sits at the board, he now plays strategic role at the board. That is milestone number 3. Milestone number 4 is the governance codes. We have in Kenya now the Mwongozo Code for state corporations. Then there is a Capital Markets Authority corporate governance for listed companies, which has placed the company secretary at the center of institutional integrity. So that is the journey, okay, the Kenya's professional journey as far as company secretaries are concerned. That's the end of the lesson. In our next session, we are going to proceed with this chapter on professional framework of the corporate secretarial practice. We are going to study the legal and regulatory framework. Bye-bye. Greetings, candidates, and welcome to the lesson. The subject is meetings. Today we are still on the topic governance standards and guidelines. We've been studying the governance standards and guidelines. Today we are moving to the governance standards number 8. That is the common seal. In our last session we covered filing annual returns. That is governance standard number 007. Today is 008. The common seal, which governs the use of the company's official signature. This standard governs the use of the company's seal or official signature. And many jurisdictions, candidates, while they have made the use of a physical seal optional, it still remains a powerful tool for executing formal documents, particularly deeds and international contracts. So the GS008 is a standard that defines how the seal is kept, who should keep it, and the specific procedures that are required to make a sealed document legally binding. So the fact that a document has a seal does not necessarily make that document legally binding. No. Before the seal is applied on a document, there is a procedure that has to be followed, and this is what we are going to learn in our today's lesson. But first of all, what is a common seal? What is a common seal? Now, the seal is a stamp. It is a physical stamp or an embosser that leaves an indentation of the company's name and registration number on a document. So it is a physical stamp. A seal is a physical stamp or embosser. A seal is a physical stamp or embosser, right? Which leaves, when stamped on a document, it leaves the company's name, registration number on a document. And under GS008, the seal represents the corporate body itself. It represents the corporate body itself. It represents the corporate body. The seal represents the corporate body itself. You understand? Rather than just an individual director. So that's the meaning of the seal. Then who should have the custody of the seal? Custody. Who maintains or who keeps the seal? Now, because the seal can bind the company to massive financial obligations, security is the top priority. Custody and security. Security is what? Is top priority. So we have the physical security because it is a physical stamp. Given that it is a physical stamp, then the company must make arrangements so that the seal is physically secure. The seal must be kept in a locked safe, right? It must be kept in a locked safe because it's a physical thing. Or a secure cabinet at the registered office. Now, if it's to be kept in a safe at the registered office, now who is to have the key to the seal? Who is the key holder? Your guess is as good as mine. The corporate secretary is usually the designated custodian. And no person should be able to use the seal without formal authorization recorded in board minutes. And that's why there is a sealing process. We have a sealing process. Understand? Yes. A document is not sealed just by stamping. No. To comply with GS008, the process must follow certain steps. we are calling here sealing process. You may get hold of the physical stamp and even stamp a document, but that is not enough. There is a process that must be followed before the document is sealed. For the we can present this in form of a table. We can have here a step like authorization, a step like authorization, a step like authorization. Let me have my pens in order. Then you can have another column for action. And another column here for requirements. Sealing process begins with authorization. Before a document is sealed, there has to be authorization, and this authorization must be done through board resolution. The board must resolve, the board must make a decision, and there has to be a specific resolution. A specific resolution must authorize the sealing of the document. A specific resolution. This is a resolution specifically to authorize the use of the seal. Then the second step is affixing. After authorization, there is affixing, which is the impression, the stamping, the impression. Right? The impression, what's the requirement for impression? Here, candidate, the seal is physically applied to the document. Physically applied, the document is physically, the seal is physically applied to the document. That is the requirement when it comes to affixing. The seal is physically applied to the document. That's what we are referring to as impression. That is affixing. You stamp the document with the seal. Step number 3 is attestation. This is the first step. Second step. Third step is attestation. Attestation requires signatures. Requires a signature or signatures, usually 2 directors or 1 director and the secretary. Director and secretary must sign next to the seal. After stamping on a document, besides the stamp, there has to be a signature by a director. There could be 2 directors and the secretary. Director's signature and the secretary's signature. That is attestation, the signatures. Are you following the process, candidates? The sealing process. The sealing process. Step number 3, attestation. Step number 4 is recording. Recording What action is required when recording? The action is a seal register. Seal register, and the requirement for the seal register is that every use of the seal must be logged in a dedicated register of sealing. Register of sealings. Every use of the seal must be logged into a dedicated register of sealings. Lodged in a dedicated register of sealings. That is the last step. The last step, recording into the seal register. Understand? The seal register, that is the action. So for the seal to be legally binding, for a document to be legally binding because of the seal, then it has to undergo these steps. Called the sealing process. A document is not sealed just by stamping. So if you have a document that is sealed, that is stamped, that is not enough. One has to confirm if that sealing was authorized, if affixing was done, if it was signed, and if that sealing is recorded in the register of dedicated registered sealings. Understand, candidates? Yes. Candidates, we are discussing the governance standard number 008 on common seal. This standard governs the use of the company's official signature. Understand? The standard defines how the seal is kept, who can use it, and the specific procedure required to make the sealed document legally binding. This is the procedure to make the document legally binding. Now let's discuss when is the seal required. When is the seal required? When is the seal required? We want to answer that question. When is the seal required? It's important to understand when a seal is required. Now, in many jurisdictions where seals are still used, GS 008 typically mandates their use for things like deeds, This is real estate transfers, mortgages, long-term leases, and so on. Then it may also be required for shares or share certificates. Share certificates. There are jurisdictions that still require a physical seal to recognize or to as evidence of share ownership. This is for formal evidence of share ownership. It may be required on share certificates. These are physical share certificates. Then there is also, it may be required for international contracts. Sealing may be required on international contracts. You understand? Yes. Physical seal to recognize a contract as valid, mostly international contracts. Or power of attorney. Power of attorney. This is granting someone the right to act on the company's behalf. Granting someone the legal right to act on the company's behalf will require the power of attorney. It will require that right or document to be sealed. You understand? Yes. These are situations where the seal may be required. So lastly, candidates, let's discuss something about the register. We've mentioned here register of sealings. What is this register of sealings? Okay, or the seal register. Seal register. Seal register. Now, to maintain a clear audit trail, the seal register, as per GS006 and GS008, there has to be a record. And this seal register must contain the date of sealing as part of the record. Number one is date of sealing. Any sealing that is done must be registered in a seal register, and the date must be recorded, the date. Then there is the description of the document that is sealed, description of a document. If it is an international contract or share certificate or deed, then it has to describe the document that is being sealed. It could be a lease agreement and so on. 3, authority. The seal register must contain the authority, the date of the board resolution authorizing it, because we said that authorization is by a board resolution. So that has to be clearly recorded in the seal register. The date of the board resolution that authorized the sealing. 4, signatories. The signatories. These are names of the officers who witnessed the sealing. The name of the officers who witnessed the sealing. You remember here there is attestation. What are the names of the directors and the name of the secretaries that witnessed the sealing or signed? Understand? Yes. So that is all, candidates, as for the common seal. It is important to note that many companies now in the modern era, they use what we call execution underhand. That means signing without a seal. However, if the company's articles of association still require a seal, then failing to use it according to the GS008 could make a dollar million, it could make a contract, it could make a share certificate or a deed unenforceable. If the articles require that these documents be sealed, and these documents are not sealed, then such documents may not be enforceable at all. So that is all for today's lesson on GS008, common seal, which we've defined as an embosser. It is an embosser or a physical stamp, which represents the corporate body itself and not just the signature of a director. We've discussed the custody of the seal. The custody of the seal, because the seal can bind the company to massive financial obligations. Security is the topmost priority, and the seal must be kept in a safe and secure cabinet at the registered office, and the company secretary is usually the designated custodian. No person should be able to use the seal without formal authorization. And the authorization process, the sealing process, we've also outlined it here. Begins with authorization, then affixing, attestation, and recording. We've given the requirements for authorization. It has to be a specific resolution that is passed by the board. For affixing, we need the seal to be applied to a physical document. Then there is signatures that are to be signed. The director or the secretary that signs the document, the signatures must appear next to the seal. Then we have said that the seal has to be lodged in a dedicated register of sealings. This lesson, we've identified when the seal is required or used. The seal is used when on deeds, on share certificates, international contracts, and power of attorney. Then lastly, we've done the seal register. The seal register. Seal register. To maintain a clear audit trail, the seal register must contain the date of sealing, the description of the document that is sealed, authority, and the signatures. And that's the end of the lesson on the common seal. Thank you for attending the lesson. We are dedicated to ensuring that you have the required materials for your training and even for those who will be appearing for the KASNEB exams. Go through the video lectures one more time, take notes, attempt past paper questions. We have books that are tailored specifically for meetings. This subject is known as meetings. Just like the rest of the other subjects, you'll find a study text that is well written for all the topics for the meetings subject. Then there is another book known as the revision partner that has KASNEB past paper questions and answers. So at the end of this topic, make sure you go to that book. You'll find the topic on the governance standards and guidelines. We've analyzed all past paper questions that have been tested, topically arranged, and the solutions are at the back of the book. When answering questions, avoid reading the answer. First attempt the question. Take advantage of the active recall style of studying. Don't study passively. Study actively by answering questions, and all shall be well for those who will be sitting for exams. For more tips on how to answer questions, we visit our channels. We have all the information that we require to help you prepare for your professional exams. Bye-bye. Bye. Hello and welcome to the lesson. The subject is business and data analytics. Today we are going to study the various types of data analytics. By the end of this lesson, you should be able to explain at least 3 types of data analytics. Types of data analytics. Types of data analytics. Data analytics, learners, is a broad field, and there are 4 main types of data analytics. There are 4 main types of data analytics. Number 1 is known as descriptive analytics. Number 2, diagnostic analytics. 3, predictive analytics. 4, prescriptive analytics. 4 types. Descriptive analytics, diagnostic analytics, predictive analytics, and prescriptive analytics. Now, each type here has a different goal and a different place in the data analytics process. Descriptive analytics is the first one. Descriptive analytics helps answer questions about what happened answer questions about what happened. What happened. And the techniques here summarize large data sets to describe outcomes to the stakeholders. And by developing the key performance indicators, all right, the strategies can help track successes or failures. And we may also have specialized metrics that are help to track the successes or the failures in an industry. We could have metrics such as return on investment, which is used in many industries, and so on. So the process here requires the collection of relevant data. Here it requires the collection of the relevant data, the processing of the data, data analysis, as well as data visualization. And the process here provides essential insight into the past performance, because data analytics answers the question, what happened? It looks into the past, the history, what happened in the past, what is the past performance, and so on. So descriptive analytics looks into the history, into the past, what happened. The second type of data analytics is diagnostic analytics. And here, diagnostic analytics helps answer the questions about why things happened. Why things happened. This is what happened. Diagnostic answers the question, why things happened. And the techniques here supplement more basic descriptive analytics. They take the findings from the descriptive analysis and digs deeper into the cause of what happened. And the performance indicators are further investigated to discover why they got better, why things got better, why things got worse, and so on. And there are various steps in the diagnostic analytics. The first step being the identification of anomalies in the data. And the anomalies may be the unexpected changes in a metric or a particular market. The second step in the diagnostic analytics is the collection of relevant data. Collection of relevant or related data. This is data that is related to the anomalies. Okay? So first of all, I've said the first step in the diagnostic analytics is to identify anomalies in the data. Then number two, data that is related to the anomalies is collected. Identify anomalies in the data, then collect data related to the anomalies in the data. Then after that, statistical techniques are used to find relationships, to find trends that explain the anomalies. That is diagnostic analytics. I repeat, identify anomalies, step number one. Step number 2, collect data related to the anomalies. Then number 3, use statistical techniques to find relationships, to find trends that explain the anomalies or the cause of the anomalies. Let me put that down. 1, identify anomalies in the data. 2, collect data related to anomalies. 3, use techniques to do what? To identify the, or to find relationships, to find trends that explain the anomalies. Use mathematical or statistical techniques to find relationships and trends in the anomalies. The third type of data analytics is predictive analytics. Predictive analytics, on the other hand, helps answer the question, what will happen in the future? Predictive analytics helps answer the question, what will happen in the future? And the techniques, the techniques here use historical data to identify trends, then determine if they are likely to recur. The predictive analytical tools provide valuable insight into what may happen in the future, and its techniques include a variety of statistical as well as the machine learning techniques, such as the neural networks, the decision trees, the regression, and so on. So based on historical data, the predictive analytical tools can help the firm answer the question, what will happen in the future, by looking at trends in the historical data, the past performance. Predictive analytics, from the word predict. These tools may help a company to answer the question, what will happen in the future? Tools such as regression, machine learning, and so on. Do you understand? Yeah, that is pretty clear. Predictive analytics. Then the last type of data analytics is prescriptive analytics. Prescriptive analytics helps answer the questions about what should be done. What should be done? What should be done? Prescriptive analysis helps answer the questions about what should be done. What should be done. And by using insights from the predictive analytics, data-driven decisions can be made. Data-driven decisions can be made. Based on predictive analytics, data-driven decisions can be made. And that allows businesses to make informed decisions in face of uncertainty. And candidates, prescriptive analytics techniques rely on machine learning strategies that can find patterns in large data sets. Patterns in large data sets. And by analyzing past decisions, by analyzing past events, the likelihood of different outcomes can be estimated. All right? Prescriptive analytics help answer the question, what should be done? This type of data analytics provide insights about insights that businesses need to make effective and efficient decisions. They provide insight that businesses need to make effective and efficient decisions. So these are 4 types of data analytics. We've said data analytics is a broad field. We've briefly described 4 types of data analytics. The first one being descriptive analytics, which you've said answers the question, what happened? Diagnostic analytics answers the question, why things happened. Number 3, predictive analytics answers the question, what will happen in the future. And lastly, prescriptive analytics helps answer the question, what should be done about what should be done by using insights from predictive analytics. We've said also that data-driven decisions can be made, data-driven decisions, because the decisions are based on past data, on past big data. So these are 4 types of data analytics: descriptive analytics, diagnostic analytics, predictive analytics, prescriptive analytics. Here is your today's assignment. Explain 4 types of data analytics, and when doing the assignment, make sure your notes, you don't make reference to notes, you don't make reference to videos. Try and see if you can recall what you have learned from your memory. Thank you. Bye-bye. I greet you all and welcome you back to the Manifested e-learning platform. The subject is meetings, compliance, and administration. The topic is governance, standards, and guidelines. Today we are moving to the governance on the governance standard number 005. Governance standard number 005, which is on board papers. In this lesson, we will be studying the characteristics of effective board papers and what are the requirements. What are the requirements for the preparation of board papers? Because candidates, board papers governs the quality, the delivery, and also the life cycle of information that is provided to the directors. The management is required to provide certain information to the directors before they hold their meeting. And if the board is the brain of the company, then we can say board papers are the fuel. And the standard 005 ensures that directors aren't just receiving data, but they are receiving actionable intelligence. If you are a director of a company, then you need to receive actionable intelligence from the management for you to be able to make informed decisions. So the standard sets the expectations for the management team to provide high quality information that enables informed decision making. Understand, candidates? Because it is the management team that is tasked with the with the responsibility of ensuring that the company records are properly kept, like the financial statements, like information on the day-to-day operations of the business. The management team may have information on marketing, on risk management. They may have information on production, on human resource, and all that. And we know when the directors meet, they have to make certain resolutions. They have to give direction on what the strategy of the company should be, and they need proper information. So that's why we have a standard called Governance Standard 005 on board paper. This standard sets expectations for management to provide high quality information that enables informed decision making by the board of directors. So what are the characteristics of effective board papers? Characteristics. Let's begin with the characteristics. What are the characteristics of effective board papers? Now, the first point is that the board papers must be, one, concise. To meet the GS005 standard, board papers must be concise. They must be concise. That means they should avoid data dumping. It should not be too detailed, but the board papers should provide summaries and key highlights. That's the first characteristic. Number two, clear. Board papers are required to be clear. That means the management should use plain language and avoid internal jargon. It must be clear in clear English that can be understood by everyone. The next characteristic of board papers is correct. These papers should be accurate. The information contained in the papers should be factually accurate with verified data. Or complete. It should include both the pros and cons. All right, both the pros and cons, the advantages and risks of a proposal. If it is a proposal, if the management is making a proposal to the board, then that proposal must have both the merits and also the risks. It has to be complete. Then we have contemporary. The board papers should provide early enough, be provided early enough to be read, but recent enough also to be relevant. Contemporary means it should not be outdated information. It should be recent. Contemporary means recent information. Understand? Provided early enough to be read, because if you are not providing information early enough to be read, you may provide information, but the directors may not have time to read it. It should be early enough, but also recent enough to be relevant. So these are the 5 C's. These are the 5 C's. To meet the GS005 standard, board papers must adhere to the 5 C's. Must adhere to the 5 C's. These are the 5 C's. C. C, 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 C. 5 C's. Concise, clear, correct, complete, contemporary. Concise, clear, correct, complete, contemporary. Concise, clear, correct, complete, contemporary. Okay? That clear, candidates? Yes, that is clear. Now, that's the first thing we are discussing in this lesson. The second thing we are discussing here is the standard structure of a board paper. What is the standard structure? What is the anatomy? What is the standard structure? Number 2, standard structure. Standard. What is the standard structure of board papers? Standard structure of board papers. Now, candidates, a professional board paper typically follows a uniform template so that directors know exactly where to find information. So there is a structure, there is an anatomy of board papers. So one section of the board paper should have a section on the purpose of the board paper. Are you following? Yes, purpose. So let's have purpose and then description. So a professionally prepared board paper follows a uniform template. And in that template, there has to be a section for the purpose of the board paper. The purpose it is for this decision, for discussion or information. You may have a board paper for decision, for discussions, or for information. Is this for decision, for discussion, or information? When the management submits a board paper to the board paper must have a purpose. Is a board paper's purpose for a decision, or is it just for purpose of discussion, or is it a paper that just provides information? Then there is executive summary. Executive summary. Executive summary. A board paper must have an executive summary. This is just an adumbration of the entire board paper. It's just a one-page overview for quick digestion. Executive summary is just a one-page overview. One-page overview for quick digestion. A board paper, if it is too lengthy, then it must have an executive summary, just a one-page overview of the entire board paper for quick digestion, so that someone who may not have time to read the whole of it should be able to read the one page and understand what the board paper is all about. Strategic alignment. Board paper should have a section for strategic alignment. Strategic alignment, candidates, is also very important. That is how the item fits the company's long-term goals. How the item fits the company's long-term goal. A board paper should contain a section that explains how the board paper fits into the company's long-term vision or goal. We are describing, candidates, the standard structure of a board paper. Must have a purpose. There's a section for executive summary, and there is a section for strategic alignment. Another section is financial impact. Financial impacts. A board paper should contain a section that explains the financial impact of that board paper, like budget requirements, return on investment, cost-benefit analysis, and so on. Budget requirements. How much budget is needed if it is a proposal? If the management team is presenting a proposal in form of a board paper, then that board paper, that proposal must have budget requirements. What are the budget requirements? It should also have what we call return on investment. What is the return on investment if it is a proposal? Or even the cost-benefit analysis or cost-benefit analysis. Financial impact. Still on standard structure of a board paper, another section is risk assessment. Risk assessment. Risk assessment. Another key section of a board paper, risk assessment. Risk assessment. What could go wrong and how will it be managed? What could go wrong? This section describes what could go wrong and how it could be managed or mitigated. If the management is submitting a proposal to the board, then there has to be a section on risk assessment which describes what could go wrong, what are the risks, and how could these risks be mitigated or managed. Then lastly, we have a section on recommendation. There must be a section on recommendation. Now, recommendation is the specific action management wants the board to take. Specific action, they must recommend specific action that management wants the board to take. A specific action that the management wants the board to take. Because candidates, you need to understand that the management has a limitation on what can be done. The management may know what is supposed to be done, but they may not have the authority to do it. So the management may be required to present a proposal to the board in form of a board paper, and it has to have these sections. What is the purpose of the board paper? The board paper should have an executive summary, a one-page overview for quick digestion. The board paper should contain a strategic alignment. That means how the item fits into the company's long-term goal. They have to explain. Then there has to be a financial impact. If it is a proposal, what is the budget for implementing that proposal? What is the return on investment for implementing that proposal? And it should also contain cost-benefit analysis. What are the costs and what are the benefits? Does the benefits outweigh the costs? That has to be part of the proposal. Then there's a section for risk assessment. This assessment, these are just identification of the expected risks. Because if you're undertaking a project or anything else, there has to be risks that are associated with that proposal. Then it should also indicate how the risk could be mitigated. Then lastly, there is a recommendation, the specific action that management wants the board to take. So this is the standard structure of board papers. Standard structure of board papers. Do you understand, candidates? Yes. Now, having discussed the characteristics of board papers as per the governance standard number 005 and the anatomy or the standard structure of board papers, we now move to the third section of our today's lesson on the timeliness rule. Number 3, the timeliness rule. The timeliness rule. Now, one of the most critical aspects of GS005, one of the most critical aspects of this standard, governance standards number 005, is the lead time. The lead time, candidates. Lead time. And in most cases, the lead time is a 7-day rule. Most governance standards mandate that board packs be distributed at least 7 calendar days before the meeting. The board, according to this standard, should receive, the board members are required to receive this board papers from management at least 7 calendar days before the meeting is held. That is the lead time. That is the timeliness rule. Understand? Yes. 7-day rule. There is the number 1. 7-day rule. I've explained that the papers should be distributed to the board of directors at least 7 days before the meeting. Then there is the late protocol. The last paper protocol is called the late paper protocol. The late paper protocol. Still on the timeliness, there is the late paper protocol. The late paper protocol. Late papers should be the exception and not the rule, and it often requires the chairman's explicit permission to be tabled. If a paper is not submitted within the 7-day rule, then it has to follow a certain protocol. It cannot be presented to the board unless the chairman tables it. Requires the explicit tabling by the chairperson. Understand, candidates? There are certain times when a paper may delay. We are calling it late paper. Maybe it is submitted in 2 days to the meeting, 1 day to the meeting, 3 days to the meeting. Understand? Yes. That is the timeliness rule. Then in closing this lesson, it's important for us to consider the security and retention of board papers. Security and retention. Security and retention. Very important. Board papers contain the company's most sensitive secrets. Okay? These are very confidential, secretive company documents. And therefore, there has to be guidelines on security and retention of board papers, and that has not been left out by the governance standard 005. So what are the provisions? One is digital portal. The move from paper toward secure encrypted board portals. That is the trend. We have digital portals. Digital portals. Moving away from paper toward encrypted board portals. That is one way to safely keep board papers. Instead of having them in physical files, they can be stored digitally. Number 2, confidentiality. Confidentiality. Directors must delete or return papers after the meeting, or store them in a secure locked environment. Understand? Yes. That is one way to secure and retain board paper. There is also the aspect of access rights. Access rights. Access rights. By access rights, we mean after discussions of the board, the management should only be allowed to access what is relevant to them, while directors have full access. So the management does not have full access to what is discussed by the board. That is very important. Management should only see what is relevant to them. Management should only see what is relevant to them, but the directors can have full access. The directors must have full access to the board papers. But there are times when there is what we call information asymmetry. There are times when these rules are not adhered to, it may lead to information asymmetry. Information asymmetry. When the governance standard 005 is not properly executed or followed by a company, it may lead to information asymmetry. This is where the management has full information, but the board has limited information. When management knows everything and the board knows very little, that may lead to information asymmetry, which may lead to a struggling board. The board struggles a lot to get information, and they may not execute the mandate effectively. And that is why the GS005 comes in to bridge that gap, to help the directors have full information and the management to have access to what is only relevant to them. The GS005 is designed to bridge that gap so that the board does not struggle as a result of information asymmetry. So that's the end of our today's lesson on Governance Standard 005 on board papers. If you have any question, please feel free to ask. Our lines are open, and any question that you send will be answered. Over and above these video lectures, we have prepared exam forecast books for you. We have the study text, which contain full information covering the entire syllabus. Then we have KASNEB past paper examination questions and answers revision kits, which are available in our physical shops. They are available in bookshops. You can also write to us. We deliver the books to you directly. Thank you. God bless you. Bye-bye. Hi, candidates, and welcome to our today's learning session The subject is advanced auditing and assurance. We proceed from where we stopped in our last session. Today we are going to study the International Standards on Auditing number 200 and number 210 as they relate to audit of banks. ISA 200, ISA 200 and ISA 210. The ISA 200 is about objective and general principles governing an audit of financial statements, whereas 210 is about the terms of audit engagements. So let's first look at the ISA 200, objective and general principles governing an audit of financial statements. This standard states that the objective of an audit of financial statements is to enable the auditor to express an opinion whether the financial statements are prepared in all material respects in accordance with an applicable financial reporting framework. The objective of the audit of a bank's financial statements, therefore, should be conducted in accordance with the international standards on auditing. And it is to enable the auditor to express an opinion on the bank's financial statements, which are prepared in accordance with the applicable financial reporting framework. Therefore, candidates, the auditor's report indicates the financial reporting framework that has been used to prepare the bank's financial statements, including identifying the country of origin of the financial reporting framework when the framework is used, or when the framework is not used, or when the framework used is not, when the framework used is not international accounting standards. So when reporting on financial statements of a bank prepared specifically for use in a country other than that under whose rules it is established, the auditor considers whether the financial statements contain appropriate disclosures about the financial reporting framework used. That is the provisions of the International Standards on Auditing number 200. All right. Objective and general principles governing an audit of financial statements. I've said that the objective of an audit of financial statements, here we are talking of general statements of all the types of businesses, including banks. The objective is for an auditor to enable an auditor to express an opinion whether the financial statements are prepared in all material respects in accordance with an applicable financial reporting framework. How about ISA 210, which is in relation to terms of audit engagement? ISA 210, terms of audit engagement. Terms of audit engagements. Terms of audit engagements. Candidates, the engagement letter documents and confirms the auditor's acceptance of the appointment. All right? That's number one. The point is that the engagement letter does what? Documents and confirms the auditor's acceptance of the appointment. The letter also documents the objective and the scope of the audit, number two. Number three, the letter documents the extent of the auditor's responsibility to the client and the form of any reports. Therefore, candidates, in considering the objective and the scope of the audit and the extent of the responsibilities, the auditor considers his own skills and competence and those of his assistants to conduct the engagement. And in doing so, the auditor considers certain factors, such as, one, the use and source of specialized accounting principles with particular reference to number one, any requirements contained in the law or regulations applicable to banks. Number two, pronouncements of the banking supervisory and other regulatory authorities. Three, pronouncements of relevant professional accounting bodies. For example, the International Accounting Standards Board. Four, the pronouncements of the Basel Committee on Banking Supervision. And finally, number five, industry practice. So when issuing an engagement letter, apart from the provisions of ISA 210 on terms of audit engagements, there are other factors that the auditor needs to put into consideration. So I've mentioned one of the factors, and this is the use and the source of specialized accounting principles with the particular reference to the five aspects that I've mentioned. Then number two is the contents. The auditor should consider the contents and the form of the auditor's report on the financial statements and any special purpose reports required from the auditor in addition to the report on the financial statements. And this includes whether such reports refer to the application of regulatory or other special purpose accounting principles or describe procedures undertaken especially to meet regulatory requirements. Then number three, the nature and any special communication requirements or protocols that may exist between the auditor and the banking supervisory or other regulatory authorities like the central bank. Then number four, we have the access that bank supervisors will be granted to the auditor's working papers when such access is required by the law, and the bank's advance consent to the access. So those are some of the factors that the bank auditor should consider when issuing an audit engagement letter. And that effectively brings to conclusion of our today's lesson, where we've considered two aspects, that is the ISA 200 and ISA 210, the terms of audit engagements. In our next session, we'll commence our study on the audit plan of a bank, audit planning when carrying out the audit of a bank. Thank you and God bless you. Hello everyone and welcome to the lesson. The subject is governance, compliance, audit. The topic is peer review mechanism. Today we are moving to the second subtopic, which is responsibilities of parties in peer review. In our last session, we defined peer review in the context of governance and auditing as the process of systematically and independently evaluating of an audit firm's quality control system and its adherence to professional standards and ethical guidelines. Auditors are required to adhere to ethical guidelines. They also have a regulatory framework within which they operate, and also professional standards. So peer review is where other reviewers audit the work of the auditors. In other words, it is essentially auditing the auditors to ensure that they are performing their work competently and ethically. That's what we learned in our last lesson. Then we discussed the purpose of peer review, the scope of peer review, and types of peer review. Today we are going to discuss the responsibilities of the parties involved in peer review. And peer review in governance and compliance auditing involves distinct responsibilities for several key parties. And these responsibilities ensure the integrity, the objectivity, and effectiveness of the review process, ultimately contributing to a higher quality audits and enhanced public trust. And the main parties involved in a peer review in the governance and compliance audit context are the reviewed firm, the firm that is being reviewed, the audit firm that is being reviewed, or what we call the auditee of the peer review. Then we have the peer reviewer, okay, the firm that audits the auditor, the firm that reviews the auditor. That's the second key party. There are two key parties. In this lesson, we discuss the responsibilities of the parties, beginning with the reviewed firm. Let's discuss the functions. One, of the reviewed. The reviewed firm. It could also be the internal audit function. The internal audit function. The reviewed firm. Now, this is the entity whose governance and compliance audit practice being evaluated. What are the responsibilities of the reviewed firm? One is cooperation and transparency. There is a responsibility to cooperate. Cooperation. There is a responsibility related with cooperation and transparency. The reviewed firm has the responsibility to cooperate and to be transparent, like providing access to information. They have a responsibility to provide access, providing access to information. That means granting the peer review team full and timely access to all requested documentation, including audit engagement files, quality control policies and procedures, personnel records, training materials, client acceptance and continuous documentation, and any other relevant information. That's providing access. Then the second point in relation to cooperation and transparency is facilitating interviews. They have a responsibility to facilitate interviews. They have a responsibility to facilitate interviews. Candidates, you recall in discussing the scope of peer review, we did mention that interviews is one of them. For the peer reviewer to get information, the peer reviewer has to conduct interviews with the key personnel management and also the audit managers and so on. So facilitating interviews. That means making relevant personnel like the partners, the managers, the audit staff, the quality control personnel available for interviews with the peer review team. Responding to inquiries. Responding to inquiries. Responding to inquiries is also a responsibility. The reviewed firm has a responsibility to timely and thoroughly respond to all inquiries and requests for clarification from the peer review team. They are also required to be forthcoming. The reviewed firm is required to be forthcoming. That means disclosing any known issues or concerns related to their quality control system or specific engagements. So that's the first responsibility. Cooperation and transparency. Then number two, the second responsibility is in relation to understanding and adherence. Understanding and adherence. Understanding and adherence. That means that the reviewed firm has the responsibility to understand requirements. It has the responsibility to, first of all, understand requirements. Understand requirements. Be thoroughly aware of the professional standards applicable to their governance and compliance audit practice and the peer review standards themselves. So the firm that is being reviewed, the governance and compliance audit firm, should understand the requirements, the professional standards that are required to adhere to. So we are talking about adherence. So first of all, they need to understand the standards, professional standards, ethical guidelines that govern governance and audit practice. Right? Then after understanding requirements, they are required to maintain quality control system. They have a responsibility to maintain quality control system. Maintaining quality control system. That means having in place a peer review. That means having in place and consistently applying a robust system of quality control that addresses leadership, ethical requirements, client acceptance, human resources, engagement, performance, and also monitoring, maintaining quality control system. So candidates, we are discussing the responsibilities of parties involved in peer review. We have begun with the reviewed firm or the internal audit function. Now, related to understanding and adherence, the reviewed firm ought to understand what we call logistics and administration. They have a responsibility in relation to logistics and administration. Logistics and administration. What does that mean? It means engaging a qualified peer reviewer within the required time frame set by the administrative entity, administering entity. Logistics and administration also means scheduling and coordination, which implies working with the peer reviewer to agree on the commencement and anticipated completion dates of the review. They have a responsibility in relation to logistics and administration of the peer review. The reviewed firm also has a responsibility to designate a knowledgeable individual as the peer review contact who is accountable for providing complete and accurate information. Another responsibility in relation to understanding and adherence is the responsibility of rectifying deficiencies. If deficiencies are identified, then the organization ought to develop and implement a corrective action plan to address them within the agreed upon timelines. So that's the meaning of understanding and adherence. You understand, candidates? Another responsibility is just paying fees. Because it is the firm that is being audited, the audit firm that is being reviewed, another responsibility is just in relation to payment of fees. That means bearing the costs associated with the peer review. So those are responsibilities in relation to logistics and administration. So here we are saying there is timely. Let me summarize the points that I've discussed. There is timely engagement of reviewer. The reviewed firm has a responsibility to engage a reviewer. That's the responsibility of the firm that is being reviewed. There is scheduling and coordination. Scheduling and coordination. Scheduling and coordination means working with the peer reviewer to agree on the commencement and anticipated completion dates of the review. Scheduling and coordination. That is a responsibility of the reviewed firm. Then there is providing point of contact. Point of contact. That means assigning an individual who will provide information to the reviewer as the work goes on. There has to be someone who is designated by the reviewed firm to provide any information that is requested by the reviewer. That's what we mean by point of contact. Designating a knowledgeable individual as the peer review contact who is accountable for providing complete and accurate information. There is also rectifying deficiencies. Number 4, rectify deficiencies. rectifying deficiencies. After carrying out the review, deficiencies may be identified in the reviewed firm. The reviewed firm then, if deficiencies are identified, the reviewed firm has the responsibility to rectify such deficiencies. If deficiencies are identified, the reviewed firm should develop and implement a corrective action plan to address them within agreed upon timelines. Pay fees, that's a responsibility. Any fees that are associated or related to the peer review has to be paid by the reviewed firm. That is the responsibility of the reviewed firm. Payment of fees, any costs that are associated with the peer review. So all these are responsibilities, candidates, of a reviewed firm, which is one of the parties in a peer review. Then the other party is the reviewer, the peer reviewer. This is number one. Number two, peer reviewer. What are the responsibilities of the peer reviewer? Okay. Now, peer reviewer are the independent professionals or firm who conduct the peer review. So what are the responsibilities? Now, the first responsibility is in relation to independence and objectivity. One, independence and objectivity. Independence and objectivity. That means maintaining independence. Maintaining independence is a responsibility of the peer reviewer. Maintaining independence. That means ensuring independence from the reviewed firm, which includes avoiding any financial, personal, or professional relationship that could impair objectivity or create conflict of interest. Then conflicts to objectivity and independence is disclosing of conflicts. Disclose conflicts of interest. The peer review team has a responsibility to disclose any conflicts. It should promptly disclose any potential conflicts of interest to the administering entity and also decline the review if objectivity cannot be maintained. Professional skepticism is a responsibility. Professional skepticism is required of the peer reviewer. That means approaching the review with a questioning mind and critically assessing the evidence obtained regarding the reviewed firm's quality control system and engagement performance. So that's the first objective. That's the first responsibility. First responsibility, independence and objectivity. Number two, the second responsibility relates to what we call competence and due care. Competence and due care. Competence and due care is a responsibility required of the peer reviewer or the peer reviewer team. That is to mean that this team should possess, first of all, expertise. It should possess expertise. That means having current knowledge of professional standards applicable to governance and compliance audits, quality control, and peer review standards. And this often requires specific training and experience. Number two, plan. Another responsibility is planning and performing review. Plan and perform review. That is the responsibility of the peer reviewer. Planning and performing the peer review in accordance with the standards established by the relevant professional bodies and administering entities. There is also a responsibility in relation to evidence, sufficient evidence. Sufficient evidence. That means obtaining sufficient appropriate evidence to support the conclusions reached in the peer review report, and this includes selecting an adequate sample of engagements and thoroughly reviewing relevant documentation. Candidates, the work of the reviewed firm is to carry out governance and engagements on different firms. For example, in a financial year, the reviewed firm, the audit firm may have 10 audit engagements. The reviewer, who is the auditor of the auditors, is required to gather sufficient evidence. That means selecting a sample out of the 10 audit engagements and carrying out the peer review to establish or to gather sufficient evidence, which evidence will be used to form an opinion or draft a peer review report. You understand? Yes. Professional judgment is a responsibility. Professional judgment is yet another responsibility. That means exercising sound professional judgment throughout the review process, particularly when evaluating the design and effectiveness of the quality control system and the conformity of the engagements. Professional judgment. The third responsibility, major responsibility, these are sub-responsibilities, candidates. So we are categorizing them into these classes. So we have independence and objectivity, competence and due care. Then the third one is what we call reporting and communication. There are responsibilities related to reporting and communication. The peer reviewer has responsibilities relating to reporting and communication, like preparing review reports. Preparing review report. Preparing review report. That means preparing a comprehensive peer review report that clearly states the scope, methodology, findings and conclusions. Communicate findings. That's another responsibility. Communicate findings. The reviewer has a responsibility to communicate findings and recommendations to the reviewed firm's management, and where applicable, those charged with governance in a clear, constructive and timely manner. The peer reviewer has a responsibility to communicate findings. There is also the responsibility on confidentiality. Confidentiality. Confidentiality is a responsibility. That is to mean that the reviewer should maintain strict confidentiality of all information obtained during the peer review process. The reviewer should not in any way disclose or use confidential information for personal advantage or to disclose such information to third parties. That is a responsibility. Timeliness is a responsibility. Timeliness. What does that mean? That means completing the peer review within the agreed upon deadlines. So this is the third category of responsibilities of the peer reviewer. The fourth category is what we call the No, these are all. Yes, these are 3 categories. We've done the report. Yes, reporting. This is the last one. Okay. This is the last one. So the candidates, that is it for responsibilities of the parties involved in a peer review. Though at sometimes I think it's important for us to get into the oversight. We can discuss the third party. These are the key parties. These are the responsibilities of the key parties in peer review, and they include the reviewed firm and the peer reviewer or the peer reviewer team. Peer reviewer team. We may have the third party, which is the administrative entity or the peer review oversight body. Peer review, let me just discuss it. Peer review oversight. The peer review oversight body or the administrative entity. The peer review oversight body. Now, the peer review oversight body, candidates, is our third party. Okay? The peer review oversight body. Initially, I said there are 2 key parties, that is the reviewed firm and the peer reviewer. But we also may have the peer review oversight body. And this is the professional organization or the regulatory body responsible for overseeing the peer review program. All right? So what are the responsibilities of the oversight body or regulatory body? So one obvious responsibility is oversight. Program administration and oversight. 1. Program administration and oversight. Program administration and oversight is one of the responsibilities of the oversight body. All right? It is one of the responsibilities of the oversight body. That means establishing standards, like establishing standards. It is the responsibility of the peer review oversight body to establish peer review standards. Because the peer reviewer, in the process of carrying out the review, must be guided by certain standards, and these standards are defined by the oversight or regulatory body. This body develops and maintains the standards for performing and reporting on peer reviews. Another responsibility is enrollment. Enrollment and monitoring. Enrollment and monitoring. All right? What does that mean? That means enrolling firms and functions in the peer review program, and also monitoring their compliance with the peer review requirements. Review qualification. Review qualification is yet another responsibility of the oversight body. So the oversight body establishes and monitors the qualifications and training requirements for peer reviewers. Reviewing qualification of the peer reviewers. That is the role of the peer review oversight body. Are you following, candidates? We are discussing the responsibilities of the third party, which is the peer review oversight body. Quality control. Quality control is another responsibility. That means conducting oversight procedures or technical reviews or DEX reviews or on-site visits to ensure that peer reviews are being performed in accordance with established standards. Then we have also report acceptance. It's what we call report acceptance. This is yet another responsibility of the peer review oversight body. That means establishing a committee, what we call a peer review committee or a report acceptance body, to review and accept peer review reports and propose corrective actions. Resolution of deficiencies is another responsibility. Monitoring the implementation of corrective actions by reviewed firms and taking appropriate action if deficiencies are not remedied. If the deficiencies are not corrected. You understand? Yes. There is another responsibility in relation to public interest. Public interest. Public interest. Here, the body ensures the peer review program serves the public interest by promoting quality in audit services. So these are 1, 2, 3, 4, 5, 6, 7 responsibilities under the major category program and administrative oversight. These are administrative and oversight functions of the peer review oversight body. Then you have support and guidance. This is A. B. Support and guidance. This is a responsibility of the peer review oversight body, providing support and guidance through maybe just offering guidance and resources to both the reviewed firms and the peer reviewers on the peer review process and related standards. Providing guidance. Provide guidance. And also in supporting and guidance, the body, the oversight body, may also maintain records. Maintaining records is a responsibility. Maintaining records. That means keeping accurate records of all the peer reviews conducted and their outcomes. All right. Then lastly, we have enforcement, if applicable. That means taking disciplinary action against firms or reviewers who fail to comply with program requirements or professional standards, which can include sanctions, suspension, or even termination of program enrollment. So these are the responsibilities of the peer review oversight body. And that's the end of our today's lesson, where we've discussed the responsibilities of parties involved in peer review. There are three main two main parties, then you have the peer review oversight body. So we began by analyzing the responsibilities of the peer, of the reviewed firm. The first responsibility is in relation to cooperation and transparency. Cooperation and transparency. Number two is understanding and adherence. The third is, so we just had two major groups, but these are sub responsibilities. These points explains the main points, which here we have understanding, adherence. For example, understanding adherence, understanding and adherence may mean understanding the requirements. These are professional standards and ethical guidelines. The reviewed firm has a responsibility to understand the requirements. Professional standards, ethical guidelines, and the regulatory framework. Maintaining quality control. There is also logistics. The reviewed firm has the responsibility to engage the reviewers on time. That's what I mean by timely engagement of reviewers. Then there is also scheduling and coordination and providing contact person, the one who will now be providing accurate information to the peer reviewer. There is also rectifying deficiencies. At the end of the review process, deficiencies may be identified in the reviewed firm's adherence, or it could be a deficiency. So this firm has a responsibility to rectify the deficiencies. Another responsibility is paying fees to the reviewer. Now the second party is the reviewer. The reviewer has also responsibilities. One responsibility is in relation to objectivity and independence. That means maintaining independence, disclosing conflicts of interest, and professional skepticism. Professional skepticism means maintaining a questioning mind throughout the review process. The second category is competence and due care. Competence and due care means possessing expertise, planning and performing reviews, gathering sufficient appropriate evidence, and professional judgment. Then the last responsibility relates to reporting and communication, preparing review reports, communicating findings, confidentiality, maintaining confidentiality, and providing the reports on timely basis on agreed upon deadlines. The third party is the peer review oversight body. There is responsibility related to program administration and oversight. That means establishing standards, enrolling and monitoring, reviewing qualifications of the peer reviewer. There is also quality control and reporting acceptance, resolution of deficiencies, and public interest. The second category is support and guidance, providing guidance and maintaining records. Then enforcement. Enforcement means taking disciplinary action against firms or reviewers who fail to comply with program requirements or professional standards, which can lead to sanctions, suspension, or even termination of what we call the program, termination of program enrollment. So that's the end of the lesson, candidates, and it's important to note that by clearly defining and adhering to these responsibilities, peer review effectively serves its purpose of enhancing audit quality and also maintaining confidence in governance and compliance assurance functions. We will continue to share knowledge in our next session. For now, we take a break. If you have any question, please, below this video, there is a comment section where you can post your questions. Thank you. Bye-bye.
Now, can look at a similar question, the previous question. We can look at a previous question. It has been tested just a few semesters back. Let's go to September 2021. September 2021. September 2021. Question who? 5B. September 2021. Question 5B. The question is saying the standard cost of certain chemical mixture is 40% material A at 20 per kg, 60% material B at 30 per kg. The standard loss of 10% is expected during production. During the month of July, the actual data was as follows. Material A used 90 kgs at a cost of 18 per kg. Material B used 110 kgs at a cost of 34. The weight produced was 182 kgs of good production. Let's start by getting our material mix, our material price variance. Our material price variance, you say it is your actual quantity, standard price minus actual price, Your actual quantity, you have two types of materials, A and who? B. The actual quantity you purchased was 90 kgs. The standard price per kg was 20 minus an actual price of 18. For material B, your actual quantity was 110. Standard price per kg was 30 and your actual price per kg was 34. 30 minus 34. This must be 180. That must be 400 and what? 40. The standard or the material price variance here for A, you had budgeted to buy at 20, but instead of buying at 20, you bought at what? 18. So that's good. So that is what? Favorable. B, you had budgeted to buy at 30, ended up buying at 34. So that is also what? That is adverse because you've spent an extra amount. Then you confirm what kind of variance this is, and this is 250, which is what? Adverse. 260, which is adverse. That is your material price variance. Let's get our material mix variance. And how do you get your material mix variance? You say it is your standard price, your actual quantity in standard mix minus your actual quantity in actual mix. Standard price, actual quantity in standard mix minus actual quantity in actual mix. And actual is standard price B. The standard price of A is 20, B is 30. Your actual quantity that was used is 90 for A and 110 for B. Your standard mix, the ratio of how you are using your materials is 40 is to 60. That is 200. That is 100. Therefore, actual quantity in standard mix you simply share the actual quantity using the ratio of your standard mix, using the ratio of your standard mix. And how will that be? This will be 40 over 100 times 200, 60 over 100 times 200. That is 80, and that is what? 120. Alright, your actual quantity in actual means we said, in actual mix we said is your actual quantity. So let's get your material mix variance here. Your standard price is 20. Actual quantity in standard mix is 80. Minus an actual quantity of 90. 100. Standard price of 30. Actual quantity in standard mix of 120. Actual quantity in actual mix of 110. This will be adverse, favorable. So that in total, that will be 100 favorable. Okay. The next item they are asking us to determine is your material yield what? Variance. Material yield variance. You said, how do you get that? You simply take your standard material cost per unit into bracket your standard yield minus your actual yield. Standard yield minus actual yield. Let's determine our standard material cost per unit. They were saying there that the standard cost of material of a certain chemical, 40% of material B was bought at 20, 60% of material B was bought at 30. So therefore, your material cost per unit, you're going to take those percentages times the price of each. Which will be 26. That should give you 26. Let's determine our standard yield. Then now need to determine our standard yield. Now they were saying the standard cost of a certain chemical mixture is 40 and 60, and a standard loss of how much? 10% is expected during what? Production. Okay. So this is what we do here. We first identify the input materials that were introduced and the output that was done what? Produced. Okay. And here with an 100% input of materials, with an 100% input of materials, your output was 90%. Your output was what? 90%. Why? Because of a standard loss of 10%. 10%. Okay. If you introduce 200, this can ignore this percentage here, that way. If you introduce 200, how much should have been your standard yield there? Your standard yield should have been 180 units. If you are to use the material in the same way you are using according to what you budgeted, you should have produced 180 units. So your yield variance will be 26, 180 minus an actual yield of 182. Your actual yield is 182. This is 52, which we are going to say is what? This is an output. This is output. So yield means output. So we are going to say it is what? Favorable. Favorable. Okay. Your material usage variance, it's going to be your material mix variance plus your material yield variance plus your material yield variance. Your mix variance is 100 favorable. Your yield variance is 52 favorable. So that is 162 what? Favorable. Let's determine our material cost variance, which is your material price plus your material usage variance. Your price variance is 260 adverse plus 162 what? Favorable, which means that is 98 what? Adverse. 98 adverse. And that is how you determine your what? Your advanced variances of who? Of material. Those are the advanced variances of what? Material. All right. Now that we have understood the advanced variances of material, we also should look at the advanced variances of labor, the advanced variances of fixed overheads, and also the advanced variances of sales revenue. Okay. All right. I hope that has been clearly understood. That has been clearly understood. That has been clearly understood. Right. Now, when we meet in the next lesson, we will introduce the advanced variances of what? Labor. We will introduce the advanced variances of labor, which will be in the next lesson. So from me, you can attempt a question, to give you a question that you can attempt in your own free time. You can look at August 2022 question 5B as an assignment, just for your practice. Your assignment. Please look at this question for your own practice. August 2022 question 5B. Question 5B. There is a variance of what? It is an advanced variance of materials. All right. So allow me, and on behalf of the institution, or on behalf of Manifested Publishers, we can call it a day. See you next time when we will tackle labor variances and overhead variances and sales variances that are advanced in nature. So goodbye and God bless you. See you next time.
Greetings to you all and welcome back to the lesson. Today we are continuing with the subject strategic management. We've been studying business strategies and models. We've covered the generic competitive strategies. Today we move to the interactive strategies. Now, in studying interactive strategies, we are going to consider the interactive price and quality strategies. Then there is the cooperative strategy and the game theory. But first of all, what do we mean by interactive strategies? Interactive, from the word interact, to interact. Interactive strategies refer to a competitive framework where a firm's strategic choices are made based on the anticipated actions and reactions of other market players. This is unlike the generic strategies which focus on internal positioning. Greetings, candidates, and welcome back to the lesson. The subject is Governance and Compliance Audit. The chapter is Post-Governance and Compliance Audit. Now, in Post-Governance and Compliance Audit chapter, we only have two sub-chapters. The one we studied in our last session, which is nature and scope of subsequent events. Then today we move to the general guidelines on subsequent events. Now, before we get into the guidelines, I want to reiterate that subsequent events, first of all, are significant occurrences, either favorable or unfavorable, that take place between the end of the audit period and the date the final audit report is signed. So in a governance and compliance audit, subsequent events are evaluated based on their impact on the audit's maturity score and the overall opinion on the organization's adherence to standards like the Institute of Certified of Secretaries of Kenya governance standards. And the subsequent events, they follow the logic of ISA 560, and due to that logic, they are classified into two, based on whether they confirm a pre-existing state or whether they introduce a new risk. That's why in our last session we said that subsequent events can be categorized into two, the adjusting and the non-adjusting events. There are two types. Type 1 is adjusting events. Adjusting events. Types A, adjusting events. This is just confirming. This is confirmatory. Events that happen after the end of the audit period and before or after the audit report is signed. So we have adjusting events. We've said in our last session that these events provide further evidence of conditions that existed during the audit period. And these events typically lead to change in the audit score or even modification of the audit findings. Examples of adjusting events could be legal settlement. Legal settlement. For example, a legal settlement. It could be a court ruling, say in March 2026, for a case that was active throughout the year 2025. So the audit period ends in, say, December 2025. This is the audit period ending December 2025, but in March 2026, this legal settlement, the court ruling in 2026, this is a subsequent event. This is an event that happens after the end of the audit period. Are you following, candidates? A legal settlement. So the ruling, this legal settlement only confirms whether the board's previous contingent liability, the contingent liability disclosure, it confirms whether the contingent liability disclosure was sufficient or if there was a systemic failure in the legal risk management. So this is an adjusting event. It confirms the condition that existed up to the audit period. That's one example of an adjusting event. Another example of adjusting event is discovery of fraud. Discovery of fraud. This means finding evidence, say in February. In February 2026, there is discovery of fraud. Okay? Finding audit evidence in February 26 of a kickback scheme. The fraud could be a kickback scheme that was operating secretly during the year ending December 2026. There was this secret scheme, kickback scheme, that was operating secretly during the audit period. But it has been discovered in February 2026. That is an adjusting event. That discovery proves that the internal control framework was not effective during the period under review. The period under review is up to December 2025. So the fraud is discovered in February 2026. This is a subsequent event. It happened after the end of the audit period. You understand? You may have things like tax audits. Tax audits. It could be a final assessment from the Kenya Revenue Authority that is received post-audit. After the post-audit, KRA conducts investigations or carries out an audit of the company, showing that, for example, tax filing errors were discovered and so on. Tax audit. That could also be a subsequent event that is that happens after the audit period. So these are just giving examples, candidates. It could be regulatory fines. Another example, regulatory fines. For example, receiving a formal penalty notice from the Office of the Data Protection Commissioner in, say, early January. It could be early January 2026. This is after the audit period. The company is fined. It could be for data breaches that occurred in 2025. And that confirms non-compliance with the Data Protection Act. That means that the company did not comply with the Data Protection Act in the year 2025. And that may happen post the date, okay? Post-audit date. So that is another example. So let's move to non-adjusting events. This is another type, non-adjusting events. Non-adjusting events. Non-adjusting events, these are disclosures. These are new events that did not exist prior to the audit period. These relate to conditions that arose after the audit period. These are conditions that arise after the audit period. They do not change the 2025 score, but they are so material that they must be disclosed to ensure the report is not misleading. One example could be board resignations. Say 40% of the board members have resigned. Sudden resignation of, say, 40% of the board. For example, the chair has resigned, the audit committee lead has resigned in January, immediately after the audit, or March or February. Now, while the 2025 board was stable, the 2026 board is now in a governance crisis. When you are auditing this company in 2025, the board was intact. But in February, 40% of the board members have resigned. So that is a non-adjusting event. This is an event that is arising after the audit period. It may not change the 2025 score, but is a serious matter that needs to be disclosed so that those who are relying on the 2025 report are not misled. Mergers and acquisitions. mergers and acquisition. It is a merger or the company has acquired another company. Signing a deal to be acquired by a foreign entity 2 weeks, say, after the year 2025 audit period, that significantly changes the organization's stakeholder landscape. It is an event that did not exist in 2025, but in 2026, that is the position. We have merger or so that is another non-adjusting event. It could be major disaster. Major disasters could be a fire outbreak that demolishes the entire server room, a fire or a cyber attack in February 2026 that destroys the company's primary data center, and that tests the business continuity plan and must be disclosed as a significant risk to governance in future. It has to be disclosed. Example for new legislation. These are examples of candidates of non-adjusting event. There's a new legislation, for example, the enactment of a new law, or it could be change in the Companies Act. So that did not exist in 2025, but that happens after 2025, say in February 2026. A new legislation that makes previous best practices now mandatory requirements. We are new provisions that did not exist in 2025, but because of the new law, what was regarded as best practice now becomes mandatory requirement. So that's it, candidates, for the types. We are discussing post-governance and compliance audit, the adjusting and non-adjusting events. This is just to reinforce what we did in our last session. So let's now shift to guidelines. That is our focus for our today's lesson. This was to reinforce what we covered in our last session. These events. Adjusting events, non-adjusting events. Today we are focusing on the general guidelines for auditors when it comes to subsequent events. Guidelines. Now, the auditor's objective, candidates, in regard to subsequent events is to ensure that the report reflects the true and current governance state of the entity at the time of signing. That's the objective. That's why an auditor has to conduct what we call proactive procedures. Proactive procedures. Because at the end of the audit period, as an auditor, you may not be aware of some of these events you are talking about. And that's why you need to be proactive as a governance and compliance auditor so that you can discover some of these guidelines. Because your objective as an auditor is to ensure that the report that you are issuing to the stakeholders reflects the true and current governance state of the entity at the time of signing that report. But you've seen there are some events that may occur, like the adjusting events, which may force you as an auditor to adjust your audit opinion. So that's why you have to be proactive. As the report date approaches, as an auditor, you should inquire with management. 1, inquire with management. And what are you inquiring about? You need to specifically ask the CEO or the company secretary if any material non-compliance has occurred since the field work ended. Then you become another way proactive through reading. You read minutes before the report is signed. Read board minutes. review minutes of any board or committee meetings that is held after the audit period. That would be, say, you check if there was if the audit period ends, as we've been discussing, December 2025, then you need to check if there was any board or committee meeting in January 2026, February 2026, March 2026. That is before the report is signed. You check if there were any changes or any information that relates to the subsequent events. 3. Search regulatory portal. Be proactive by searching the regulatory portal. Regulatory portal. Check for new filing on eCitizen or Business Registration Service to ensure there is no late filings or changes in beneficial owner during that period. So these are just 3 ways to become proactive. This is a guideline to help you ensure that the report that you are issuing is reflecting the true and current governance state. Then, of course, there is number 2, response to material deviations. Responses to material deviations. Responses to material deviations. If an event is discovered that significantly changes the governance score, then you can evaluate disclosure. One thing you do is to evaluate disclosure. Evaluate disclosure. Determine if management has disclosed the event in the notes or the chairman's statement. Then you can report modification. Report modification. What do we mean by reporting modification? If that means that if the event indicates a systemic failure in governance, like massive fraud uncovered post-audit, then the auditor may need to modify the governance and compliance opinion. To modify the opinion if it is significant. That's a very important guideline. Then number 3, communication. Communicate. Inform those charged with governance immediately in order to discuss how the events impact the final scoring. You have to communicate immediately. Those charged with governance, that could be the audit committee, the board of directors, the CEO, the senior management, and so on, including the company secretary. Then, of course, another guideline would be in relation to the responsibility of management. Management's responsibility. Management's responsibility. What is the management's responsibility when it comes to subsequent events? Now, under the ICS governance standards, the responsibility to keep the auditor informed rests with management. So the management have a duty, first of all, to disclose. Duty to disclose. The management has a duty to disclose. The management must proactively notify the auditor of any significant fact that comes to light before the report is issued. Then they need to update the compliance matrix. They have a duty to update compliance matrix. The management have a duty to update the compliance matrix. That means that if a subsequent event resolves a previous gap, for example, a missing policy is finally approved, then management should update the matrix and provide the signed artifact to the auditor for verification. So that is the management's responsibility, and that is the end of the lesson on the general guidelines when it comes to subsequent events. And in closing, candidates, we need to remember that if a material fact becomes known after the governor's audit report has been issued, then the auditor is required to take action. If that happens, number one, the auditor has no legal obligation to perform further procedures, but there is one exception. The exception is if the fact is so severe that it would have resulted in a qualified or an adverse opinion, then the auditor should discuss the matter with the board, whether the report will need to be recalled or the report will need to be amended in order to prevent misleading the public or misleading the regulators. You understand? That is what we call the post-issuance fact. Repeating, if a material fact becomes known after the governor's audit report has been issued, after the report has been issued, then the auditor has little. The auditor can do nothing. But if that information is so significant, if the fact is so severe that if it was not before if it was known before the report is issued, if that information could lead to qualification of the report or making the report adverse, then something has to be done. You as an auditor, you should discuss the matter with the board as to whether that audit report is to be withdrawn or recalled or amended. And that is very important so that those who are using or relying on the report, like the public or the regulators, are not misled. So that is the end of today's lesson on the general guidelines when it comes to subsequent events. General guidelines on subsequent events. Thank you. God bless you. Bye-bye.
So if we can start with task one. If you have gotten the worksheet, you should probably open it on your computer if you have access to your computer. Then we'll start with the tasks. So task one says insert a new row at the top of the worksheet and insert the heading. I think here, this one I wanted to say insert the title, New Day Motors September imports. So there is a car dealer of some sort here. They've imported these vehicles. We have the cost. We probably be asked to do the duty, the shipping, and then the total cost. So what we want to do is follow these tasks, right? So if there is anyone amongst us, how do we insert a new row up here? We want something at the top of the worksheet. To insert a new row, we had not discussed this before, but I'm sure probably there's someone amongst us who will know how to do this. So I'll point at where the one is, number one, and right click on that, and there will be an insert option. So just click that, you get a new row, right? So, and the same works for if I wanted to insert a new column and so forth. We don't want a new column right now. So what we want to do is insert that heading. Let's see, New Day, calling it New Day Motors September imports. So what does the next task say? Format the title to be bold and size 30. So we apply some basic formatting. So to format this, we will of course highlight it, then go to the home tab and click on bold. When they want it size 30, we change that here. Sometimes you will find that the size you want to put is not listed here. Like size 30 is not amongst these ones. So what do? We just type it directly and we get a size 30, right? So that's size 30. Then they want the cells merged in the range A1 to G1, right? I can see this font is already quite big. Maybe I should adjust the size. But let's see. Highlight this to merge the title, to merge the cells. We will highlight the range from A1 to H1. Then I will go to the Home tab and click on this Merge and Center. So it merges it within that range. The only issue right now is that it doesn't fit, so I can adjust a bit. What I've done is drag this a little to make sure that the whole of the title shows. Okay, I hope we're together up to that point. So that is formatting. Let's see. Yeah, there is one more formatting thing. We're supposed to apply visible table borders on the spreadsheet. We want some visible borders. So this part is going to be visible. So to apply borders, highlight the whole range where you want to apply the borders. Then we can again use the Home tab, and borders are here. So there is this font group, this ribbon, font group, borders, and click on borders, and you have borders there. Okay. That's clear. So let's try do some calculations now. We are applying some of what we have been learning. And this is where I want to get some interactivity out of you. We have been told to calculate duty. The duty, the rate for the duty is 40% for cars that cost 5,000 US dollars and below, and 55% for the rest. That means for vehicles that cost above 5,000, the duty is higher, it's 55%. So if anyone can recall from our discussions, what do we need to do here? What will we be using, a formula or a function? And if it's a function, what function shall we use? Okay, let me review this one for you. Now, we talked about the if function. The if function is a conditional function. Remember here, the condition is the duty changes according to the amount, the cost of the vehicle. So if the vehicle is above 5,000 USD, duty is this. If not, it is this other one. So it just sounds like an English sentence. So we have equals, then we start at the if function. If, then we will click this. So it should read like an English sentence. If the cost is above or equal to 5,000. Okay, if the cost is above or equal to 5,000, then what happens? So we have to have a then clause. This is called the condition. If that condition is true, then we have started with a greater than, actually, come to think of it, because here it says 5,000 and below. So we need to change this to answer the question correctly. We are less than or equal to, and notice the order of these symbols. You have to start with a less than sign followed by the equal sign. Sometimes students mix them up. You start with equals, then less than, and it doesn't work. So you put them in the order in which you say them. Less than or equal to 5,000. Then the duty is 40%. If you recall from our last lesson, I remember we did a bit of a function. You have to say 40% of what? If I just wrote 40%, then I'll get the wrong answer. Or rather, I'll just get 0.4 because 40% is 40 out of 100. I need to say 40% of what? 40% of the cost. Okay, so the duty is 40% of the cost. Else, so if this value does not meet the condition, the value in here does not meet that condition, then the duty is 55% of the cost. Right? Very important to remember there. Otherwise, there are some cases where a student will work out this. They will put the 40% and not put the value. Let's just see what would happen. If you didn't put 40% of what you're trying to get, you'll get this. And then you will wonder, why is my formula not working? because you've not said 40% of what or 55% of what. So you can use this to actually also check what rates are being used for the duty. Anything above 5,000, you see it is 0.55. This one is 0.55, which is 55%. So we need to specify it is 40% of the cost. That is how we do it. Remember, we have talked sometimes about clicking on the options rather than typing them. Then when you click, that is when you're able to out of field like we have done. We can also try the next one, shipping. Shipping is again straightforward. It is 15% of the cost for all vehicles. So that one should be a straightforward calculation, equals 15%. Okay, we said you use a percent sign. The percent sign is shift and 5. There are those people who will do 15 over 100 times the cost, which will still work, but there's no need to do that when you have the percent sign. So we use the tools that are available on the spreadsheet. So 50% of the shipping, or rather the cost. Then we drag this down, and then we have the shipping cost, right? Then the total cost, as you would guess, will be the sum of all this, right? So how do I get the total here using one function that we have learned so far? So select everything, including the cell where you want the solution. Then we can click on this auto sum sign. In fact, you can do all of them at the same time. So if I undid that and did this, then click on the auto sum, then you get all the answers. Okay, correct. This, it shows we are learning. Okay, so what we want to do is, so we have answered all that, we've calculated the total cost. What we want to do is also fill out this section here. We want to do a bit of analysis. Okay, so this analysis, I want to get the number based on every make. Okay, so I want to get, say, the number of Subarus, the number of Toyotas, and so forth. So there are different types of cars here. So I want to use the make field and get the number. So what I actually need to do here is to adjust this. See, instead of having this, do this, and then I'll move this. I can move this around. Again, part of it is, suppose I wanted to move this to the end. Let me put them here. So I can do my analysis around there. And instead of this, I will write names of every make. Toyota. Then I have Volkswagen. You can correct that even on the worksheet you received. And I think the last type of vehicle is Nissan. So that one is getting the number based on the make. But we can also do some analysis based on the category. So all of this is make. So I can merge that and put a small title there and say make. And then I've included an extra cell, so correct that by going back there to unmerge and then merge afresh. Then I'll do some analysis here by category. So I'll just type a category. And there are how many categories? There is station wagon, then there is SUV, then I have sedan, then I can make this smaller, adjust this a little. Then I have what other category? Sedan, crossover. And I think I have a van. Let me make this a van as well, instead of making it a minivan. Van. Right, so what we want to do is to use some functions that we have learned also the past few days or weeks. to fill in, to do some analysis on this. Before we learn new things, we need to master the ones we have already learned. So what we want to do is remind ourselves, what function shall we use if we want to display the number of Subarus, for example? How many Subarus are on this list? What function shall we use? Who remembers the function? Okay, so that is count. Tried, but not quite count. You've gotten it partially correct. What are we counting? When you use count, if I remember correctly, in the last lesson, we said if you use count by itself, count only counts numeric values, all right? We talked about count and count A. So we call these two. This one counts numeric values, and it will count everything in the range that you have selected. This will count, it will count string values or other text values in the whole range that you have selected. So we will need to use count if correct. Count if is a correct. So we are counting with a condition. So equals count if. Open a bracket. Then I like the range, and you need to specify what you're counting. So the criteria, and it gives you a prompt over there. So we have the first one we're counting is a Subaru. Said because we are now familiar with Excel, we don't need to go typing the formula over and over again. We can find a way of auto-filling the formula, copying the formula all the way, say up to here for make. We can even put, let's put some different colors here so that we see it is different type of data. I can use some green. I can put a green fill of that section and put some borders, and I can put a different fill here to differentiate the sections. Put a light blue fill and apply a border. So I want to copy the formula here and here. Can anybody recall again from our discussion in the last lesson? There's something we said. If I tried copying this one directly, I'll get something that doesn't seem to be very right. First of all, I'll get zeros. And another problem is that it's still counting Subarus, right? So even if I change this, let's say I change this to Toyota. Let's see if it will give us the correct answer. Change it to Toyota. I still get a 0. So it's still not counting the things I want. But if you look carefully, this range is B3 to B14. But this range is C3 to C14. So it has moved from here to here. It's looking for Toyota here, and it can't find any Toyotas because that is a make, right? And you'll even get an error message, right? So what we want to do is to, while we are still here, we use absolute referencing. If you remember, we were pressing Fn and F4 to apply those dollar signs. So that locks the reference to that section, to that range. So if I copy this now, I get some 3s. So there's a bit of hope. At least I have something. It's not showing me zeros. The only problem now is easy to spot, is that it's still counting Subaru when I need to change that to Volkswagen and Nissan. So I'll start with Nissan. I just need to change that to Nissan. I can either type it. If I had a list of those types somewhere here, I could use that range. We'll check. I'll show you that in a minute. So Nissan, it tells me the 2. Then Subarus, need to change that from Subaru to Volkswagen. Right, so it will count the Volkswagen, it finds 3, then we put Toyota and see how that will change. and those ones are 4, right? So, and you'll notice if you make any changes here, it will automatically be reflected. So what I'll say is, if I had this, a list of this somewhere, Toyota, Volkswagen, and I have the next one, Nissan. In category, so I have Subaru, Toyota, Volkswagen, and Nissan. I can still use a range that is somewhere on the worksheet to do what I've just done. So if I kept this range, then instead of this Subaru here being there, I can click on this. So it will still look for Subaru. My search criteria will be whatever is contained in that cell. I hope that makes sense. Then if I want to drag it across, then it would make more sense if I put this one in this, somewhere in these cells. So if I put them across like that, then I will be able to autofill directly. So because this is referring to L14 now, so that is L14 where Subaru is, then I can autofill like this. And you see the numbers remain the same because this one has Subaru. When I go to the next one, M14 now has Toyota. So that's M14. If I go here, that N14 has Volkswagen, and that O14 has Nissan. So that's one way to do it. Unless this is, I don't think it's very confusing. Sometimes it saves you a few minutes of typing. If I had them here, then I would not have to go typing the names again there. But even typing will still give you the same result, right? I hope that is not too confusing. All right, let's try to apply the same formula to work out how many station wagons there are, how many SUVs there are, and so forth. Get the numbers by category. It will still be the same formula, so I'll do equals count if. Then I open a bracket, then this time I'm using this range, then I'll press F4, that is function F4 because I'm using a laptop. Then I put a comma, and I could do one of two things: write those the different categories here. Alternatively, just type them in directly. So let me just maybe the other point. So type them in, and I can do that. And if I copy this formula, I then have to go changing them. Like this one now will read station wagon, and I want it to read the van. I have to remember to change that one inside there to tell me there are 2 vans. Then I want to change this category to crossover to tell me how many crossovers are. There are 3. Then the next category is sedan. And so forth. Close the bracket. And there is SUV and so forth. Right, so we have used the count if formula. Remember, we have used that formula in very many different scenarios. The point is, presented with the different scenarios, you should be able to choose the correct function and apply it. Okay, so what we have done so far is we've kind of gone around the same functions in different scenarios to just make sure that you internalize their usage, their syntax, and their application. Okay, so let's talk about the average cost. We want to get the average cost by make, the average cost of a Subaru, the average cost of a Toyota, the average cost of Volkswagen, and so forth, the average cost of a station wagon, the average cost of a US SUV. Average if live and pop. So average if, then we have our criteria. So we want to get the average cost. So we'll use this total cost tool. Where are we looking for Subaru? We'll select that range, then lock it. So I'll not go through the detail of locking again. Then what is the criteria? We are looking for a Subaru. So I can even use this directly. Let me lock that Subaru there. Shift and 4. Or I don't even need to lock it, but there's no harm. Then I'm doing the average of the total cost. So FN4, that should give the average cost of a Subaru. Okay, it looks like a very long formula, especially when you have the absolute signs. But just to break it down again, is let me expand it so we can make it slightly bigger so you can see it clearly. It says average if this range, it looks at that range for that thing. So it is looking in this range, which is that range, the make for Subaru, and then it will get the average of the total cost. So this is where it gets the value that it is working out the average of. So there's three, they're called parameters. This is a function with 3 parameters. It has the range where you're looking for that thing in the second section, and the range where the calculation comes from. All right. So I'll put that back, smaller size, and remember shortcuts. I'm using Control-Z to move backwards. Then I can look at this and see the decimal points are a bit too many, then reduce those decimal points using this. We have learned. Let's make it 2 decimal points because it's money. Then we go to Toyota. We'll use the same idea. If I autofill this one, so let's autofill this and see what the problem is. We get the same answer. So that's not a bad thing. It means there is only one thing we need to change. So those who are getting what I'm saying, what do I need to change in order to get the different values here? What do I need to change? Okay, so let me help you see it. So if I double click this, if you look at those variables there, there's range, criteria is the middle one, average range is the last one. So you can tell that this middle one is what is determining what the average will be, because this middle one is the one that represents that Subaru. Okay. So what I need to change is that middle one. Right now it's referring to the Subaru, so I need to change that to Toyota and change it on to Volkswagen and Nissan and so forth. So in fact, to make it easy, let me just use that. So right now it is C18, it means it's referring to that Subaru. If I autofill it, changes. So you'll notice that this changes to D18. That means it is now looking at the Toyota. If I look at this one, it has changed to E18. That means it is looking for the Volkswagen. If I look here, it's referring to F18. So what I needed to do is to change the criteria, because for all of them, it is checking here for that thing and doing the average based on that column there. I hope that makes sense. Right. So just to have a quick peek at that formula again, it has a range, it has a criteria, it has an average range. It works the same way for sum if. Sum if has the range, the criteria, and the sum range. So if you wanted to work out the sum, let's say total cost by, let's add a quick one here, total cost by make. So we'll see total cost by make. We basically need to, I can just copy this formula downwards. You see the logic of it. let's see, it is going to C19. So I want this to remain as C18. If I do that, it gives me the same numbers. But it's giving me the same numbers because the function is still average if. So I want it to be sum if. I'll just change this to sum. And I'll get a sum of all the costs of the, let's say the first one will be Subaru. So it will take that number, 3875 plus 12,750, then add it to 10,200. That is where that number is coming from. So it works exactly the same way as the average if. It takes three parameters, the range, the criteria, and the sum range. Which range are you summing, right? So we'll use the same idea for getting the sedan. If you want to get the average, rather the category, if you want to get the average cost by category. Average cost by category, we'll use equals average if. It's the same formula. Then the range, this time we are using category, and we lock it. Then our criteria will be this one. Then close that. Then we still do the average cost, or rather the cost, total cost. Press enter, and we'll get this cost here. This 5,786 is the average cost of a station wagon. How many station wagons are there? There is 1, 2, 3. So that means it has taken these numbers, it has added that, plus that, and divided it by 3 to get that. So if you think about the math explanation for that. And because we have put the right references with this one, I can just copy it across. That is why it's important that you take some time and try this thing yourself. If you try it yourself, then you'll see the logic of what I'm doing, right? And try to get hold of this recording as well. So what I'll do is, this looks like too many decimal places. Again, to review how you do decimal places, do this. Reduce them to 2 decimal places, right? Then total cost, I can use the same formula, similar formula. I'll just copy one of these down. I'll get some error message, and I will look at the formula and know that the thing that has changed is this one. Because these ones are locked, I will be guaranteed that they have not changed. So this G19 is what has changed. And if I look at it, G19 is the average cost, but we do not want or rather G19 is the number here. We do not want that as the criteria. The criteria is meant to be the category. So I just need to change this part, G18, that it's referring to the category. Then if I fill it across, it will give me the same numbers, but before I fill it across, because we are doing total now, we need to change that to sum, the sum function. Let's see, press enter, and then I can fill this across. So it is data that kind of makes sense. You want to know what is the average cost of an SUV. If I look at these numbers, they kind of tell me something. An SUV is on average more expensive than all these other types of cars, followed by some types of sedans, right? These are different types of cars. Then it looks like from this list, station wagons have the lowest average cost, okay? And then in terms of the total amount the dealership spent on importing the cars, the amount they spent, I think looking at these numbers, if I apply some formatting, right now they're not very clear. Because they are currency, I can put a comma on them. I put a comma using that. And now I can tell where the thousands are. So I can easily now tell the category that we spent most money on was SUVs, followed by the crossover, followed by the station wagons. Okay, so the total amount was highest on this. And again, like we're saying, this information, this formula can be used in different contexts. You want to know which products cost you the most, which products did you make the most money on, and so forth, depending on different scenarios. So let's try one more. Highest cost. This one is a bit separate from this, from the ones we've just done. We want to know out of this whole list, which one has the highest cost and which one has the lowest cost. And there's a function we learned for that. Again, let me throw the question back to you. Which function do we need to use to get the highest amount from a range? Max value, that's correct. So we have max equals, and max, open the bracket, highlight the range to pick the highest value at range. So 17,000 was the most expensive thing. It was a Land Cruiser, Toyota Land Cruiser. Then the lowest cost, we will use mean function, open a bracket, highlight this, then it gives you the lowest out of those figures. So the lowest was 3,875. Again, you can format this as, because this is currency. Generally with currency, we tend to put two decimal places. So if you look at it, this one has no decimal places, so I can quickly format all of them, select the whole range, then add some decimal places. Okay, so that makes it two decimal places. This one, I can make this two decimal places as well, and format it to have a comma, so I can see clearly where the thousands are, or in some cases, where the millions are. So let me put a comma there as well. It kind of makes it easy to read. Okay, so a number of functions we have reviewed there. Just a quick run through of what we have done so far. If you recall, the duty, we started with the duty. We used the if function. The if function in this case had three parameters, three things inside the function. So what I'm calling parameters are these things. There are three sections. There is the logical test. This is the test it will carry out. Then it will give you this value if that test is true. If that test is false, then it will give you that value. So it has three options. The condition, what will happen if the condition is true, and what will happen if the condition is false, right? So that's a basic if function. You could make it a little more complicated, but for our purposes, we will just be using relatively straightforward if functions. We will not use very complex if functions. There are some that are nested. You can make it have very, very many options, but for our purposes at the moment, we're just doing an if function with a condition. What happens if the condition is true? What happens if the condition is false? So that was the if function. For shipping, we didn't use a function, we just use a formula to calculate the percentage. The thing with the percentage that we have emphasized for the last two lessons is that you use a percent sign that is on your keyboard, Shift and 5. Okay, then you click on the number on the figures rather than type them. That is useful for when you want to autofill. Okay, so if I make the mistake of typing 2,500 here, then I'll have a problem. The first answer will be correct, but the rest of the answers will be wrong. If I did that, it gives me the same thing, which makes everything else wrong. So instead of typing 2,500, I click on it, the center, then I can autofill. I get the other answer, correct answers, right? Then the total, of course, we did a sum function. We added all of them. So far, if function, sum functions, function. Then when we came to the analysis section, we've added 3 functions: count if, average if, then sum if. And with some practice, you'll be able to see the application of this. Like I can see Twadrimana there is getting the hang of it. And we said there is also these functions that we talked about, I think, in the last lesson. If I was to count the number of vehicles, in like the total number of vehicles, so I say total number of vehicles. Let me just call it total number. Okay, I want to count everything on this list. It depends on what I want to count. If I want to count by the make, notice that this is text. These are text values, not numbers. What would happen if I did count? If I did count, then highlighted this section, I get a 0. Then I would be very frustrated if I'm a student who has forgotten how to count text. So to count text, I need to add an A there. Small change, it gives you the correct answer. So count A is a function that is used to count text values. If I was to count this range here, if I counted the cost for whatever reason, you want to use that that range to get the number of vehicles. Then in that case, if I did this, let's see what will happen. I want to count this. This is money. Let's see if it will work. It still works. So you can use count A to count both. But in this case, because they are numeric values, even count by itself will work, right? So count A specifically for counting a string or text characters, right? Then in the same session, we have looked at formatting. Formatting is also an important aspect of spreadsheets. You can apply borders, which is part of the exercises I sent you. Applying borders is the home tab, going to borders and selecting all borders. Sometimes you will need to remove borders for if you're asked to remove some borders, then same place, and I say no borders. But in many cases, you will want to do borders, right? So that turns it into, if I wanted to print this, it's a bit neater. So if I went to File, Print, then the presentation is a little better than when it has no borders. Okay, look at it. Then color coding makes it a little better when you're printing. Just one more thing before while we're still talking about printing, if you look at this, at the moment, it's portrait orientation. So some things are running to the next page. So if I wanted things in one page, I probably need to make this landscape. I can make it landscape by going to page layout, orientation, and turn that into landscape. Okay. I do not want to print the tasks. These were for our use. So if I move this out of the way, you'll notice there is a dotted line there. So if I go to print preview now, that dotted line shows you what will be on the page. So you notice all of these fits now, and this part, some parts are outside, but for the sake of illustration, we didn't need to print to show the other bits. So the part that is missing is just that one there, which we can force that to get into the print area by moving this around. Okay, so we've also mentioned something about printing. Now, as for the next lesson, I'm targeting to start looking at slightly more, I won't call them complex, but they will be a bit more advanced functions. So we'll start looking at something called the VLOOKUP function, which you expect to know. VLOOKUP. Then we will talk about things like pivot tables. We'll talk about some other functions that are more specific to accounts or finance, like PMT and so forth, a little more advanced. But we couldn't have gone to that extent without first understanding the basics. What I suggest is I will also, you have a copy of this already. So I suggest that you do the exercises. Take time to do these exercises. If you have questions, let's start with those the next time we meet. But just before we close again, while we are still on this, if I can quickly throw in something else, charts. We are supposed to learn how to make charts. So we can make, this looks like a good piece of some data to create a chart on. Suppose we wanted to create a chart based on the make and the total cost. It could be a bar chart, a column chart, a pie chart. So, but let's try exploring the different types of charts. If I wanted to select make and total cost, there are two ways to do it. One way is to select everything. Then I will go to insert and chart. Let's say it recommends that we do a clustered column chart, which is not what we want. Let's say we just want a simple column chart. Then we click OK. It gives me a column chart. Okay, so it is using, let me see that again. This is not what we are looking at. This is what we're looking at. So it seems to have picked duty and total cost. So let me go back there, then go to insert chart. I needed to see, I was expecting more columns. So if I do this and OK, then I get a chart looking like that. In this case, I don't need the line, so I get rid of it. Then it's showing me many variables. If you look at this, the blue one is the cost, the orange one is the category, then we have many variables. So, but I just want the make and the total cost. So I can remove from this the things that I don't want. So I can remove, when I look at this, it says cost. I don't want this cost, get rid of it. And this is duty. And this is shipping. What I need to do is to edit this. I need to select different data. So I want it to show me this instead. So what I've done is edited directly. I've right-clicked on this, then gone to select data and highlighted the range I want. Okay. The alternative to doing that, like that looks a bit messy. It's a bit even confusing. Let's just not do that method. Method 2, you start by selecting exactly what you want. So I'll highlight that. Then I hold the control key on my keyboard. If I hold control, then I can select this one to avoid the confusion of having to delete some columns, then the chart looks a bit more confusing. I have highlighted this first, then hold down control, then highlight the next one. Right? So that way, when I'm inserting the chart, I will only be dealing with 2 columns, and it will be very straightforward. So if I click this, then it shows me the total cost and by make. Even the title will be meaningful. Total cost by make, right? Then I can even choose to, if you formatted this, you can vary the colors by the different types of data they have. I want to this. I can do vary colors by point, and then it will be able to show me different colors for different cars. But that's just a bit of some additional information. We'll still do a few more charts. I just wanted to give you a bit of a sneak peek into charts because it's also one of the we're supposed to cover. Now, what I want to do is, because I don't want to overload you with too much information, I will let you do a bit of practice before you go to sleep today. Try and redo the things we have done. So if there's no questions, We'll end it at that. See you next lesson.
Welcome to Manifested Publishers. And I want us to go to a question on August 2024. Question 4B. Question 4B. Question 4B. Part 2 of that question. 4B, part 2 of that question, where they're saying, determine the expected value of perfect information. The expected value of perfect what? Information. But the first part B of that question, they are saying, the finance director of Lengo Training Institute is considering a proposal by the board of directors to launch a new course nationwide. The potential enrollment of the course is classified as either high, medium, or low. The net present value under each of the three conditions is estimated to be 50, 10, and negative 20 million, respectively. The marketing director of the institute estimates that there is 0.4 probability that the enrollment will be high, 0.25 probability that it will be medium, and 0.35 that it will be low. The objective of the institute is to maximize the expected net present value. And they want you to determine your expected value of perfect information, but we want to use a decision what? Tree approach. So you're going to have that as your alternative. Your decision is either you're going to launch a new product or not. So you either do what? You do not launch a new product or a new course. In fact, it is a new course, not a new product. A new what? Course. Or you do what? Launch it. Or you launch it. When you launch it, they're saying that you have either you're going to have high enrollment, medium, or low, and they have given us what? Probabilities for each. So when you're given probabilities, it means those are states of nature, because you're using what decision-making criteria? Conditions of risk, where you must have what? Prior probabilities. Conditions of risk, you'll be given prior probabilities. So let me represent this in a better way. You will understand. And here you'll have your states of nature. So you have high, medium, and low. High, medium, and low with a probability of 0.4, 0.25, and lastly how much? 0.35. Then we have our states of nature given by probabilities. Then we need to determine our payoffs, and the payoffs of each, when under the condition that was 50 million. So I'll have my values in millions of shillings. That was 10 million. And lastly, this is a loss of 20 million. Okay. Having presented that, then let's now determine our what? Expected monetary value with perfect information. So your expected monetary value with perfect what? Information. Your expected monetary value with perfect information. Let me compute it here. Expected monetary value with perfect information. You're going to say it will be under high, the payoff is 50 million with a probability of 0.4 plus launching, your payoff is 10 million with a probability of what? 0.25, but low, and you have, and with low enrollment, your loss is how much? 20 million. But if you had positive, or if you are sure that low will give you a what? a negative, you will not have accepted to launch the product and to generate what? A loss of negative 20 million. What instead you would have done, you would have taken all the necessary measures such that you don't get a what? A loss. The only thing you can get is a what? You may not make a profit, but do not make a what? A loss. So therefore, you're going to make a what? Or you're going to not make any profit and loss. So you're going to have a what? Zero cash flows. So here instead of 20, you're going to have what? 0 times what? 0.35. 0.35. And then we calculate that. Remember, we've said instead of a loss, you're going to ensure you don't, at least you cover your costs. At least you cover your cost from your payoffs. 10 times 0.25 plus 0. So there, if you had perfect information, your cash flows should be worth how much? 22.5 million, or your payoffs should be 22.5 million. Let's now get the expected monetary value without perfect information. Without perfect information, your cash flows will be 50 million by what? 0.4 plus 10.3, 10 times 0.25 plus, without perfect information, you're going to make a loss of 20 with a probability of 0.35. 20 with a probability of 0.35. So this is the normal EMV. 15.5 million. Therefore, your value of perfect or your expected monetary value, which is the value of perfect information, monetary value of perfect information, you simply now get the difference. You simply now get the what? The difference. So this should be 7 million. That should be 7 million. All right. And that is how you determine the expected value of perfect information. Expected value of perfect information, which is here. Expected value of perfect what? Information, which using which decision making criteria? Using your decision tree. Using your decision tree. All right. Your assignment, I'll give you an assignment. Please attempt the same August 2024, question 4B, 4C now. Question 4C. Can attempt that question for what? For practice purposes. All right. And we've come to the end of decision-making environments. From me and on behalf of the school, goodbye and God bless you.
I greet you all due to the manifested e-learning platform. Today we are going to study a topic known as peer review mechanism. The subject is governance and compliance audit. The topic is peer review mechanism. This topic has 5 subtopics. First, scope and types of peer review. 2, responsibilities of parties in a peer review. 3, peer review mechanism stages. 4, quality management and assurance measures. 5, confidentiality requirements. We will be taking a subtopic one at a time. Today we begin with the purpose, scope, and types of peer review. Those are 3 things. 1 is purpose, then scope and types of peer review. But first of all, what is a peer review? Now, peer review in the context of governance and compliance audits refers to the systematic and independent evaluation of an audit firm's or internal audit functions quality control system and its adherence to professional standards in conducting governance and compliance engagements. That is to mean that the governance and compliance auditor is required to adhere to professional standards and to adhere of or to put in place quality control systems. In conducting audits, the auditor has to adhere to certain professional standards, and therefore peer review refers to the process of systematically and independently evaluating an audit firm's adherence to such professional standards, where an independent person evaluates a governance and compliance auditor as to whether the auditor is adhering to professional standards or quality control systems. That's what we are calling peer review. It is essentially auditing the auditors to ensure they are performing their work competently and ethically. Auditing the auditors is what we refer to as peer review. So what is the purpose of auditing the auditors? That's one question to answer. Purpose. An auditor, I repeat, is required to adhere to certain professional standards while carrying out governance and compliance audits. And it's important to evaluate whether the auditor has complied, whether the auditor has adhered to professional standards in conducting governance and compliance audits. So what is the purpose of such peer reviews? One is to enhance audit quality. One, enhance audit, to enhance audit quality. The fundamental goal of peer reviews in the context of governance and compliance auditing is to ensure that governance and compliance audits are conducted in accordance with established professional standards, ethical guidelines, and relevant regulatory requirements. Audits are not conducted anyhow. No, there is a framework which the auditor has to follow in carrying out. That's why we have independent persons who come in to find out or to evaluate the auditor's work to ensure that the auditors are adhering to these ethical standards, professional standards, and regulatory framework. Enhancing audit quality is the primary purpose. Now, the second purpose of peer review is promoting consistency and best practice, is to promote consistency and best practice. And how does peer reviews promote consistency and best practice? Peer reviews identify areas where an audit firm or internal audit function can improve its methodologies, documentation, and reporting, and that facilitates the sharing of best practices across the profession. That is how peer review promotes consistency and best practice. The third purpose of peer review is maintaining public trust and credibility. Maintain public is to maintain public trust and credibility. Is to maintain public trust and credibility by subjecting audit practices to external scrutiny. Peer review assures stakeholders like the board, like the management and regulators, that the audit function is operating within integrity, objectivity, and competence, and that builds confidence in the governance and compliance reports that are issued by the auditors. That's how peer review helps to maintain public trust and credibility. Now, the fourth purpose is identifying areas for improvement, is to identify areas for improvement. To identify areas for improvement. Peer reviews provide constructive feedback and recommendations for strengthening internal control systems, internal quality control systems, methodologies, and also training programs. And this fosters what we call continuous improvement within the audit practice. The fourth purpose of auditing auditors is to ensure compliance with professional standards. To ensure compliance with professional standards. Is to ensure compliance with professional standards. Candidates, auditors are people. These are human beings, and as much as they are auditing companies, they also need to be checked if they are complying with professional standards, because in conducting governance and compliance audits, they are required to comply with ethical standards, regulatory requirements, and so on. So, many professional bodies issue standards for governance audits. All right? Many. They issue these audits. They issue standards which mandate peer reviews for firms or internal audit functions conducting audits under their standards. And that ensures adherence to the professional requirements. So, peer reviews help to ensure compliance with professional standards. Peer reviews can also be used to mitigate risks for the audit firm. Mitigate risks for the audit firm. Peer reviews can mitigate risks for the audit firm. And how does that happen? Now, by proactively identifying and addressing weaknesses in audit processes, peer review helps audit firms and reduce their exposure to litigation, exposure to regulatory penalties, and also reputational damage. The seventh purpose is in relation to professional development. Professional development. Peer reviews provide an opportunity for the reviewing peers to learn from the practices of others, and for the reviewed entity to gain insights for professional growth. Professional development is a purpose of peer review. So these are 7 purposes. Let's now move to discuss the scope. What is the scope of peer review? Scope. What is the scope of peer review? Now, this is peer review candidates in governance and compliance audit. We are discussing peer review in the context of governance and compliance audit. So the question now is, what is the scope? Now, the scope of peer review for governance and compliance audits typically encompasses an assessment of the audit firm or internal audit functions, entire system of quality control, and this application to individual engagements, which may include review of quality control system design, review of quality control system design. Review of quality control system design. This means evaluating whether the firm or the audit firm has clearly defined leadership responsibilities for quality within its governance and compliance audit practice. So it may include leadership and responsibilities. Reviewing of quality control system design may include 1. Leadership and responsibilities. Leadership and responsibilities. It may also include ethical requirements. Review of quality control system may include ethical requirements. That means assessing policies and procedures related to independence, objectivity, and also integrity of the personnel involved in governance and compliance audits. So we have these personnel who are engaged in the audit team. When carrying out peer review, the focus is on the independence, the objectivity, the integrity of the ethical team. Have they met these ethical requirements, ethical issues, things to do with integrity, objectivity, independence, and so on, for the personnel involved in the audit. Because remember, here we are discussing peer review, which you said it is the audit of the auditors. So as much as the auditor examines the audit company in relation to these ethical requirements, the auditor again is also required to adhere to certain ethical standards. And when carrying out a peer review, that is also part of the scope, ethical requirements. Understand? Yes. Then you also have acceptance and continuance. Acceptance and continuation or continuance of the engagement of the client relationship, That is also part of the scope. Acceptance and continuance of the client relationship. That means reviewing the process for deciding whether to accept or continue governance and compliance audit engagements, including consideration of client integrity and the firm's competency. That is review of quality control system design. There may also be the human resources. Human resources is also part of the scope under quality control system design. All right? That means examining policies for recruitment, for professional development, for performance evaluation, and also assignment of personnel with appropriate competence and capabilities for governance and compliance audits. The governance and compliance audit firm is required to have competent auditors. Now, when auditing the governance and compliance auditors, this review focuses on whether the audit firm has policies for recruitment, has policies for professional development, has policies for performance evaluation. Does the audit firm evaluate the performance of its workers? And does it assign responsibilities appropriately? Those are questions that are covered or is part of the scope when carrying out this review. we may also have engagement performance. Engagement performance. Engagement performance. That means evaluating policies and procedures for planning, executing, supervising, reviewing, and also documenting governance and compliance audit engagements, including adherence to the relevant audit standards. And these standards could be the IIA standards for internal audits and so on. And this would cover areas like understanding of the entity's governance framework and compliance obligations. It may include risk assessment procedures for compliance risks, also sufficiency and appropriateness of audit evidence that is gathered, and also documentation of audit work and findings. It can go on also to include the formulation of audit conclusions and responsibilities, and also reporting practices. The audit reports. Are the reports clear? Are the reports accurate? Are the reports complete? So that is the engagement performance. That is the execution. How did the auditor carry out the entire audit engagement? How did the auditor perform? There has to be policies and procedures for, first of all, planning. It begins with planning. Then after planning, there is the execution phase. Does the auditor carry out vision? That has to be checked while auditing the governance and compliance auditors. Of course, then there is monitoring. Monitoring is part of the scope of peer review. Monitoring means assessing the effectiveness of the audit firm's internal monitoring processes to ensure that its quality control system is operating effectively. So that's the first scope. Review of quality control system design. Then the second part is review of selected engagements. Review of selected engagements. Review of selected engagements. Review of selected engagements. Have the walkthroughs and also detailed reviews. The peer reviewer will select a sample of completed governance and compliance audit engagements. And for these selected audit engagements, the reviewer will examine the audit documentation and reports to determine if the work was performed and reported in accordance with professional standards and the firm's own quality control policies. And that may include assessing whether the scope of the engagement was appropriate, or whether sufficient evidence was obtained to support the conclusions, or whether findings were adequately supported and reported, and so on. So that is part of the scope. Review of selected engagement. The auditor selects an engagement that governance and audit engagement, and then it checks all the aspects that I've mentioned to ensure that the audit is carried out professionally. 3, we have interviews as part of the scope of peer review. That means interviewing the key audit personnel like the partners, the managers, and the staff in order to assess their understanding of and adherence to the firm's quality control policies and professional standards. If you are to audit the auditor, then you also just carry out interviews. The auditor carries out interviews while gathering audit evidence from the client. Because you are auditing the auditor, interviews must also be part of it. Carrying out interviews with the audit staff, with the partners, with the audit key personnel to assess their understanding and their adherence to the firm's quality control policies. Interviewing management also may be part of the peer review process. That is interviewing management or the audit committee of the client organization. So the interview here is not just limited to the auditor, but also interviewing the audit committee members, the management, the top level management, just to get feedback for the quality of the audit services received. Interviews is part of the scope of the work of the peer reviewer. Then there is review of other relevant documentation. Review of other relevant review of other relevant documentation. Other relevant documentation. Review of other relevant documentation, like training records of audit personnel, like independence confirmations, like the firm's methodologies or templates or checklists for governance and compliance audit. The auditor, the one who reviews, the auditor should also check other relevant documentation. So that's it, candidates. These 4 areas are what are covered in peer review work. So that is all for the scope. Let's now analyze the types of peer review. Types. What are the types? Types of peer review. Now, the specific terminology for peer reviews can vary slightly depending on the professional body or jurisdiction, but they fall into around 4 categories. The types we may have, for example, the system review. The first type is systems review. Systems review of the system. Most common for audit firms. Okay. The purpose of system review is to provide reasonable assurance that the firm's system of quality control, the audit firm system of control, quality control for its accounting and auditing practice is suitably designed and operating effectively to provide the firm with reasonable assurance of performing and reporting in conformity with applicable professional standards in all material respects. That is the purpose of systems review. And the scope can be broad, covering the entire quality control system. And it's typically applied to firms that perform audits, that perform examinations, or reviews under generally accepted generally accepting auditing standards. It could also be just attestation engagements. You understand? So the scope can be very wide. And system review involves reviewing policies, interviewing personnel, and also examining sample of engagements to see if the quality control system is followed and it is effective. That's the first type of peer review. Number 2, we have engagement review. Engagement review, engagement reviews. The purpose for engagement reviews is to determine whether specific engagements selected for review are performed and reported on in conformity with our professional standards in all material respects. And here, engagement review, the scope is narrower compared to systems review because it focuses only on the selected engagement files rather than the entire quality control system. And it provides no opinion on the firm's overall quality control system. It just determines whether specific engagements selected for review are performed and reported in conformity with applicable professional standards. What of the methodology? What's the methodology used in engagement review? Now, engagement review involves reviewing the documentation and reports for a sample of engagements, and it's often used for firms that perform only the compilation. The firms that only they do compilation or review engagement basically are lower assurance, or sometimes as a component of a larger system review. You understand? The methodology this is just taking a sample of engagement that provide lower assurance services. Number 3, there is internal quality assessments. Did I get it right? Yes. Internal quality assessments, or what we call self-assessments with independent validation. These ones are often conducted by internal audit functions, all right? And the goal is to monitor the internal audit activity adherence to the international standards for the professional practice of internal auditing standards and the code of ethics. That is the purpose. It's conducted by internal audit function. That is very important to note. The goal is to monitor. The goal of internal quality assessment, you see here the word internal quality. It is first of all conducted by the internal audit function. And the purpose or the goal is to monitor the internal audit activities adherence. So this review is conducted by the internal audit functions. It assesses the internal audit department's adherence to the standards across all aspects of its operations, including governance and compliance audit it performs. That's why it's sometimes known as self-assessment with independent validation. The 4th type of peer review is specialized reviews. Specialized review. Now, some industries or regulatory bodies might have specific peer review requirements tailored to their unique governance and compliance frameworks. For example, we may have reviews for firms auditing public companies, or specific reviews for government audit organizations. So that's what we call specialized review. It may be tailored for just public the government audit organizations. So these are 4 key types of peer review. Over today's lesson, the objective was to analyze the purpose of peer review, the scope of peer review, and the types of peer review. So we've identified 7 objectives of peer review. One is to enhance audit quality. But first of all, we defined peer review as the process of auditing the auditors. Peer review. The auditor audits another auditor. It is in the context of governance and compliance audit, we've said it refers to the systematic and independent evaluation of the audit firms or internal audit functions quality control system and its adherence to professional standards in conducting governance and compliance audits engagements. So the purpose 1 is to enhance audit quality. Number 2 is to promote consistency and best practice. Number 3 is to maintain public trust and credibility. Number 4 is to identify areas for improvement. 5 is to ensure compliance with professional standards. And number 6 to mitigate risks for the audit firm and also professional development. Then we've identified the scope of peer review. 1 is reviewing of quality control system design, is reviewing of selected engagement. Number 4, use. Number 5, reviewing of other relevant documentation. Lastly, we've identified or analyzed 4 types of peer review. 1 is systems review. Number 2, engagement review. Number 3, internal quality. Then specialized reviews. Now, in closing, candidates, it's important to remember that peer review is a vital quality assurance mechanism in governance and compliance auditing. It ensures that those responsible for assessing an organization's adherence to rules and practices are themselves adhering to the highest level of professional standards, thereby safeguarding the integrity and the value of the audit process. Peer review is a process of auditing the auditors. That's all. God bless you. Bye-bye.
Welcome to yet another session, and on behalf of Manifested Publishers, I wish to welcome you again. We can now read this particular question. Question 2A. Zinc Limited is a manufacturer of 3 products, namely XYZ. The management of the company is unhappy with the current production mix and is seeking to advise on the most optimal arrangement. The current production is 10,000 units of X, 5,000 units of Y, and 6,000 units of Z. The management accountant has provided the following information relating to the 3 products. You have your selling price per unit of 1,200, 2,000 and 2,250, material cost of 300, 900 and 600, overhead cost that is variable of 150, 400 and 450. Each type of the product passes through 3 departments in which a different type of labor is used. The labor requirements in each department are given below. You have your department, your rate per hour, your labor requirements per unit. Department 1, your rate per hour is 20, X is 3 hours, Y is 4 hours, Z is 6 hours per unit. Department 2, the rate per hour is 40, X you're using 1 hour per unit, Y 2.5 hours per unit, and Z 4 hours per unit. Department 3, the rate is 30 shillings per hour, X is 5 hours per unit, Y is 7 hours per unit, and Z 9 hours per unit. There is a shortage of labor in Department 2, and it is not possible to increase labor input hours beyond the level currently utilized. Fixed overheads are budgeted at 5 million per annum and are expected to remain constant. They are expected to remain constant. A recent survey disclosed that the maximum sales potential for the company is 12,500 units of X, 7,500 units of Y, and 8,000 units of Z. Advise the management of Zinc Limited on the most profitable production mix and the optimal profit using what? Throughput accounting. Now, our available labor hours, here, they're saying that there is a shortage of labor in Department 2 and it is not possible to increase labor input hours beyond the current what level. Okay, so X, this is Department 2. For you to produce a single unit of X, you require how many hours per unit? 3. And you are producing how many units? The budgeted production was 10,000. So you need 30,000 hours. Y, how much here? And this is 1 hour. This should be 1 hour in Department 2. That is 1 hour in Department 2, not 3 hours as previously indicated. So that is 1 hour in Department 2. Then Department 2, for Y, you're using 2.5 hours. You multiply by a budgeted production of 5,000. Z, 4 by who? 6,000. So that will be 24,000 hours. Then the product of 2.5 hours is 12,500. So for you to produce all your output, you need 46,500. 46,500. Then have your required labor hours still in department 2. X, we are determining this so that we can determine our limiting factor, so that we can see how much is scarce in this particular company. You require 1, 2, and 4, but your maximum sales demand is 12,500. Y is 7,500, and Z is 8,000. So that is 12,500. That is 15,000, and that should be 32,000. So for you to meet all your production needs and your maximum demand, you require how many labor hours? 59,500. 59,500. Therefore, you have a shortage or a deficit of how much? 46,500 minus 59,500. That means you have a deficit of 13,000. A deficit. Why? Because what you require is far much more than what is available. That is the first thing you do. Then the next item now is to determine our throughput. Our throughput cost per unit. Cost per unit. That is the second step. The first step here is to get our deficit. This is step number 1. So the second step is to get to determine our throughput cost per unit. And your throughput cost per unit, you're simply going to take your what? Your selling price, you subtract all your what? All your material cost. So it will be the selling price per unit, subtract all your direct materials. Your selling price per unit is 1,200. Y is 2,000. And Z is 2,250. You less your material cost. Remember, we've said using throughput accounting, the material cost is the only cost that is assumed to be what? Variable. The only cost assumed to be variable. So your material cost is 300. 900. And lastly, 600. So that this will give you what? Throughput cost per unit. Cost per unit. That is 900. That is 1,100. That must be 1,650. 900. Wonderful. Once we've done that, step number 3 is we determine your throughput cost per unit per limiting factor or per scarce what? Resource. Per limiting factor or per scarce resource. And how will you do that? You're going to determine that by taking your throughput cost per unit. You divide by your limiting factor per unit. You divide by your limiting factor per who? Unit. X, Y, and who? Z. Your throughput cost per unit. That is 900. That is 1100. And that is who? 1650. That is 1650. You want to divide that by your limiting factor. And remember, your limiting factor is said is a scarce what? Resource. So your limiting factor is a factor that gave us a what? A deficit or a what? Shortage there. And what was it? The shortage was given by your labor hours. The labor hours per unit. And here, X, you are using 1 hour, Y, 2 hours, and Z, 4 hours per unit. So therefore, your throughput cost per unit, per labor hour per unit, that will be 900. That is divided by 2. It's 550. 1650 divided by what? 4 is for 12.2.5. For 12.5. The fourth step is to determine your rank. And the rank here, you're normally going to use, or is going to be based on the highest throughput cost per limiting factor. So here, it is based on the highest per unit, which is step number what? Which is step number 3. So here you have X, you have Y, and you have who? Z. Your throughput cost per limiting factor is per labor hour per unit. Per labor hour per unit. Here you'll have X, you'll have Y, and you will have who? Z. As per step number 3, that was 900, that was 550, and that lastly, that was 412.2.5. Then you now introduce your who? Ranks. And the first product you want to rank number 1 is XY. It has the highest throughput per labor hour per unit. Then product 2, and lastly product what? Z. Product XYZ. Step number 4 is you determine your optimal output. You determine your optimal output. This optimal output will be the one to maximize your throughput cost per unit. So here you must have your product, your available labor hours, because that was the limiting factor. Compare this with the required labor hours. Then determine your who? Output in units. Determine your output in what? Output in units. According to the rank we've just determined in step 4 above, the first product we want to produce is X. So let us produce X as our first product to produce. Our available labor hours as per our working in the first part of the question was 46,500. Those are the total available labor hours. And for you to produce X, you require how many labor hours? 10,000 labor hours. So to determine your output, you're going to take your required labor hours of 10,000. Then you divide this by the hours per unit of X in department 2, where you are using how many units? Hours per unit, 1. So therefore, you're going to produce how many units? 10,000 units. The next product according to our rank is produce product Y, where you now will determine your available labor hours after producing what? X, by taking 46,500 hours, but to produce X you've used how many hours? 10,000. That means how many hours are remaining? 36,500. 36,500. The required hours to produce Y were 12,500. 12,500. So we then need to determine our who? Output. How is that? We are going to determine it. You are going to determine 12,500. Then you divide that by the hours per unit that Y is using in department 2, which is how many hours? 2.5. 2.5. And therefore, you will need to produce how many units? 5,000 units of which product? Of Y. Let's produce product Z. Let's produce product Z as a last product. You have produced 5,000 units of Y and used how many hours? 12,500 out of a possible how many hours that are available? 36,500. That means the new available labor hours that you're going to use to produce who? Product Z will be 24,000 labor hours, which is 36,500 minus the required hours that you used of 12,500, 24,000. You require Z 32,000, but you don't have 32,000 available labor hours. You only have 24,000 available labor hours, and that is what you're going to use. Then let's get our output. You're simply going to take 24,000 labor hours. You divide by the labor hours per unit of what? Z. And the labor hours per unit of Z is 4. So that is 6,000 units. 6,000 what? Units. 6,000 units. Let's then determine our optimal what? Profits. We need to determine our optimal profit. I will work this optimal profit in this other end. They were asking us to determine our output and our optimal what? Profits. Now, let's start with our sales. We will have for which product? X, for Y, and lastly for who? Z. The units of X or the selling price is 1,200, but how much were you selling of X? You are producing and selling 10,000. Y is 2000. By how much? You are producing and selling 5,000 units. Z 6,000. Your selling price rather is 2250. You multiply by how much? 6,000 units. 6,000 units. Then we less our direct materials. Our direct material cost, which we've said when you're using throughput accounting, always treat the material cost as a variable what? Cost. Therefore, it is going to change with your who? Output. So the material cost that we want to determine here will be for this optimal output. For this optimal output. You can start with X, Y, and who? Z. The material cost per unit of X is 300, Y is 900, and Z is 600. You multiply your optimal output of 10,000 units, which is this 10,000. Y is 5,000, and Z is 6,000 units. That will give you your throughput what? Cost. That will give you your throughput what? Income. Then we need to less our other. But these other costs, all of them are going to be treated as what? Fixed costs. They are going to be treated as fixed cost. Therefore, when you're determining these other costs, you're not going to multiply them by the optimal output when they have been given the cost per unit. Instead, you're going to be multiplying them by the budgeted output. You're going to be multiplying by the budgeted output. You can start with which cost? Variable overheads. The variable overheads of X, Y, and Z, they were given per unit basis, so therefore you are going to multiply by your current budgeted production. The cost per unit of X is 150. By your current budgeted production of how much? 10,000. Y plus fixed cost. Y 400. By a budgeted production of who? 5,000. Z 450. By who? 6,000. By 6,000. That is variable what? Overheads. The other cost must be the cost of direct labor. Direct labor. Direct labor. And your labor cost here can say for department X or departments. You have in departments. You will have in departments. So in department 1, can start with who? X. Can start with X, and X you are using 3 hours per unit. Then you multiply by your budgeted production of 10,000 plus so for X will be 3 hours times budgeted production of 10,000 plus Y is 4 hours by a budgeted production of 5,000 plus Z, the hours per unit are 6 hours by your budgeted production of how many units? 6,000 hours. Once you've determined your labor hours, you then multiply by your labor rate per hour of how much? 20. You multiply by your labor rate per hour of 20. So this will just give you the product of the labor hours. Let's go to department 2. Department 2. Department 2, X, you are using an hour times budgeted production of 10,000. Y, you are using 2.5 hours by a budgeted production of 5,000. Z, you are using 4 hours times budgeted production of 6,000. But in department 2, the rate per hour is how much? 40. Department 3, you are using 5 hours per unit, but your budgeted production was 10,000 for X. Y, you are using 7 hours by budgeted production of 5,000. Z, 9 hours times who? Times 6,000. Then all that you multiply by a rate per hour of how much? 30. Then the other cost, those are the other costs here. So the last cost is your fixed cost. Your fixed costs. And your fixed cost was given by note number 3. Fixed overheads are budgeted at 5 million per annum. 5 fixed overhead costs. Of what? 5 million. Then we are going to determine a net profits or what? Loss. Your net profit or loss. And let's do that. Let's do that. We want to get the product, our profit rather. Our profit using the throughput costing. The throughput income will be 2.44 million. $2.44 million. $150 by 10,000. That is 1.5. That is 2 million. That is 2.7 million. $30,000 plus 20,000 plus 36,000 means you have used 86,000 hours by 20. That is 20,000. 10,000 hours of X plus hours of Y plus the hours of Z you have used 46,500, but each hour is being paid at 40, so that is 60,000. 50,000 hours, which is 5 by 10 plus 35,000 hours plus 54, that is 139,000 hours by 30 of his labor hours on that variable overhead. The variable overhead is 6.2. million 750,000. So therefore your profit or loss will be 545 and confirm this is okay. 50,000. All right. So the main difference between what throughput accounting and what limiting factor is simply the treatment of what, or the determination of what, throughput, cost per unit here, the determination of throughput cost per unit. Under throughput accounting, you must determine your throughput by taking your selling price minus your direct material cost. But with limiting factor, you normally take your selling price, you subtract all the variable cost, Remember, in throughput accounting, we've said all other costs that are not what? Direct materials, you will tend to treat them like fixed cost. You will tend to treat them like fixed what? Fixed cost, like fixed costs. All right. We have come to the end of that subtopic known as throughput accounting, and in the next lesson we are going to do drop or continue decisions. Goodbye.
Hi candidates, welcome to another session of Manifested Online Classes. We are still continuing with the topic of group account, and in this session I want us to look on another concept of group accounts, and the concept is changes in group structure or disposal of interest. So when we talk about the disposal of interest, or basically changes in group structure, this whereby the parent company will sell all the shares held in a subsidiary, or basically sell part of the shares and retain some of the shares held in such what? A subsidiary. So therefore, what we're going to do here is we're going to look on how to prepare the group account whenever there is changes in the group structure, or basically we have now the disposal of what? Of interest. But before we even do that, we can have an introduction to this, and we say that changes in group structure occurs when the parent company sells the whole or part of shares, shareholding in the subsidiary company, So basically that's what we refer as the disposal of interest. So the parent company here will sell some of the shares, or basically all the shares which are held in a subsidiary company. Now generally the disposal of interest can be broadly classified into two main categories. First of all, we have what we refer as a full disposal. A full disposal is whereby the parent company sells all the shares which are held in a subsidiary. That is a full disposal. But on the other hand, we have a partial disposal whereby the parent company sells some of the shares held in a subsidiary and retain some of the shares. So therefore here we can talk of types of disposal of interest, So when we say there are two types of this, we say disposal of interest can either be, number one, we have the full disposal, and then we have the partial disposal. Disposal. But in accordance with the International Financial Reporting Standard number 3, a disposal of interest basically occurs when the parent company loses control. So mean that once the parent company sells some of the shares which are held in a subsidiary company, and the parent company now loses control. So mean that the shares which will be held by the parent company in the subsidiary falls below 51%. So actually from 50% to 0. That is the time the disposal is deemed to have occurred in accordance with IFRS 3, in which case then the parent company is required to determine something called the gain or loss on disposal. So therefore the gain or loss on disposal basically is determined when the parent company loses control. So therefore you can say according to IFRS 3, IFRS 3, International Financial Reporting Standard number 3, disposal of interest occurs when the parent company loses control. The parent company loses control. Loses control. So basically what that means is that the shares now which are retained by the parent company, the subsidiary, or basically the parent company will sell some of the shares and retain shares which are less than 51%. So that is the time the disposal take place. And in such a case, then we are saying the parent company should proceed and determine the gain or the loss on disposal. What is important, therefore, to note as far as that point is concerned is that if the parent company has retained a control, when talk about retaining a control, this whereby we can be told A Limited, which held 80% of the ordinary shares issued by B, the parent company we can be told like sold like 20% of the shares. 20% of the shares. What does that mean? It means that the parent company has retained 60% of the shares in what? In B. In such a case, you can see the parent company still having a control, because we said a company or an investor company will have a control of the investee, whereby the shares held by the investor company, the investee company, lies between 51% to 100%. So, but you're saying disposal in accordance with IFRS 3 occurs anytime the parent company loses control. It sells some of the shares here and retain shares which are now less than 51%, from 50% to 0. In which case we are saying a gain or a loss on disposal should be what? Should be determined. And therefore, you can say when disposal of interest occurs, that is when the parent company loses control, a gain or loss on disposal should be computed or should be determined, we can say should be determined as follows. So how do we compute that particular gain or loss on disposal of interest? So gain or loss on disposal of interest. So to determine this gain or loss on disposal of interest, number one, we take the fair value of purchase consideration received. Purchase consideration received. So when the parent company sold some of the shares, or basically all the shares in a subsidiary, how much amount was received by the parent company? So that is now what referred as the fair value of purchase consideration received. To this we add the fair value of investment which has been retained. Fair value of investment which has been retained. When talk about the fair value of the investment which has been retained, so this basically applies in case of a partial disposal whereby the parent company has not sold all the shares in a subsidiary. If, for example, the A Limited, which is the parent, which initially had acquired 80% shareholding in B, which is the subsidiary, if, for example, the parent company sells like half of these shares, sells 40% of the shares held here, it means that the parent company has retained a shareholding which is equal to 40%. So at the date the disposal took place, the remaining investment will have to be revalued at its fair value, and always that figure will be provided to you. That's what we refer to as the fair value of the investment retained. So after adding those two figures, we come here and we less, number one, the fair value of net assets, fair value of net assets held at date of disposal, at date of disposal. So the fair value of the net asset held at the date of disposal, and then to this we also add the parent company and impaired goodwill. The parent company and impaired goodwill. And after deducting those two figures, we can get a positive figure here. If a positive figure, that is a gain, but if a negative figure, this is a loss on disposal. A loss on disposal. Yes, so this is basically how the gain or loss on disposal is determined anytime the parent company has lost the control. The parent company sells some of the shares held in a subsidiary, and therefore it retains shares which are less than 51%, from 50% to 0. Always in such a case we compute the gain or loss on what? The gain or loss on disposal. So then next we can proceed and look on how we prepare the consolidated financial statement anytime we have changes in the group structure. So let's look on the preparation of group accounts. So in this case, we're going to look on how we prepare the group accounts at different types of disposal. So remember, you have said that disposal of interest can be broadly classified into two: partial disposal and the full what? Disposal. Let's start with the full disposal. The full disposal. A full disposal generally is whereby the parent company sells all the shares held in a subsidiary. Sells all the shares held in a subsidiary. Maybe first of all, you can say that this is a whole what? Disposal, or basically a whole sale of shares in a subsidiary. So a wholesale of shares in a subsidiary company. And this one is basically governed by IFRS 5. So basically, in terms of how the parent company should treat that particular subsidiary which has been free disposed, that should be accounted for in accordance with IFRS 5, meaning that that subsidiary now will be termed, or basically will be referred to as a discontinued operation. Assuming we are told A Limited had acquired 80% shareholding in B Limited, and the parent company sells all these shares. sells all these shares. So if that is the case, then this particular subsidiary is a discontinued operation, and should be accounted for in accordance with what? In accordance with IFRS 5. So what IFRS 5 requires is that the parent company should, number one, determine the gain or loss on disposal, and number two, the parent company should determine the gain or loss reported by that discontinued operation, and that one should be recognized, or those two items, the gain or loss on disposal of interest, the gain, not the gain rather, the profit or loss from the discontinued operation, they should be recognized as separate items in the consolidated income statement. So therefore, we can say in this case, the parent entity or basically company should determine, or in other terms determine, number one, the gain or loss on disposal, the gain or loss on disposal of interest, and number two, the profit or loss from discontinued operation, from, we can abbreviate this as DO, from discontinued operation. And you are saying that these two items, that is the gain or loss on disposal and the profit or loss from discontinued operation, they should be recognized. This should be recognized as separate line items in consolidated statement of profit or loss. Should be recognized as separate line items in the consolidated statement of profit or loss. Let's maybe from our group structure here, we introduce another company here, that is C Limited. We also assume that the parent company had a shareholding of 75%. So, and also we are told that the parent company, that is A, had 80% shareholding in B Limited, but we are told during the current financial year, the parent company sold all the shares held in B. So we have said B is a discontinued operation. So therefore, when A Limited is preparing the consolidated income statement, the consolidated income statement or the consolidated statement of profit or loss. So the parent company should first of all determine the profit or loss from the continuing operations. So the continuing operations will be the parent company and the NC, because you have said this one is a discontinued operation. So therefore, the parent company should determine what? The profit or the loss from continuing operations. Continuing operations include A and C. And for the parent company to do that, basically, in this case, we take the revenue of this, that is A, plus the revenue of C. And then we also take the expenses, including the cost of sales of A plus that of C, We less that now from the revenue. We get, whatever you get here will be the profit or loss from continuing operations. Continuing operations. And then we are saying that these two items here should be added to the profit or loss from the continuing operations. So then we have the discontinued operations. Discontinued operation, basically you have said is this subsidiary which has been disposed. So two items will be included here: the gain or loss on disposal of interest, And you have to recall that this one is computed using that particular approach there, or that particular format there. And then we also have the profit or loss from discontinued operation. So how do we determine this a profit or loss from discontinued operation? So we take the revenue of this company. For example, the parent company sold the shares held in B Limited, for example, 6 months from the start of the current financial year. So in that case, you take the revenue of B for the first 6 months and also its expenses for the first 6 months, and then determine the profit or even the loss which was reported by that subsidiary B, which was fully disposed. You'll get the profit or loss from the discontinued operation. So if it's a profit, you add. If it's a loss, we do what? We less here. We less. And then we add that now to the profit or loss from the continuing operations. And then we get the profit for the year. The profit for the year. So that's basically how we deal with what referred as a full disposal. A full disposal. And basically, remember, these are priced in preparation of a consolidated statement of profit or loss. Consolidated statement of profit or loss. So basically, when now preparing the consolidated statement of financial position, at the end of the year, the parent company will have fully disposed its shares in this subsidiary. So the parent company will not be having any control. Equally, there will be no NCI. So therefore, we can say that when preparing this consolidated statement of financial position, we can say there will be no NCI, or basically we can say assets and liabilities of subsidiary fully disposed are not included in consolidated statement of financial position. So the assets and liabilities of that subsidiary will not be included in the consolidated statement of financial position. And equally, as far as that subsidiary is concerned, there will be no NCI. The minority shareholders will not be entitled to share the net asset of that subsidiary as at the end of what? Of the year. That's basically how we deal with the what referred as a full disposal. Then from there we have the other type of disposal. Recall in our case here we have said that we have two types of disposal: the full disposal and the partial disposal. Partial disposal. Now here we have different types of partial disposal. Actually, we can say we have different scenarios of partial disposal. Number one, or number A, we have what referred as a disposal of a company which was initially a subsidiary and which still remains a subsidiary. Which still remain what? A subsidiary. A subsidiary company to a subsidiary. So when talk about a subsidiary to a subsidiary, this whereby we can be told the parent company had like 80% shareholding in B Limited, and the parent company, for example, sold 20% of the shares. So if it sold 20% of the shares, then it means that the parent company here retained 60%. So therefore, you can see B Limited still remain what? Remain a subsidiary. So when it comes to preparing a consolidated income statement, what you do, you take the revenue and expenses of that subsidiary, you add to that of the parent. Actually, that disposal do not have any effect as far as the preparation of the consolidated statement of profit or loss is concerned. On the other hand, when preparing the consolidated statement of financial position, because this company is still a subsidiary at the end of the year, you take its assets and liabilities, you add to those of the of the parent. Actually, this particular type of partial disposal do not have any effect as far as the preparation of the group account is concerned. It's also important to note that here, because the parent company is not losing control, no gain or loss on disposal of interest is computed. This one is not computed because you have said we only compute that one anytime the parent company loses what? Control. So we can say no gain or loss on disposal of interest. On disposal of interest. So that is it about that scenario of partial disposal. So the other type of partial disposal, part B, is a disposal which makes a company which was initially a subsidiary to be an associate or a joint arrangement. So first of all, you have to recall from what you have discussed in our previous sessions that investment in associate, investment in joint arrangement should be accounted for in the same way using the equity method. That is something, first of all, you have to recall, and that's why you can see here we are talking of associate or the joint arrangement at one point. So this whereby we assume that the current financial year was ending on 31st of December 2023. That is the date of consolidation when the group accounts are supposed to be prepared, meaning that the year started on 1st of January 2023. We may be told that the parent company initially had acquired like 80% of the shares, like maybe A Limited had initially acquired 80% shareholding in B Limited some time back, but during the current financial year, maybe on 1st of July 2023, the parent company sold or disposed 40% or half of these shares. So mean that the parent company sold 40, and that means that the parent company then retained 40%. So if it retained 40%, then it means that this company, which was initially a subsidiary, then becomes what? An associate. And therefore, in the first 6 months, the parent company, you can see, had 80% shareholding, meaning that this company was therefore a subsidiary. And then after selling half, the parent company retained 40%, meaning that in the last 6 months, that company was what? Was an associate. So how do we go about in this case, or how do we prepare the group account in such type of a partial disposal? Number one, when preparing the consolidated statement of profit or loss, number one, we have to compute the gain or loss on disposal. We have to compute the gain or loss on disposal of interest, of which this particular gain, if it's a gain, it is recognized as in the income statement as an income. If it is a loss, it is recognized as an expense. Number two, we then consolidate the results of the subsidiary company up to date of disposal. Like in this case, in preparing the consolidated income statement, you're going to take into account the revenue and expenses of B for the first 6 months when it was a subsidiary. And then in the last 6 months, because it was an associate, you have to recall that we don't include the revenue and expenses of associate in the consolidated income statement. So that's why we are saying consolidate it results up to the date of disposal, and thereafter include group share group share of its profit after tax, and that is in accordance with equity method. And that is in accordance with IS 28, because as far as the associate is concerned, we include, or what we include in the consolidated income statement is the group share or the parent company share of its profit after tax. So mean that you'll take the profit after tax of this company here, which is always given in its income statement, multiply that with 6 all over 12, so that you get now the profit after tax for the last 6 months when it was an associate, and then multiply that with the parent company shareholding in B, which is 40%. 40%. So that's basically how we prepare that. And then how do we prepare the consolidated statement of financial position? Consolidated statement of financial position. So in preparing the consolidated statement of financial position, our interest is basically the status of this company at the end of the year. So what will be the status of the investee company at the end of the year? At the end of the year, the investee company, that is B, will be an associate, and therefore in accordance with the equity method, what we include in the consolidated statement of financial position as far as the associate is concerned is something called the investment in associate. We don't include, or we don't combine the asset and liabilities of the parent, those of the associate, in preparing the consolidated statement of financial position. So therefore, in preparing this, we say compute the investment in associate, investment in associate or joint arrangement, and included in consolidated statement of financial position as a non-current asset. So in that case, you compute, or we compute something called the investment in associate or investment in joint arrangement, and we include that in the consolidated statement of financial position as a non-current asset. So how do we compute this particular investment in associate or joint arrangement? So investment in associate or joint arrangement. So this one is computed using this approach here, or this format. So number one, we take the fair value of investment which has been retained. Fair value of investment retained. So the investment which has been retained here is 40%, and basically we have said that in case of a partial disposal, the investment which has been retained always will have to be revalued to its fair value on the date of disposal. That figure will always be provided to you. So you'll be told that the investment which has been retained on the date of disposal had this fair value. That's what you use here, and then to this we add the group share of post-acquisition net assets. Post-acquisition net assets, and whatever you get here is now what you refer to as the investment in associate, investment in joint arrangement, and you're saying that that should be taken to the consolidated statement of financial position as one of the item of the non-current asset. Yes. So basically those are different scenarios of partial disposal, and basically how we deal with them specifically in preparing the consolidated financial statement. So basically that's what you need to know. I want us to stop at that particular point. Once we come back in our next session, I want us to look on an illustration question regarding how to prepare the group accounts, and also how to compute the gain or loss on disposal in case of disposal of interest. So see you in the next session.
Greetings, candidates, and welcome back to the lesson. The subject is meetings, compliance, and administration. We continuing with the topic on governance standards and guidelines. So far, we've covered guideline standard number 001, 002, 003, 004, 005, 006. Today, we move to governance standard number 7, GS 007. This is filing annual returns. Filing annual returns is our today's focus. That is governance standard number 007. And this is the standard that ensures that public record of a company is kept current. It is done what? It is kept current. Because while many mistakes an annual return for say tax returns, the GS 007 focuses on statutory compliance. Many mistake an annual return for tax returns, but GS 007 focuses on statutory compliance. That means confirming that the company's structural details, like directors, shareholders, and their addresses with the government register are accurate. So GS 007 is a standard that mandates that an organization provides a periodic health check to the registrar of companies, and that is to ensure transparency for the public, for the creditors, and for the investors. You understand? Yes. So do not mistake annual returns for tax returns. Here we are not discussing tax returns. We are discussing filing annual returns. All right? The standard focuses on compliance, statutory compliance, because the law mandates companies to make certain returns. So what is an annual return? If an annual return is not a tax return, then what is an annual return in the context of governance standards? Now, an annual return, candidates, is a statutory document that summarizes the company's legal structure as of a specific date. Let me define it. An annual return is a statutory document. Statutory document. First of all, it is a statutory document. An annual return is a statutory document that does what? That summarizes the company's legal structure. That summarizes the company's legal structure as at a certain date. All right? That summarizes the company's legal structure as of a specific date. As of a specific date. As of a specific date. That is the meaning of a statutory annual return in a snapshot. In a snapshot. That is the meaning. It is a statutory document that summarizes the company's legal structure as of a specific date. It is not a financial report, but a confirmation of, say, registered office. It's a confirmation of the company's registered office. It's a confirmation of the company's registered office. This is the physical and postal address of the company. It is also a confirmation of the company's officers. It is a confirmation of the company's officers. This is the current list of directors and the corporate secretary. It is a confirmation of the company's share capital. It is a confirmation of the company's share capital. That is the total number of shares issued and their value. It is also a confirmation of the company's shareholders. It is a confirmation of the company's shareholders. These are the owners of the company, names of members, and any share transfers that occurred during that year. It shows the list of shareholders and any transfers that were made during that specific year. Understand? Yes. It also confirms the company's indebtedness. It confirms the company's indebtedness. It details any mortgages or charges secured against the company's assets. Mortgages or charges secured against the company's assets. Indebtedness. You understand? So that is an annual return. Because you recall in our previous sessions, we covered the documents, the statutory documents, the statutory documents, the statutory paper, the statutory documents, registered office, company's offices, company's officers, the share capital, the shareholders. So an annual return, it is not a financial report. Neither is it a tax return, but it is a statutory document that confirms or summarizes the legal structure of a company as at a specific date. It confirms the company's registered office, the company's officers, the company's share capital, the shareholders, and indebtedness. Now let's discuss the deadlines and timing. Deadlines and timing. This is number one. Number two, deadlines and timing of filing annual returns. Okay, so in analyzing the deadline and timing, we are going to have the milestone and the requirement. Let's have the milestone and another column for requirement. Milestone and requirement. We begin with the return date. Return date. The return date. This is usually the anniversary of the company's incorporation. These documents or confirmation must be done during the anniversary of the company's incorporation. The requirement is usually the anniversary of the company's incorporation. The company's incorporation is the birthday of a company. It is the day the company is born. So after the first anniversary, after the first year of incorporation of a company, then the company has to file annual return. Then there is the filing window. filing window. There is a window within which the filing has to be made. And most jurisdictions require the return to be lodged within 20 to 42 days of the return date. 28 to 42 days. 28 to 42 days of the return date. That is 42 days or 28 days after the return date. The return date is exactly 1 year after the incorporation of the company. Understand? So filing has to be done by 42 days. Okay? Within 42 days, not more than 42 days. And it could be after 28 days, between 28 and 42 days after the anniversary. It could be first anniversary, second anniversary, third anniversary, and so on. So that if a company was incorporated on 1st January 2024, the first anniversary would be 1st January 2025. So the filing date, the filing window, there is a window. It's supposed to be between 28th of January, then not more than 42 days after 28th day of January 2025. That is the filing window for a company that is incorporated on 1st January 2024. That is the filing window. Then another milestone is the AGM link. AGM. The AGM link. In many jurisdictions, the return is made up to a date shortly after the annual general meeting. That is General Standard number 001, annual general meeting. The return is made up to a date shortly after the annual general meeting. The date shortly after the annual general meeting, because general meetings are also held annually. That's why they are called AGM. This A stands for annual. So shortly after the AGM, these returns are supposed to be filed. Understand? Yes. So that is the deadline and timing of filing annual return. The GS 007 also has what we call a compliance check. To fulfill this standard, there are steps that must be undertaken. So what is the compliance check? So this is number 3. Number 3, compliance check. There are steps that must be followed when filing the annual returns. To fulfill the GS007, there are steps that must be undertaken. The first step is verification. Number 1, verification. 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 This is to ensure that information in the return matches the internal statutory records. Because what is filed is just information in the statutory records. If the company is to confirm the registered office, then the name of the registered office in the return should be the name in the register or in the name in the statutory records. So what is filed here is what is contained in the statutory records. So there has to be verification. What is contained in the annual return should be what appears in the statutory records. That is what we are calling verification. And that is the work of the company secretary. Company secretary should ensure that the information in the return matches the internal statutory registers that we covered in our last session, that is GS006, registers and records. Because what is being filed is confirmation of what appears in the records and files. You understand? Yes. Number 2, after verification, there is certification. After verifying, then there has to be certification. The return must typically be signed by at least one director and the company's secretary. Then, of course, there is the aspect of financial statements. The financial statements. What do we mean? For many companies, there ought to be a certified copy of the audited financial statement, which must be attached to the return. In some countries, in some regions. Then the 4th item on the compliance checklist. This is a compliance checklist. Is payment. Lodgement is only considered complete once the statutory filing fees is paid. So that's very important. And candidates, here we are discussing statutory matters. What we are discussing here, these are requirements of the law. And there are consequences of non-compliance. If the company does not comply, if the company does not file annual returns, then there are consequences of non-compliance. Consequences. Let's discuss the consequences of non-compliance. Consequences of non-compliance. Because these are statutory responsibilities, then the company that does not comply then faces certain consequences. Because GS007 is heavily enforced because the registrar relies on this data for public transparency. The registrar of companies relies on the data that is provided under GS007 for the purposes of transparency. And failure to file results may lead to automatic fines. This can lead to automatic fines. Automatic fines. The company may be fined for non-compliance. The company can be fined for non-compliance. There could be a daily penalties that accumulate until the return is filed. Understand? Yes. Number 2, dormant status. What do we mean by dormant status as a consequence of non-compliance? The company may be listed as not in good standing, which may affect bank accounts, which also may affect It may affect bank accounts. The dormant status may also affect contracts that are entered into by the company. The contract may be declared null and void because the company is dormant. It is not in good standing. That is a consequence of non-compliance. That is a consequence of failing to file annual returns. Another consequence is striking off. The company may be struck off. Persistent failure can lead to the registrar of companies. The registrar of companies may possibly dissolve the company and seize its assets. It can lead to striking off of the company. The company may be dissolved because of failure to file annual return. Consequence number 5 is personal liability. Personal liability. What do we mean by personal liability? Personal liability. Directors can be held personally liable, and in extreme cases, they could be prosecuted. Understand? Okay, so these are consequences of non-compliance. And that effectively brings the lesson to an end. The topic is governance, standards and guidelines. Today we are studying GS007, filing annual returns. We've defined what an annual return is. We've said an annual return is not a tax return, but it is a statutory document that summarizes the legal structure of a company as at a specific date. It is just a document that confirms the company's registered office, the company's officers, the share capital, the shareholders, and the indebtedness of the company. In this lesson, we've studied the deadlines and timings of making annual returns, of filing annual returns. The first milestone is the return date, which is usually the anniversary of the company's incorporation. The second milestone is the filing window. The filing has to be done between the 20th day to the 42nd day of the return date. Then there is the AGM link. These returns could be made shortly after the AGM is conducted. Then in this lesson, again, candidates, we have outlined the compliance checklist. Before the filing is done, the company secretary has to verify that what is contained in the annual return is what appears in the company's records. Then there is certification. At least one director is required to sign the annual return. Number 3, in certain jurisdictions, the financial statements are required to be attached to these annual returns. Then number 4, the compliance checklist. The 4th one is payment. We've said that lodgement is only considered complete once the statutory filing fee is paid. Then, of course, lastly, we've discussed the consequences of non-compliance. Non-compliance can lead to automatic fines, dormant status, striking off, and also personal liability. That's the end of today's lesson. Thank you for attending the lesson. Make sure you go through the video again, take notes, then go to our revision partners. We have questions on this topic, governance standards and guidelines. Attempt the questions without looking at the answers that are provided at the back of the book. You understand? At the end of this topic, please get hold of our revision partners. We have analyzed KASNEB past paper questions, topically arranged for your ease of revision. Attempt questions on governance standards and guidelines before looking at the answers at the back of the book. Thank you for taking your time to study with us. In our next session, we are going to the next governance standard, number 008, common seal. Bye-bye.
Welcome to Manifested Publishers. We then can now do a question. December 2024. Question 4. Agrovet Group. The question states, Agrovet Group is a multi-divisional agrochemical firm that deals in multiple products. Delta Division, one of its subsidiaries, makes 3 products branded BTAX, Zite, and Alpha. The management is contemplating changing the sales mix in scenario 1 to a new sales mix in scenario 2 in order to maximize the net profit. The 2 scenarios are envisaged as below. Scenario 1, the sales costs and output data for the original sales mix for the year 2024 for the 3 products is as follows. You have your sales mix, your selling price per unit, your variable cost, your total fixed cost, and your total sales revenue. Scenario 2, Agrovet Group sales, estimated sales cost and new sales mix as follows. Your sales mix, your selling price, your variable cost, your total cost, and your total sales. Management performance measures are based on cost volume profit analysis. The weighted average contribution margin ratio of each scenario is determined based on its sales mix. Compute both the break-even point in sales revenue and the profit for each. By comparing the break-even point and net profit, advise the management of Agrovet Group whether it is worthwhile to change the sales mix. All right. So let's start by analyzing what we've been given. We have 3 products, which is BTAX, Zite, and lastly Alphas. Your selling price P is how much? 2,000. A variable cost of 1,000. So that your contribution margin will be 1,000 and your contribution margin sales ratio is 0.5. Zite, your selling price is 3,000 with a variable cost of 1,800. So that is 1,200. That should be 0.4. 2,500, 1,500. That is 1,000. .4. This is scenario 1. This is scenario 1. Scenario 1. Here, that is scenario 1. Scenario 1. Your total fixed cost in scenario 1 is 15,664,000. Your total revenue is 45 million. Is 45 million. 45 million. Then first part of that question, compute both the break-even point in sales value and net profit for each scenario. For each scenario. Let's get the break-even point. To get your break-even point in units, say it is your fixed cost divided by your weighted average contribution margin. And your weighted average contribution margin, you're going to take it as the weight times the contribution margin of each product. And they're saying the sales mix of BTAX is 0.4 by the contribution margin of 1,000, the weight of ZT of 0.3 by the contribution margin of what? 1,200 plus the weight of alphas 0.3 by contribution margin of how much? 1,000. By contribution margin of 1,000. So therefore, your total contribution margin, will be 1060. 1060. Right? So therefore, your break-even point, you're going to take what? 15,664,000 divide by 1060. 664,000 divide by 1060. That should give you 14,777.36 units. 0.36 units. To determine your break-even point in shillings or in sales, you simply take your fixed cost, divide by weighted average contribution margin sales ratio. Your weighted average contribution margin sales ratio, you're going to take the weight by the sales ratio. The weight was provided as 0.3 times your sales ratio of 0.4. The weight, which is the current sales mix in the question, of 0.3 times your sales ratio of 0.4 times 0.4. So that should give you 0.44. So therefore, your fixed cost in scenario 1 was 15,664,000 divided by who? 0.44. So in shillings, that should be 35,600,000 what? 35,600,000. Scenario 2, we analyze scenario 2 here. We want to analyze scenario 2. Scenario 2. You have your first product, BTAX, then ZT, then alphas. Your selling price, your variable cost per unit, your contribution margin, and lastly, your contribution margin sales ratio. Your selling price is 2,000, of BTAX 1,000, contribution is 1,000, that must be 0.5. ZT, your selling price is 2,800, variable cost of 1,680. The contribution margin sales ratio will be 1120 divided by 2,800, which is 0.4. Alphas, this is 2,500, that must be 1,000, that must be 0.4. Your fixed costs is 15,664. Your revenues are expected to be 45 million. They are expected to be 45 million. BEP units, it is your fixed cost divided by your weighted average contribution margin. So let's determine our weighted average contribution margin. We're going to take the weight. The weight is changing now in scenario 2 such that the sales mix is 0.5 by who? 1,000 plus 0.3 by 1120 plus, this should be 0.2 not 0.3, 0.2 by 1120 plus 0.3 by 1,000 times 1,000 times 1,000. So 0.5 times 1,000 plus 0.2 times 1120 plus 0.3 times 1,000. That is 1024. That is 1024. So therefore 15,664, which is our fixed cost, divided by 1024, 15,664,000 divided by 1024 means for that company to break even in units, they need to sell 15,296.875 what? Units. They need to sell those number of units. Break even point in shillings. It is your fixed cost divided by your weighted average contribution margin sales ratio. How do you get your weighted average contribution margin sales ratio? You simply take your weight of 0.5 by your sales ratio of 0.5 plus weight of 0.2 times 0.4 plus 0.3 times 0.4. So 0.5 plus 0.2 times 0.4 plus 0.3 times 0.4. That should give you 0.45. So 15,664,000 divided by 0.45. That should give you 34,888,888.89 shillings. 0.89 shillings. Part 2 of that question, and they also are still in part 1. They're asking compute both the break-even point and the net profit for each scenario. So let's get the net profit. Let's go back to scenario 1. Net profit. You're going to say it is your weighted average contribution margin sales ratio. You multiply by your revenue minus your fixed cost. Minus your fixed costs, 0.44. Your total revenue was 45 million minus fixed costs of 15,664,000. That is 6,000 shillings. So that company will make a profit of how much? 4.1 million. Then the net profit in scenario 2, again you take your weighted average contribution margin sales ratio, you multiply by your total revenue minus fixed cost. Your sales ratio was 0.45 times 45 million as your revenue minus fixed cost ya 15, 664,000. 45, 86, 4.5, 86,000 shillings. By comparing the break-even point and net profit, advise the management whether it is worthwhile to change the sales mix. The current break-even point in shillings is 35,600. The other one is 34,808. The net profit of this company is 41,36, and this is 45,86. 45 what? 86. Therefore, what will you advise them? If you use the what? The break-even point as your basis of decision making, you're going to tell them to do what? To have the new what? Product. To have the new product ratio. So using the break-even point, you will advise them to do what? To have a new sales mix, or to take scenario 2. To take scenario 2. Why are you doing that? Because the break-even point in scenario 2 is lower than the break-even point in scenario what? 1 in shillings. In shillings, it is way what? Lower. Now, the net profit here, the net profit in scenario 1, that is 41,36. In scenario 2, it is 45,86. So what will you tell them? You're going to take the second what? The second what? Ratio, or the second scenario. Why? Because it has a higher what? Profit. It has a higher profit. It has a higher profit. So in both cases, you're going to tell them to change to scenario 2. You're going to tell them to change to scenario 2. So in both scenarios, you've agreed that you choose scenario 2. So you change the ratio or the sales mix to be 0.5 is to 0.2 is to 0.3 is to 0.3. Now, sometimes a student may ask, why is it that we are choosing scenario 2 instead of scenario what? 1. We are choosing scenario 2 instead of scenario 1 because it has what? Less shillings. That means any extra shillings above 34,000 is a what? Is a profit. Any extra amount above 35 million is also a what? A profit. It is a profit. All right. So you choose scenario 2 because it is the one with that will generate a break-even point in shillings very fast at 34 million compared to 35.6 million in scenario 1. Now, all right. So now that we have done multiple product, remember this is multiple product. It is multiple product. So this should not have been here so that it doesn't confuse you. That is multiple product. I will leave you an assignment that you can attempt in your own free time, which is April 2022, question 1D. April 2022, question 1D is the assignment I will leave you to attempt in your own free time. And please remember to attempt those questions. They are practice questions, and this being a mathematical unit, it is important you attempt them for your own what? Practice. For your own practice and understanding. I wish you a good time and God bless you.
Hello candidates, and welcome back to the lesson. The subject is governance and compliance audit. Today we move to another topic known as post-governance and compliance audit. Post-governance and compliance audit is a topic that has two subtopics. 1, nature and scope of subsequent events. 2, general guidelines on subsequent events. These are two subtopics. So we are going to begin with the nature and scope of subsequent events. Nature and scope of subsequent events. Now, candidates, first of all, what are subsequent events? Subsequent events. Subsequent events are significant events that occur between the end of the audit period and the date the audit report is issued. These are significant events that occur between two dates. One is between the end of the audit period, end of audit period, the end of the audit period. The audit period may end, for example, 31st of December. But after 31st of December, there might elapse a time before this audit is issued. And the date the audit report is issued. So there are events that may occur, there are some significant events that may occur between end of audit period. The end of audit period is a specific date. So between that specific date and the date the audit report is issued, those significant events is what we are referring to as subsequent events. All right? And they may even be sometimes even after the report is issued, but before it is acted upon. Okay? Because a report may also be issued, but it may not have been acted upon. Such events may still occur between that period. So in the aftermath of a governance and compliance audit, the auditor's responsibilities doesn't strictly end the moment the report is signed. No. The responsibility of the auditor exceeds even after the report is signed. You understand? So in governance terms, these subsequent events can fundamentally change the validity of the auditor's opinion or an organization's compliance status. That is the meaning of significant events, the meaning of significant events in governance terms. These events that occur after the auditor has completed his work can significantly alter the compliance status, can significantly alter the auditor's opinion as expressed in the auditor's report that is issued. So what is the nature? Because we are studying, that is the meaning of subsequent. First of all, we have defined subsequent events. Now, having understood what subsequent events are, what is then the nature of these subsequent events? Nature. Let's move to understand the nature of subsequent events. What is the nature of subsequent events? Now, subsequent events in a governance audit typically fall into two categories that mirror international auditing standards. Right? One is adjusting events. Adjusting. There is what we call adjusting events. These are conditions existing at year end. Adjusting events are conditions existing at year end. Adjusting events are those conditions existing at the year end, at the end of the audit period. These are conditions that were existing. You understand? And these conditions provide evidence. They provide evidence that existed during the audit. These events provide evidence of conditions that existed during the audit period, but only became clear after the field work. These conditions only became clear after the audit period. For example, there could be a court ruling on a lawsuit that was ongoing during the audit that confirms massive breach of a treaty. So by the time the auditor is completing his work, the company could be facing a lawsuit in a court of law, because that is a condition that was existing at that time at the year end. So by the time the report is being issued, maybe the case has not been determined. So the case is determined after this, the date the audit report is issued. The case is now determined. A court ruling on a lawsuit that was ongoing during the audit that can confirm a massive breach of treaty. So that means that the impact then is that the auditor must do what? The auditor must adjust the findings and even adjust the maturity score, because the risk was present all along. That's why we are referring to it as adjusting event. The auditor has to make adjustment in the audit report, because these are conditions that exist during that audit period. You understand, candidates? You understand? Yes, that's the meaning of adjusting events. Then number 2, we have non-adjusting events. Non-adjusting events, on the other hand, these are new conditions. These are new events. These are new conditions. They didn't exist. These are just new occurrences. These are events that arose after the audit period. They arose after the audit period. That is to mean they don't change the past data, but they make the audit report stale or misleading if not disclosed. Can we give an example? Yes. An example of a non-adjusting event is a massive fire outbreak, a major fire destroying the IT server room, or a sudden change in a national legislation that renders the current board structure illegal. There is a new legislation that has been signed that changes the board structure, that makes the board structure illegal. There is a fire that breaks and destroys the IT server room. That is a condition that never existed before. That is a new condition. So what is the impact? Now, the impact of a non-adjusting event is that the auditor must add an emphasis of matter. The auditor should add what we call emphasis of matter. Emphasis of matter. The auditor has to add the emphasis of matter or a disclosure note to the audit report so that the stakeholders are not misled. This event occurs after the auditor has signed the report has been issued. Something happens that alters even the entire opinion. Okay? So that report cannot be relied upon. The auditor has to add an emphasis of matter so that the stakeholders, those who are going to rely on the report, are not misled. Now, let's, in light of what we just discussed, let's move to another important aspect in relation to subsequent event, which is the scope of review. What is the scope of review? What is the scope of review? Now, the auditor's scope for detecting these events involves specific procedures rather than a full audit. You understand? If you are an auditor and the audit report has been issued, you need to carry out certain procedures in relation to subsequent events. And this is not an entirely new audit, but it's just a review. The scope of detecting these events involves specific procedures. You have to carry out specific procedures to identify or to discover or to be aware of the subsequent events. And the procedures may include inquiry of management. You can inquire of management. You can ask the board and the CEO if any significant contracts were signed, or if assets were seized, or if regulatory probes were launched since the field work ended. You need to ask those questions, because that can reveal subsequent events. The second procedure is reviewing minutes. Minutes review. After the audit report is issued, you can read the minutes of the board and the committee meetings, the minutes of board and minutes of committee meetings that are held after the audit period. You check the minutes so that you can identify if there are any subsequent events. Then there is regulatory monitoring. Conduct regulatory monitoring. Check for new gazetted laws or circulars from the central bank or from any relevant authority. That can also reveal subsequent events. Then there is media and market intelligence. Media and market intelligence. Media and market intelligence. You can monitor news for any reputational hits or legal challenges involving the organization's directors, and so on. So that is how you establish if there are any subsequent events. And we've said, candidates, these subsequent events can significantly alter the audit report or position. So maybe in closing, let us, so this is scope. Let's discuss the impact of subsequent events on the audit opinion. Because the timing of when a subsequent event is discovered determines the auditor's course of action. So let's have it in a diagram. So we can have here the discovery timing. So we are discussing here the impact. Let's have a column for discovery timing. Discovery timing. Then we can have the other column is the action, auditor's action. The auditors. I've said that the timing of when a subsequent event is discovered determines the auditor's course of action. So the first timing is before signing the report. Before signing the report. Before signing the report, you can see this obviously, the auditor can incorporate the findings into the report. Incorporate findings in the report. If a subsequent event occurs before the audit report is signed, then it's very easy for the auditor to incorporate the subsequent events into the audit report. But it could be after signing, but before, could be after signing, but before issuance. Could be after signing the report, but then the report has not been issued, because you can sign a report, but you still holding it, it has not been issued. So when that happens, what will be the auditor's action? The auditor's action here is to discuss with management. Discuss, you can discuss with management with the view of revising. You can discuss with management, then revise the report because it's not yet been issued. You can dual date the report or even issue a revised version. Issue a revised version of the audit report. That is the second scenario. The third scenario is after the report is issued. After issue of the report. After the report is issued, what will be the auditor's action? Now, if the event is serious, for example, fraud discovery, the auditor may need to notify the board and the regulators that the report can no longer be relied upon. Notify the board. Here you notify the board of directors and the regulators that the report cannot be relied upon. Here you notify the board and the regulators that the report cannot be relied upon. You can see here, candidates, when the report has already been issued, you cannot revise it, you cannot incorporate the findings. So what you do, you notify the regulators and the board the report cannot be relied upon. Understand? So as we are closing, candidates, it's important for you to understand that the management has a continuous disclosure obligation in regards to these subsequent events. The management has an obligation to report on any subsequent event to the auditor. And failure to do so is often considered management override of control and can lead to a legal liabilities for the directors. So that's the end of our today's lesson on the nature and scope of subsequent events, which we have described as significant events that occur between end of the audit period and the date the audit report is issued. And we say there are two categories of subsequent events: the adjusting events, which are events that existed at the year end. Then there is the non-adjusting events, which are new conditions. Then we also went ahead to discuss the scope of review. These are the procedures that the auditor is required to carry out in order to discover or establish if there are any subsequent events. One is inquiry of management. You review the minutes, you check regulatory environment, then you can do market intelligence and you read what is happening in media in regards to the company. Thank you. God bless you. Bye-bye.
Hi candidates, welcome to another session of Manifested Online Classes. In this session, I want us to look on an illustration question regarding how to prepare the group accounts, whereby we have a disposal of interest. And the illustration I want us to go through reads, Pareto Limited is a holding company of a listed group of companies with its year ended on 30th of June 2021. So Pareto Limited has made a number of acquisition and a disposal of investment. So the following summarized draft statement of financial position relate to the group companies for the year which ended 30th of June 2021. So we are given the statement of financial position for three companies: Pareto, Paba, and also Dafu Limited. Non-current assets include property, plant, and equipment. Then we have investment in Paba, investment in Dafu. We have financial assets, and then we have the current assets. We have the total assets. At the equity, we have ordinary share capital, share premium, retained earnings, and then we have non-current liabilities and current liabilities. Then we have some additional information. Number one, where we are told on 1st of October 2020, Pareto Limited acquired an 80% equity interest in Paba Limited when it retained earnings stood at 3,500 million. The purchase consideration comprised of 1,250 million of Pareto Limited shares with a nominal value of shillings 1 each and a market price of 6.8 each. At the acquisition of Paba Limited, the only adjustment required for to the identifiable net asset of Paba was for land which had a carrying amount of 625 million, less than its fair value. So number two, we are told the group policy is to measure non-controlling interest at fair value. That information definitely is to guide you how to compute the goodwill. If you come across that information that the group policy is to measure NCI at fair value, it means that when computing the goodwill, we then compute that goodwill using the full goodwill method. And then you're told at the date of acquisition of Paba Limited, the non-controlling interest had a fair value of 21.25 million. Number three, Pareto Limited had acquired 100% equity interest in Dafu a number of years ago when it retained earnings amounted to 1750 million. At acquisition, the fair value of identifiable net asset of Dafu approximated their carrying values. The purchase consideration comprised cash amounting to shillings 5750 million. Number four, you're told Pareto Limited disposed of 60% of its investment in Dafu on 1st of April 2021 for shillings 4,700 million, when the fair value of identifiable net asset of Dafu were shillings 6250 million. The fair value of the remaining 40% equity interest was 4,300 million at disposal. Pareto Limited has not accounted for the disposal. And then number five, we are told none of the companies had issued any shares since Pareto Limited acquired its shareholding in them. And number six, we are told neither the goodwill on acquisition of subsidiaries nor investment in associate, that is, had been impaired. So from that information, what you're required to do, number one, is we compute the goodwill arising on acquisition of the investment in the subsidiaries. Number two, to compute the gain or loss arising on disposal of the investment in Dafu as reported, Roman 1, the individual financial statements of Pareto element 2, consolidated statement of profit or loss. And finally, part C of that question, we are required to prepare the consolidated statement of financial position as at 30th of June 2021. So these are questions for group account, and as usual, what we need to do first of all is to come up with a group structure. Then we go through the additional information, we see whether there are workings which we need to do, and then from there we prepare, or basically we compute what is required. So therefore, let's first of all we come up with the group structure here, which will be working 1, a group structure. A group structure. So where do we get that particular information about the group structure? So that information, we have it from the additional information number 1, whereby we are told on 1st of October 2020, Pareto Limited acquired 80% equity interest in the company which is called PABA Limited on 1st of October 2020. 1st of October 2020, and also we are given the retained earnings of PABA on that date. That one will be used in the computation of goodwill, including the purchase consideration. That one will be used in the computation of goodwill. But let first of all we go to the additional information number 3, whereby we are told PABA Limited, not PABA but rather Pareto Limited had acquired 100% equity interest, 100% equity interest in the company which is called Dafu Limited a number of years ago. So in this case, we are not given the specific date of acquisition, but we are told Pareto Limited had acquired 100% shareholding in Dafu sometime back, or basically a number of years ago. So basically what that means is that from this group structure here, Pareto Limited, this will be the parent company, and automatically the parent company is the one which is supposed to prepare the group account. Then PABA is a subsidiary, and also Dafu here is a fully owned subsidiary, a fully owned. Fully owned means that the parent company acquired all the shares or hold all the shares in that particular subsidiary. So we have that information, but also before we go maybe back to note number 1, there is another information which is given and which is very, very important in note number 4, sorry, where we are told Pareto Limited disposed of 60% of its investment in Dafu on 1st of April 2021. So that is information about disposal of interest. Disposal of interest. Disposal of interest, whereby we are told Pareto Limited disposed 60% shareholding in what? In Dafu. So we have disposal of interest in Dafu Limited. Dafu Limited. So, and automatically this particular disposal of interest, this usually take place during the current financial year. During the current financial year. Now, first of all, if we go to the information we have at the paragraph 3 up there, so the current financial year was all ended on 31st of or that is June 2021. So basically what that means is that this year started on 1st of July 2020. But now if we go back to the information we have in note number 4, we are told Pareto Limited disposed 60% of its investment in Dafu during the current year. So that is the 1st of April 2021. 1st of April 2021. So how many months do we have here to the date of consolidation? We have April, May, June. So here we have 3 months, and automatically here we have what? 9 months. So what that means is that for the first 6 months, this particular company here, that is Dafu, this was a subsidiary, because you can see in the first 9 months, the parent company had 100% shareholding. But on this date, we are told the parent company disposed 60%. of its shareholding in Darfur. So that what that means is that the parent company retained 40% shareholding in Darfur, and therefore Darfur in the last 3 months was an associate. And therefore, if for example in this particular question here the examiner was requiring the candidate to prepare the consolidated income statement, it's very, very important to note that this company here, that is Darfur, for the first 9 months you treat it as a subsidiary, meaning that you take into account its revenue and expenses for the first 9 months, for the first 9 months, and then you add that to the revenue and expenses of the parent and the revenue and expenses of what? Of PABA. But in the last 3 months, that is, Darfur Limited will be an associate, and therefore what you need to include in the consolidated income statement is the parent company share of Darfur Limited profit after tax in the last 3 months. And also in this case, because the parent company lost the control, you have to determine the gain or loss on disposal, which then you recognize in the income statement as part of the profit or loss. But in our case, if you check on what the examiner was requiring here, specifically in part C, we are only required to prepare the consolidated statement of profit, the consolidated statement of financial position. So what that means is that in preparing that, we check the status, we determine the status of Darfur at the end of the year. Darfur Limited at the end of the year will be an associate, and therefore in preparing the consolidated statement of financial position, we are going to add similar items of asset and liabilities, those of Pareto, the parent, and those of PABA, but we are not going to take into account the asset and liabilities of Darfur because it's an associate. So what we are going to do is we are going to determine something called the investment in associate, and basically that is the only item we are going to include in the consolidated statement of financial position as far as Darfur Limited is concerned. Yes, that is why the group structure here is important. But before you do that, maybe you can just go through this additional information again. We see whether there are some workings which are required. Note number 1, we go back to note number 1. We are given information about the acquisition of PABA, and actually the retained earnings, the purchase consideration, all that will be used in the computation of goodwill, which you are required to compute as per part 1 of that question. And also we are told that at the date of acquisition, PABA Limited, or at the acquisition of PABA, the only adjustment required to the identifiable net asset of PABA was a LAD with a carrying value of 625 million less than the fair value. So basically what that means is that this company on the date of acquisition devalued the asset, and remember that process we refer to it as the fair value adjustment or the fair value exercise. So this is by PABA Limited, and the asset it revalued was LAD, and we are told that this LAD had a carrying amount of its carrying amount was 625 million less than the fair value. So in this case, the carrying amount was less than the fair value with an amount of 625 million. In other terms, we can say that the fair value, we start with the fair value, was greater or was more than the carrying amount with 625. So automatically, what is this? This is the revaluation gain. And this particular revaluation gain, which occurred on the date of acquisition, automatically was not accounted for by PABA. So therefore, in preparing the consolidated statement of financial position, this one we add it to the group PP, and number 2, this one we treat it as a pre-acquisition revaluation reserve, pre-acquisition revaluation reserve. In computing the goodwill on acquisition, that will be one of the component of the net worth asset of PABA Limited. So I think we have that particular information there. And then it is also important to note that this particular asset here, that is LAD, this is not a depreciable asset. LAD is not depreciated, and therefore in this case, no depreciation other charge. No depreciation other charge to be computed here, simply because LAD is not depreciable asset. But if this was a depreciable asset, we needed to compute the depreciation other charge. So let's move to, but we will still come back to that particular point, specifically in answering part A of that question when computing the goodwill. So in number 2 is about information regarding the computation of goodwill. We will still use that in answering part A. And then part additional information number 3, we are given information about the acquisition of Pareto, where we are told the parent company, that is the acquisition of Dafu, whereby we are told Pareto Limited had acquired 100% shareholding in Dafu some time back. We are given it retained earnings there, and also the fair value of identifiable assets, which we are told equaled to the year carrying amount. So mean that at the date of acquisition, this company revalued the asset, and the fair value of identifiable asset was equal to carrying amount. There was no revaluation gain or loss. And then you're given the purchase consideration, which was 5750. All that information, we're going to use it in answering part A, specifically in computing the goodwill. And then we're given information number 4 about the disposal of some disposal of interest in Dafu. And also this one, we're going to use it in answering part B of that particular question. And then we have note 5. Note 6. I think no working which is required here. So I think we can go straight to part A of that particular question. Part A of the question. So what you are required to do is to compute the goodwill arising on acquisition of investment in subsidiaries. Investment in subsidiaries. So we start by computing the goodwill arising on acquisition of the first subsidiary here, that is Paba. So let's start by computing the goodwill arising on acquisition of investment in Paba Limited. Equally, remember, as per the information which are given in note number 2, we are computing the goodwill using the full goodwill method. That's the first thing you need to appreciate, or basically to note. So how do we compute the goodwill using the full goodwill method? Number 1, we take the cost of investment. So how much purchase consideration was paid by the parent company in acquiring the shares of Paba? So that information, we have it in the balance sheet or in the statement of financial position of Pareto, specifically at the non-current asset. We are given the amount of the amount invested by Pareto in Paba, which is 8,500. So to this, then we add the NCI at fair value, because you're using the full goodwill method. So this figure is also given in note number 2. Additional information number 2, the last sentence, we are told at the date of acquisition of Paba, the non-controlling interest had a fair value of 21.25. So we add the 2. So this will give us 25, 10, 6, 10, 6. So let's confirm whether that is correct. So we have 85 plus 21.25. So which will give us 10,625. That is correct. So then from there we proceed and we less fair value of net assets. Fair value of net assets acquired. So how do we compute this one? Because it's not given. So we have to determine the fair value of a net asset of Paba on the date it was acquired. And we determine that by taking the ordinary share capital of Paba plus pre-acquisition reserves. So therefore, where do we get this? Let's go back to the statement of financial position of Paba, specifically at the equity. So at the equity, number 1, we are given the ordinary share capital of Paba. The ordinary share capital of Paba is a figure of 25. Still, in that case, we also have a share premium. Share premium of a subsidiary company, unless told otherwise, is always taken to be a pre-acquisition Then the retained earnings which we have there of 5250, that is at the end of the current year, that is not what we're interested with. We're interested with the retained earnings of PABA on the date it was acquired. And that is now what we refer as the pre-acquisition retained earnings. So that one is given in the addition information number 1, whereby we are told when PABA Limited was acquired, its retained earnings stood at 35. And then to this, other than taking now the items in the statement of financial position specifically under equity, you also have to check whether this company revalued its asset on the date of acquisition. In case it revalued its asset, was there a revaluation gain or loss? So like in our case, remember here, PABA Limited revalued land with an amount of what? 625. This one we have said is a pre-acquisition revaluation reserve. A pre-acquisition revaluation reserve, which is 625. Yes, I think that's what we have. And basically what we need to do here, we get now the total. So we have 25 plus 1,000 plus 35 plus 625. So this will give us 7625. And because we are using the full goodwill method, we take 100% of this. 100% of this will be 62, that is 7625. We less it from the figure up there. We less it from 10,625, which will give us goodwill on acquisition of what? Over 3,000. So that is the goodwill on acquisition. And remember that is a full goodwill. Basically the goodwill determined using the full goodwill what? The full goodwill method. So basically that is what is required there. And basically the items which are marked in such a case are those items which we have there. Then we need to proceed and compute the goodwill on acquisition of the other subsidiary, that is the full goodwill on acquisition of goodwill on acquisition of Darfur Limited. Darfur Limited. So we need to have two columns here. And even before you compute now the goodwill on acquisition of Darfur, it is very, very important for you to note that in Darfur, there is no NCI here. There is no NCI because you can see that the parent company acquired all the shares, acquired 100% of the shares issued by what? By Darfur. So therefore, in Darfur, we don't have what? NCI. And that's why you can see, despite the group using the partial goodwill method, the full goodwill method in computation of goodwill, we are not given the NCI at fair value in Darfur, simply because there is no NCI. So therefore, what we do here, we take the cost of investment, the purchase consideration paid by the parent company, that is Pareto in acquiring shares of Darfur. That one is given in the statement of financial position of Pareto under the non-current asset, which is 750. And then in this case, we should add the NCI at fair value, which you are saying is 0 because we don't have NCI. We don't have NCI. We get 5750, and then to this we proceed with less fair value of net assets acquired. Equally, to compute this, we take the ordinary share capital of Darfur plus pre-acquisition reserves plus the reserves it was having on the date it was acquired. So where do we get that? Let's first of all we go to the statement of financial position of Darfur, specifically at the equity section. So the ordinary share capital of Darfur, is 2,000. Also Darfur had a share premium of 500. of 500. And then the retained earnings in the statement of financial position of Darfur 5750 is at the end of the current year, but that is not what we're interested with. We're interested with the retained earnings of Darfur on the date it was acquired, and that is given in the additional information number 3. Pareto Limited acquired 100% equity interest in Darfur a number of years ago when it retained earnings. It retained earnings stood at 1750. And also you check whether Darfur Limited revalued its assets. So basically, as per the information which are given in note number 3, this company revalued its asset, but you're told their fair value was the same with the carrying amount. There was no revaluation gain or loss. So what we do, we get the total here, and then we less that from the figure we have down there. So we have 2000, which will give us 2500 plus 1750. So which will give us 4250, and then we take 100% of this. 4250, we less it from this figure minus 5750, 5750, which now will give us a goodwill of that, which will give us goodwill of 1500. So basically that also what was required there, and automatically the items to be marked there include what we have there, that, and that. And basically by computing the goodwill on acquisition of the 2 subsidiaries, the marks allocated there were 4. So let's move to part B of that particular question. Part B, we are required to compute the gain or the loss on disposal of investment in Darfur, Limited, Roman 1, as it was reported in the individual financial statement of Pareto, as it was reported in the individual financial statement of Pareto. Now, in this case, when Pareto Limited basically invests, or the parent company invests in a subsidiary, to the parent company, that investment in a subsidiary is like an asset. And therefore, once the parent company sells some of the shares, or basically all the shares in a subsidiary, the parent company in its individual financial statement, not in the group account, in its individual financial statement, it will need to recognize the gain or the loss on disposal. Now, that gain or loss on disposal is computed by taking the sales proceeds. The sales proceeds is basically the amount of money which was received by the parent company after selling some of the shares or all the shares in the subsidiary, minus the carrying amount of investment disposed. Or basically investment sold. And this one is very simple because all these figures are given. So let's go to the additional information number 4, and you're told Pareto Limited disposed 60% investment in Darfur on 1st of April 2021 for 4,700. So that 4,700 is the sales proceeds, the amount of money received. Yes, and then to this, what we know is that the amount of money which Pareto Limited had invested in Darfur is 5750, which is given in the balance sheet of Pareto. The amount invested in Darfur was 5750. In the statement of financial position of Pareto and current asset, the amount invested in Darfur 5750. But in our case, we know the parent company only disposed 60% of that. So that is the carrying amount of the investment sold. So that's how we compute the gain or loss to be recognized in the individual financial statement of Pareto. So this will give us what? 60%, 5750. We less that from 4700. So this will give us 1200. And basically that is a gain. That is what? That is a gain. that is a gain. So basically by doing that, the candidates here were allocated how many marks? Were allocated 2 marks, 2 marks, 2 marks for computing that. You can see that was quite straightforward. Also in part B, we are required to compute the gain or loss to be or as it will appear in the group account, as it will appear in the consolidated statement of profit or loss. So this is now the gain or loss to be recognized in the group account. So this is something we discussed in our previous session, how to compute the gain or loss arising from disposal of interest. So in terms of how we compute this, we take a number of figures here. Number one, we take the fair value of consideration which was received. How much amount did the parent company receive after selling the 60% stake or interest in Darfur? So that figure, we already have it in note number, addition information number 4, and which was 47. And then to this, we add the fair value of investment retained. Fair value of investment which was retained. Still, we have that in note number 4 as a figure of 4,300. The fair value of the 40% equity interest which was retained was 43. After adding those two figures, we proceed and we less two items. Number one, we less the parent company unimpaired goodwill. Parent company unimpaired goodwill, and that is something we have already computed here. The goodwill arising on acquisition of Darfur, this figure here. And we also have to note that this particular goodwill here, despite computing it using the full goodwill method, this is a goodwill attributable to the parent company, because in this Darfur we don't have NCI, because generally here what we take into account is the parent company goodwill which is not yet impaired. So this goodwill was not impaired as per the information given in note number 6, and the full amount is the goodwill attributable to the parent company. So that is what we less here. And then we also less the fair value of net assets at date of disposal. At date of disposal. So what was the fair value of Darfur Limited net asset on the date of disposal? That information, we also have it in note number 4. We are told on 1st of April 2021, the fair value of identifiable net asset of Darfur was 6250. Was 6250. So that's how we determine the gain or loss on disposal to appear in the consolidated, or to be recognized in the consolidated statement of profit or loss. So we have 47 plus 4700 plus 4300 minus 15 minus 6250. Is that will give us 1250, which is a positive figure, and that is a gain on disposal. The gain on disposal. The gain on disposal. And actually, that what was required in that part there, and basically by doing this, the marks allocated there were 2. So these are the items automatically which were marked. So let's move to part C of that particular question, whereby we are required to prepare now the consolidated statement of financial position, which you have said is simple, because what we need to do is to appreciate the fact that this will be a subsidiary at the end of the year, and then Darfur Limited at the end of the year, it will be an associate. It will be an associate. So therefore, in preparing a consolidated statement of financial position, we combine similar items of asset and liabilities, those of the parent and those of the subsidiary. And then for Darfur, we just compute something called the investment in what? In associate. So therefore, let's do that. Part C. So the name of the group here will be is a Pareto group. This is a consolidated statement of financial position as at 30th of June 2021. 30th of June 2021. So here we just need to have a single column, and our figures are in thousand of shillings, in million of shillings. So we start with the non-current assets. So first of all, we have the PP. So of PP, we are taking the PP of the parent, recall that, of the parent, that of PABA. We are not including those of DAFU. DAFU is an associate. We don't consolidate asset and liabilities of an associate with those of the parent. What we include here, as far as the associate is concerned, is something called the investment in associate. So therefore, we are only adding the PP of Pareto and those of PABA. We have 14,900 plus 9250, and then we check whether we have any consolidation adjustment affecting the PP. Do we have any consolidation adjustment? Yes, this one. On the date of acquisition, PABA Limited revalued its asset upward with an amount of 625, which was not accounted for. So we add that here, 625. So remember, we don't have any depreciation other charge, which would have been deducted there. So then below the PP, we'd have investment in PABA, investment in DAFU. So those investment, we don't include them here, but as far as PABA Limited is concerned, which will be a subsidiary at the end of the year, we include its goodwill here. So the goodwill on acquisition of PABA is 3,000. And then for DAFU at the end of the year, remember, it will be an associate. So what we include here as far as the associate is concerned is investment in associate or investment in DAFU Limited. So in our previous session, we looked on how to compute this, and actually we said to compute investment in associate, we take the investment, that is, we take the fair value of the investment which has been retained. So which is what you are given here, 43. And then to this, what we add is the group share of the post-acquisition net asset in that DAFU. So how do we get the group share or the parent company share of the post-acquisition net asset in DAFU? So what we do is that we take the net asset of DAFU at the end of the year, and basically by now we know that the net asset of a subsidiary is always equal to equity, share capital and reserves. So what is the equity of DAFU at the end of the year from its statement of financial position? You can either take the asset minus liabilities, or you just take equity. The total equity of DAFU, which is the same with the net assets, is 8250. This is the net asset of DAFU at the end. But now the date DAFU Limited became a subsidiary, became an associate, sorry, its net asset, you have to recall in note number 4, we were given as a figure of 6250. So therefore, whatever the difference here is the post-acquisition net assets. So we get the parent company share of this, which will be 40%. Which will be 40%. So this will give us a difference of 2,000, 40% of 2,000, 40% of 2,000. This one is 800. We add it to this, which will give us 5,100. So that is now the investment in what? Investment in DAFU, which you are saying will be included here as an item of non-current asset. Okay, so then below that we also have the financial assets. Financial asset, no adjustment for this. We just take the financial asset of the parent, 31, plus those of the subsidiary, 28. This will give us 59. And then from there we have the current asset. Actually, for current asset, we are given the total, 3850 plus 4425. Do we have any adjustment to the current asset? We check for things for like intercompany debts. We don't have things like unreleased profit. We don't have. So means that no adjustment for this. So what we just need to do, we get the final figure. We get the final figure. We have 3850 plus 4425, which will give us 8275. We get the total assets. The total assets. So let's first of all we compute the figure for PP there. we have 14,900. There is something we have forgotten here before we add here. So this particular purchase consideration which was received, that is a figure for 47. This amount was not yet accounted for. So therefore is amount receivable. It was not yet paid. So we also included as part of the current asset. We also included as part of the current what? Asset before we get the final figure there for PP. So let's add 4782. 75, 8275 plus the purchase consideration received, this one, which will give us 12,975. Okay, so we get the final figure for PP. We have 49 plus 9250 plus 625, which will give us 24, that is 24,775. Yes, and then we can add all these figures now, plus 3,000 plus 51 plus 59 plus 12,975. So that will give us a total of 51,750. So these are total assets. So we proceed, record equity. So for equity, we record the ordinary share capital, that of the parent company only, which is the 10,000. The share premium for the parent company only, 5,000. Then from there, we will compute the group retained earnings. This one we computed as the last item. And then we will get the total equity. We proceed and compute the non-controlling interest. And the non-controlling interest here will only be computed as far as or in relation to, or we are going to compute this for PABA. PABA is the one which was a subsidiary. Remember, DAFU is an associate. So then from there we have non-current liabilities. So for non-current liabilities, we are given the total. So we have 85 for the parent, and that for PABA, no adjustment here. So we get a total of 14,500. And then we have the current liabilities. Current liabilities, we have 47,75 plus what? Plus 17,25. We don't have any adjustment there. We get total equity and liabilities. Total equity and liabilities. Total equity and liabilities. So let first of all we add these particular figures here. For current liabilities, we have 47,75 plus 17,25, which will give us 65. And then for the non-controlling interest, this one we can compute it directly because the group policy here is to measure NCI at fair value. So when that is the case, then the computation of NCI is quite simple, because what we do, we take the NCI at fair value on the date of acquisition, which is 21/25, plus now the group share of what? The group share of post-acquisition adjusted retained earnings. So the retained earnings of PABA Limited after it was acquired, how do we get that? We take its retained earnings at the end of the year. The retained earnings of PABA at the end of the year in the statement of financial position is 50.
Greetings and a warm welcome to the Manifested e-learning platform. Today we continue with the subject governance and compliance audit. We are going to study the nature and purpose of governance audit. And therefore, by the end of the lesson, you should be able to explain the nature and purpose of governance audit. And as we defined in our earlier sessions, a governance audit is a specialized and independent assessment of an organization's governance framework, structures, processes, and practices. And it goes beyond the traditional financial audits to evaluate how an organization is directed, controlled, and held accountable. So we will study two things, nature and purpose of governance audits. Let's begin with the nature. What is the nature of governance audit? What is the nature of governance audit? To understand the nature of governance audit, we need to highlight the characteristics of governance audit. It is the characteristics that will bring out the nature of governance audit. One is holistic or view, holistic perspective. Unlike financial audits that focus primarily on financial statements, a governance audit takes a comprehensive view of the entire organization. It examines the interrelationships between various components of the governance system, including the board, the management, and internal control, as well as risk management and stakeholder relations. So governance audit looks or considers the entire aspect of an organization, beginning from the board of how the board runs its affairs, the board structures, the management, how the management is running the organization, the internal control system, the risk management, and all that. So it has a holistic perspective. Number two, principles. It focuses on principles. It assesses the organization's adherence to established principles of corporate governance, such as transparency, such as accountability, fairness, responsibility, integrity, and ethical conduct. These principles form the criteria against which the organization's governance practices are evaluated. It is on the basis of the principles that I have mentioned that the governance auditor assesses the organization to find out if the organization is being controlled and managed based on the corporate governance principles. So governance audits focus on principles, evaluative and advisory. Evaluative and advisory. A governance audit isn't just about identifying problems. It's also about providing recommendations for improvement. It evaluates the effectiveness of existing governance mechanisms and offers insights on how to enhance them. So it is evaluative and advisory. That is the third point. The fourth characteristic of governance audits is that governance audits are forward-looking. They are forward-looking. What does that mean? Now, while it examines current and past practices, a governance audit often has a forward-looking dimension, aiming to strengthen the organization's ability to achieve its strategic objectives and navigate future challenges effectively. So it is forward-looking. It is forward-looking. 5, and objective. Independent and objective. Now, to ensure credibility, Governance audits are ideally conducted by independent individuals or teams, whether internal or external, who can provide an unbiased assessment free from conflicts of interest. That's why most governance auditors are appointed by the shareholders and not management. By the fact that they are appointed by the shareholders, that makes them more independent because they do not report to management, but they report to the owners of the company. So candidates, these are 5 characteristics of governance audits. We can add 6 and methodical. They are systematic and methodical. It involves a structured approach, including planning, gathering evidence, analyzing findings, reporting conclusions, similar to other types of audits. So they are systematic and methodical. The 7th characteristic, dynamic and evolving. Evolve. They are dynamic. Governance frameworks are not static. The nature of governance audit acknowledges this and also considers the organization's adaptability to changes in the regulatory landscape, industry-based practices, stakeholder expectations, and so on. So these are 7 characteristics of governance audit. Let's move on to the purpose. What is the purpose of governance audits? Purpose. Of what importance are these governance audits? Now, the first purpose is to enhance accountability and transparency. Governance audits enhances accountability and transparency to verify that responsibilities are clearly defined and that individuals and groups are held accountable for their actions and decisions. Another point here is to ensure that the organization provides timely, accurate, and clear information to stakeholders, which fosters trust and confidence. That's the reason why governance audits are conducted, to enhance accountability and transparency. Number 2, board effectiveness. Governance audits are used to assess and improve board effectiveness because a governance audit, by its very nature, involves, among other things, assessing board effectiveness. Governance audits evaluate the composition, the structure, the diversity, and independence of board of directors. When a governance audit is conducted, one thing that happens is to assess board effectiveness by evaluating the composition of the board, the structure of the board, the diversity of the board is also assessed, and even the roles of the board. It's used to assess the board's roles, responsibilities, and decision-making processes. And the purpose is to ensure the board provides effective oversight of management, strategy, and also risk. The third purpose, why governance audits are conducted, is to strengthen risk management, to strengthen internal controls. To strengthen risk management and internal controls. That means to assess the adequacy and effectiveness of an organization's risk management framework, including risk identification, risk assessment, risk mitigation, and monitoring of risk. Governance audits also evaluate the robustness of internal controls designed to safeguard assets, to ensure data integrity, and also to promote operational efficiency. So governance audits can strengthen risk management and also internal controls. The fourth reason or purpose of governance audit is to promote ethical conduct. Ethical conduct and organizational culture. To promote ethical conduct and organizational culture. And that is possible through reviewing the organization's ethical framework, code of conduct, and mechanisms for addressing ethical dilemmas and misconduct. You understand? Yes. So governance audits can also be used to assess whether a strong ethical culture is embedded throughout the organization, from the board down to its employees. So that's what a governance auditor is required to do, is to evaluate or to assess whether there is in place an ethical culture that is embedded throughout the organization, right from the board of directors to the rest of the employees. Another purpose is to ensure compliance. To ensure compliance. This means to verify adherence to relevant laws, regulations, industry standards, and also internal policies. And while not a pure compliance audit, governance audits often identify compliance gaps that arise from governance weaknesses. Number 6, the sixth purpose is improve decision making. Governance audits can be used to improve decision making by providing objective insights into governance strengths and weaknesses. The audit helps the board and management make more informed and effective decisions. 7, confidence. Governance audits can enhance stakeholder confidence because a robust governance audit signals to investors, regulators, employees, customers, and public that the organization is committed to good governance, which can enhance its reputation and attract investment. That is point number 7. Now, point number 8 is to identify of improvement. Governance audits can identify areas of improvement by pinpointing specific areas where governance practices are weak, inefficient, or non-compliant, and also to provide actionable recommendations for improvement. Number 9, objectives. Governance audits can also support strategic objectives. That is to mean ensuring that that means that governance audits can be used to ensure that the governance framework effectively supports the achievement of the organization's strategic goals and long-term sustainability. So these are 9 purposes of governance audits. And that is the end of our today's lesson, where we've discussed the nature of governance audit. In discussing the nature, we highlighted the characteristics of governance audit. By discussing the characteristics, we understand the nature of governance audits, or the nature of anything. So candidates, if you are required to discuss the nature of anything, the easiest way is just to bring out the characteristic of that thing. In our today's lesson, it was about governance audit. So the first point is holistic perspective. It has a holistic perspective. Number two, governance audits focus on principles. These are principles of corporate governance. Number three, the governance audit are evaluative and advisory. Apart from just identifying problems, at the end of governance audits, the governance auditor can make recommendations on how to improve governance processes and also areas of weaknesses. Evaluative and advisory. Number three, or four, forward-looking. Another characteristic, independent and objective. They are independent and objective. Number six, they are systematic and methodical. Number seven, dynamic and evolving. They are dynamic and evolving. Dynamic and evolving. Then we've discussed the purposes of governance audit. The first purpose is to enhance accountability and transparency. Number two is to assess and improve board effectiveness. Number three is to strengthen risk management and internal controls. Number four is to promote ethical conduct and organizational culture. Number five is to enhance compliance. Number six, to improve decision making. Number seven, to enhance stakeholder confidence and trust. Number eight is to identify areas of improvement. And lastly, to support strategic objectives. So candidates, in essence, a governance audit serves as a critical tool for organizations to self-assess, learn, and continuously improve their foundational structures and processes, leading to better performance, reduced risks, and also increased stakeholder value. So that's all for today's lesson. In our next session, we are going to continue with the topic on governance and compliance audit. Bye. Greetings and welcome back to the meetings, compliance and administration lesson. Today we are going to study the subtopic complying with requirements of various meetings. Complying with requirements of various meetings. And candidates, complying with the requirements of various meetings, we know is a cornerstone of good corporate governance and legal validity. And in the context of companies in Kenya, compliance is mandatory. And this compliance is primarily governed by the Companies Act of 2015 and the company's own articles of association. So companies, candidates, are required to comply with the various laws and rules in relation to meetings. And this compliance, I'm saying, is governed by the Companies Act and the company's own articles of association. And failure to comply with these requirements can have serious consequences, including invalidation of the said meetings, invalidation of resolutions that are made in the meetings. It can have consequences like legal action, fines, and even reputational damage. So in this lesson, we are going to study, first of all, the general requirements for all company meetings. Then we will go ahead to analyze the specific requirements for different meetings. So we begin with the general requirements for all company meetings. What are the general requirements for all company meetings? General requirements. So one is a general requirements. General all right. Companies are required to comply with a certain laws or rules in relation to meetings. Now, there are fundamental principles that must be adhered to regardless of the meeting type. That's what we want to analyze here. But later on, we are going to analyze the specific requirements for different meetings, like the annual general meeting, the board meetings, the creditors meetings, extraordinary meetings, and so on. Because before we get to those different types of meetings, let's first of all analyze the general requirements for all meetings, regardless of the type. You understand? Now, the first requirement is proper notice. Proper notice. Proper notice. Before any meeting is held, before any company meeting is held, there ought to be a proper notice that is given out. This is the most critical requirement. A notice must be given to every person that is entitled to attend the meeting. And it must be in writing, right? Which can be in hard copy or electronic form. And it must specify the date. The notice must specify the date, the time, and the place of the meeting, as well as the general nature of the business that is to be transacted in that meeting. So the first general requirement for holding company meeting, regardless of the type of a meeting, there has to be a proper notice that is issued to those who are required to attend the meeting. That's number one. The second general requirement is proper authority. There has to be proper authority. Proper authority. What do we mean by proper authority? Now, the meeting must be convened by a person or a body with the legal authority to do so, as stipulated in the company's articles of association or in the Companies Act. Not anyone can convene a meeting. The laws are very clear on who can convene a meeting, be it an annual general meeting or a meeting of creditors or an extraordinary meeting. The Companies Act and the Articles of Association of the company stipulates clearly who is to convene such meetings. So that is the second general requirement of holding any company meeting. The third requirement is in relation to quorum. Quorum. Now, a valid meeting cannot proceed without a quorum. A quorum means the minimum number of members or directors that are required to attend or to be present during the meeting. And this number is typically specified in the company's articles of association. There are meetings that require a certain minimum number of members who are to attend such a meeting. So if the members are not present in that meeting, then that meeting cannot be held. That meeting cannot be held. And if a quorum is not present within the specified time after the schedule starts, then the meeting must be adjourned. The meeting has to be done what? The meeting has to be adjourned. That is the third general requirement. Now, the fourth general requirement is in relation to chairman or chairperson. The chairman or the chairperson. There has to be a designated person. There must be a person, a designated person. In other words, a designated person must chair the meeting to ensure it is considered an orderly and the meeting is held in an orderly and a fair manner. You understand? That's a requirement. A meeting must be chaired by a designated person. And this person ensures that the meeting is held in an orderly and fair manner. Chairman. 5 minutes. That's another requirement for holding a meeting. Minutes. There ought to be detailed minutes of the proceedings that must be kept, and these minutes, the minutes, okay? The business that is conducted in the meeting must be documented. Detailed minutes of the proceedings must be kept. And these minutes are a legal record of the meeting and must accurately reflect the decisions or resolutions that are made during the meeting. They should be signed by the chairman. These minutes must be signed by the chairman of the meeting or the chairman of the next meeting. Minutes. That is general requirement number 5. And these are the general requirements of holding meeting regardless of the type of meeting. So first of all, I said we are studying the general requirements. The first one being proper notice. Number 2, proper authority. Number 3, quorum. Number 4, chairman. Number 5, minutes. That is the first part of this lesson. Then number 2, we want to study the specific requirements for different meetings. Specific requirements for different meetings. Specific requirements for different meetings. There are different kind of meetings that a company can hold. One such meeting being the annual general meeting. Number 1, we have the annual general meeting. The annual general meeting. What are the requirements for annual general meetings? Annual general meeting or AGM. Now, an AGM is a formal meeting of the company's members that is held once a year. That's why you are referring to as annual general meeting. Companies are required by law to hold an annual general meeting. So, in studying the requirements of holding a general meeting, then we need to ask ourselves, who must hold an AGM? Who must hold an AGM, an annual general meeting? Now, every company, except for a single member company, every company must hold an annual general meeting each year. And we have even public companies that are required to hold their annual general meeting within 6 months of their financial year end. Understand? Private companies are not legally required to hold an AGM unless the articles of association say so. But public limited companies are required to hold an annual general meeting. Private companies are not required by law to do so. But if the articles of association states that there ought to be an annual general meeting, then such an annual general meeting must be conducted. So then number 2, we need to study the notice. Remember, we say that one requirement for holding any meeting, regardless of the type, is having a proper notice. Now, for a private company, the notice period must be at least 14 days or 21 days as per the Companies Act. But for the public companies, the notice period is at least 21 days. The company articles can specify a longer notice period, but the Act specifies that it has to be at least 21 days. So that is the requirement when it comes to notice of an annual general meeting. Then number 3, the third requirement when holding an annual general meeting is in relation to the business transacted. Business transacted. Business transacted. Now, an annual general meeting typically deals with routine matters, including approval of the company's annual financial statements and reports. Another routine matter could be declaration of dividends. It could be the appointment of the directors or appointment of auditors or appointment and fixing the remuneration of auditors. These are routine matters that are transacted during annual general meeting. So the law is also clear on what businesses or what business ought to be carried out or conducted during the annual general meeting. So that's the third requirement in relation to the meeting we are referring to as the annual general meeting, the A. Then number 4, we can study the procedures. The procedures. Now, to comply, the company must ensure all required documents are circulated to members along with the notice. Now, to carry out candidates an annual general meeting, there are procedures that have to be followed. For example, is ensuring that those who are to attend the meeting have access to the required documents like the annual report, like the financial statement, that ought to be circulated to members along with the notice. Along with the notice. So these are the requirements of an annual general meeting. Let's now analyze the requirements of the extraordinary meeting. Extraordinary meetings. This is another type of meeting that can be held by a company. Now, an extraordinary meeting is a meeting of members convened to discuss special or urgent business that cannot wait until the annual general meeting. That's why it's called extraordinary. So the question we need to ask ourselves is, who must hold or who can convene such a meeting? The first requirement, who can convene such a meeting? One, who can convene an extraordinary meeting. Now, the directors can convene an extraordinary meeting whenever they deem it fit. You understand? The directors can convene an extraordinary meeting. But members also have a right to requisition such a meeting. Number two, members' right to convene. The shareholders, apart from the directors, the shareholders may also have a right to do so. The Companies Act gives members a right to convene an extraordinary general meeting. You understand? Members holding a certain percentage of the company's voting shares can compel the directors to convene or to call a meeting. And if the directors fail to do so within a specified time frame, and this time frame is 21 days, then the members can call the meeting themselves at the company's expense. So directors can convene this meeting. The members can also convene the meeting. We are calling the extraordinary meeting. Understand? Yes. Then let's discuss the notice in relation to extraordinary meeting. Notice. Now, the notice period for an extraordinary meeting is generally 14 days. So the notice here is 14 days. 14 days. Then what of the business that is to be transacted? Business transacted? Business. What business is transacted during an extraordinary meeting? Now, an extraordinary meeting deals with specific non-routine matters such as altering the company's articles of association, approving major transactions, or removing a director, and so on. These are non-routine matters, as opposed to the annual general meeting that deals with the routine matters like the appointment of directors, auditors, and so on. So that is a business that may be transacted during extraordinary meeting. Understand? And it is important to note that a resolution that is passed at an extraordinary meeting is often a special resolution. If resolutions are passed at an extraordinary meeting, it is usually a special resolution. Special resolutions are issued at an extraordinary meeting, okay, which requires a 75% majority of the votes that are cast. And the notice must clearly state that a special resolution will be proposed at the extraordinary meeting. So that's all we can say about extraordinary meetings. This is the second type of meeting. The first type is the annual general meeting. Candidates, we are studying the special or specific requirements for different types of meetings. The first one is the annual general meeting. The second one is the extraordinary meeting. The fourth one is the board meetings. Board meetings. Now, board meetings are meetings of the company's directors to discuss and make decisions regarding the company's management. So what is the frequency of this meeting? So the first requirement is in relation to frequency. How frequent are these meetings held? Now, the company's articles usually specify how often board meetings should be held. So it could be 2 times in a year, 3 times. It depends with the articles of association of the company. What of the notice? Notice. Now, are there notices that are required? Yes. The company's articles of association typically also sets the notice period for board meetings, which can be much shorter and less formal than for general meetings. Then number 3, we have quorum. Are there any requirements in relation to quorum of board meetings? Yes. The quorum for a board meeting is usually specified in the articles of association of the company. The article of association of the company will specify the quorum that is required for board meetings to be held. Then lastly, we have minutes. Minutes. Now, the Companies Act requires that minutes of all proceedings at board meetings are recorded and kept at least 7 years, for at least 7 years. The minutes must be kept for at least 7 years. And these minutes are a key legal document and can be used as evidence of the board's decisions. You understand? Yes. Then lastly, we have the director's duties. What are the director's duties in relation to these meetings? Director's duties. Director's duties. Director's duties. Now, at all times, directors must comply with their fiduciary and statutory duties to act in the best interest of the company. So when dealing with board meetings, there is a requirement that the directors have to be loyal. The directors are required by law to comply with their fiduciary duties and statutory duties, and these duties require that these directors act in the best interest of the company. And their deliberations and decisions at board meetings must reflect these duties. They must reflect fiduciary and statutory duties. You understand? Yes. So this is the meeting we are referring to as board meetings. Then lastly, let us analyze creditors meetings. Creditors meetings. Creditors meetings. This is a meeting of creditors. Creditors meetings. Apart from the board members, apart from the shareholders, the auditors may also convene a meeting. And these are meetings that are held during the company's liquidation, administration, or restructuring. When the company is restructuring, when the company is facing liquidation, then the company may have to conduct what we are calling the creditors meeting. So what is the purpose of this meeting? One, purpose. What is the purpose of creditors meetings? Now, the purpose of conducting a creditors meeting by a company is to inform creditors of the company's financial status. It may also be to approve the scheme of restructuring or arrangement, or to appoint a liquidator. When a liquidator is to be appointed, then the creditors must be involved, and they can only be involved when a creditors meeting is called. So I've identified for candidates the purposes of a creditors meeting. Number one is to inform creditors of the company's financial status. The second purpose is that the meeting can be held when approving a scheme of arrangement by the company, or number three, when the company seeks to appoint a liquidator. So these are part of the requirements we are discussing. You understand? Yes. Then let's analyze the legal basis. What is the legal basis of holding a creditors meeting? Now, the process for creditors meeting is governed by the Insolvency Act of 2015. So that is a requirement. When conducting a creditors meeting, then the meeting has to be conducted in line with the Insolvency Act of 2015. Compliance. The administrator or the liquidator must comply with the strict procedures and timelines that are outlined in the Insolvency Act, including sending notices to all non-creditors, including preparing statements of affairs, and also conducting the meeting in a manner that allows for a fair vote. So these are the requirements for holding a creditors meetings. And that's the end, candidates, for today's lesson on complying with the requirements. Complying with the requirements of various meetings. And at the beginning, we did state that complying with the various requirements of various meetings is the cornerstone of good corporate governance. We did also state that failure to comply with these requirements can have serious consequences, including invalidation of resolutions that are made during the meetings, including legal action and also fines and reputational damage. We've gone further in this lesson to analyze the general requirements that companies are required to comply with, regardless of the type. There are fundamental principles that companies must adhere to, regardless of the meeting type. And one such is proper notice, proper authority, quorum, chairman, minutes. Then we've analyzed the requirements for specific meetings. The first meeting type is annual general meeting. We've studied the requirements of extraordinary meetings. Then number three is board meetings. Then lastly, we have the creditors meetings. Creditors meeting, the requirements for creditors meetings. Now, in closing, we can state that compliance with the meeting requirements is a detailed process that requires strict understanding of the Companies Act, the Insolvency Act, the Articles of Association, and the various laws that pertain to meetings. And that requires the company secretary to be quite skilled. A skilled company secretary here becomes an invaluable asset in ensuring that these requirements are met, which then protect the company from legal and financial risks. So that's why we are studying the subtopic on complying with the requirements of various meetings. So as a company secretary, you need to understand what are the requirements of various company meetings, which include the annual general meeting, what are the requirements for the extraordinary meeting, what are the requirements for the board meetings, what are the requirements for the creditors meetings. And that's the end of today's lesson on complying with the requirements of various meetings. Bye-bye. Bye. Greetings and welcome back to the lesson. The subject is meetings. Today we are going to cover three things, that is convention of meetings, constitution of meetings, and conduct of meetings. Convention, constitution, and conduct. And in the context of companies and in the context of corporate governance, the term convention, constitution, and conduct of meetings are distinct but interconnected. They form the three pillars that govern how a meeting is planned, executed, and validated. So we will begin with the convention of meetings. Convention of meetings. Number one, convention of meetings. Now, in the context of corporate governance, what do we mean by convention of meetings? Now, convention of meetings or convention refers to the established norms, customs, or unwritten rules that are commonly followed during meetings. These are established norms, the way things are done, from the word normal, okay, or customs, and unwritten rules on how meetings are conducted. These are not legal requirements, but they are considered best practices that constitute or contribute to effective and fair, or they contribute to professionalism. They are practices that contribute to efficiency, fairness, and professionalism. They are not legal requirements. No, they are just unwritten rules. These are customs, established norms that constitute or that contribute to professionalism in terms of meetings. And the purpose of conventions, the purpose of convention of meetings is to ensure meetings are productive and the participants are treated with respect, because these conventions streamline the process. They streamline the process as everyone knows what to expect because of convention. Now we give a few examples. What are examples of these conventions? Examples of conventions. Now, one example is punctuality. Punctuality, being punctual, starting and ending the meeting on time. If a meeting is to be carried out in one hour, then the company may have a custom or a norm or unwritten rule of just having that meeting completed within 1 hour. There's a specific time the meeting starts, there's a specific time the meeting ends. That is an example. Another example is chairmanship. Chairmanship. That means having a designated person to chair the meeting to guide the discussion and maintain order. Then we may have a scribe. This means having a person to take minutes and keep a record of the meeting. Another norm is time management. Time management could also be a custom. That means limiting the time for discussion on each agenda item. Each agenda item being allocated a specific amount of time. That is also a norm. All right. Respectful communication. Respectful communication. There could also be a convention where each person is allowed to speak without interruption and also addressing all comments through the chair. That is a convention. Pre-reading, you can go on and on. Pre-reading. Now, pre-reading means circulating all relevant documents in advance so that members can prepare for the meeting. It could be financial statements, it could be reports, And while breaking a convention may not invalidate a meeting, we've just given examples here, candidates of conventions: punctuality, chairmanship, taking a scribe, time management, respectful communication, pre-reading, means circulating documents to members before the meeting takes place. And we say that conventions are not legal requirements. That means they may be broken. In the event that they may be broken, the breaking of these conventions cannot invalidate a meeting, but it can only lead to inefficiency. Breaking norms can lead to frustration and even breakdown of trust among the members. But breaking norms cannot invalidate a meeting. So that's the meaning of convention of meetings. We've defined convention of meetings as established norms, customs, and unwritten rules that are commonly followed during a meeting. Let's move on to constitution of meeting. Constitution of meeting. Constitution of meetings. Now, the constitution of a meeting refers to the legal and structural requirements that must be met for the meeting to be considered valid and these decisions legally binding. These are the formal rules that are typically found in the company's governing documents and the relevant corporate laws. These are legal and structural requirements. Constitution of meeting refers to legal and structural requirements. Legal and structural requirements. And the purpose of constitution of meetings is to ensure that decisions made are legally sound, transparent, and binding on the company and its members. And the key elements of a meeting's constitution include, we can have elements. The elements of constitution of meetings would include proper authority. One, proper authority. Proper authority. The meeting must be called by the correct person or body as stipulated in the Articles of Association. For example, the board of directors or a specified number of shareholders. Not just anyone can call for a company meeting. The articles, the constitution of the company stipulates who has the power, authority to call a meeting. Then there is also proper notice. This is an element of constitution of a meeting. All members entitled to attend must receive adequate notice of the meeting, stating the date, stating the time, and the place of the meeting. And the notice period is often specified by law. It could be, say, 21 days notice. 21 days for an annual general meeting in Kenya, and it must be strictly adhered to. That is a legal requirement per notice. 3, quorum. Quorum refers to the minimum number of attendees required to be present for a meeting to be legally valid. And without a quorum, any decisions that are made are invalid. And the quorum is usually specified in the company's articles. Agenda number 4. This is an element of a constitution of a meeting. Agenda. Agenda is a clear list of the business to be transacted at the meeting. And business not on the agenda usually cannot be voted on in the meeting. 6. Voting. Now, decisions must be made through a formal voting process as specified by the company's constitution. For example, it could be a simple majority, a special resolution requiring a higher percentage, it could be a poll vote, and so on. So these are elements of constitution of a meeting. You understand? And it's important to note that failure to comply with the constitutional requirements can lead to the invalidation of resolutions and even legal action being taken against the company or its directors. It's not like the case of convention of meetings. We saw that convention of meetings, these conventions can be broken. But the breaking of these conventions do not constitute invalidation of the meeting. It only inconveniences the members, it brings frustration and so on. But where the elements of the constitution of a meeting are breached, failure to comply with the constitution requirements, that can lead to the invalidation of all the resolutions that are made at the meeting. For example, if there was no proper authority, if no proper notice was given, if the meeting was transacted where the quorum had not been attained, that can lead to invalidation of the resolutions and even legal action being taken against the company or its directors. So that is constitution of meetings. We are moving now to discuss conduct of meetings. Conduct of meetings. What do you mean by conduct of meetings? Now, conduct of meetings refers to the actual procedures and actions that take place during the meeting itself. Actual procedures and actions. These are actual procedures and actions that are taken during the meeting. Conduct. What takes place during? That's the meaning of conduct of meeting. And that begins from the moment the meeting is called to order until the meeting is adjourned. And this is where the principle of convention and constitution are applied in practice. The principles of convention and constitution are applied during the conduct of a meeting, right from when the meeting begins up to the meeting. From the moment the meeting is called to order until the meeting is adjourned, what takes place is actual procedures and actions, which you are referring to as conduct of a meeting. Now, what are the aspects or key aspects? What are the key aspects? What are the key aspects of conduct? Aspects of conduct of meeting. One is calling meeting to order. Calling the meeting to order is part of the conduct of a meeting. The chairman officially opens the meeting and confirms that a quorum is present. When the quorum is present, then the meeting is called to order. That is one action that takes place during the meeting. 2, reading and confirmation of minutes. After the meeting is called to order, then there could be reading and confirmation of minutes. The minutes of the previous meetings are read, they are reviewed for accuracy, and they are formally approved by the members. That is what takes place during the meeting. The third element of conduct of meetings is the chairman's role. The role of the chairman. Now, the chairman directs the meeting, manages the discussion, and ensures that the rules of the procedure are followed. They are the authority to maintain order, to rule on points of order, and put motions to vote. 4, proposing and seconding. This also takes place during the meeting. Proposing motions, seconding motions. A motion is a formal proposal for a decision. That's the meaning of a motion. And it must be proposed by one member and seconded by another before it can be debated or before it can be voted on. Proposing and seconding motions. Constitution of meetings. These are the legal and structural requirements. Legal and structural requirements that must be met for a meeting to be considered valid and for its decisions to be legally binding. Very important constitution of meetings. Before holding a meeting, the organizers must ensure that the meetings comply with the legal framework. And that would include proper authority. The meeting has to be called by the proper authority. There has to be proper notice. There has to be a quorum for the meeting. There has to be agenda for the meeting. And there's also voting. Failure to comply with the constitutional requirements can lead to the invalidation of resolutions and even legal action being taken against the company and its directors. Finally, we discuss the conduct of meetings, which we've defined as the actual procedures and actions that are taken during the meeting. There are 7 aspects we've singled out. One is calling meeting to an order. You would expect the chairman to call a meeting to an order. That is what actually takes place. Number 2, there is reading and confirmation of previous minutes. Number 3, there is the role of the chairman, proposing and seconding motions. Debate takes place during the meeting. There is voting and passing resolutions and adjournment. These are the 3 pillars that govern how a meeting is planned, executed, and validated. It is through conduct of meetings that the Constitution and Convention are made practical. Because the Constitution provides a legal framework, the Convention provides the best practice, and the conduct is the practical application of both the Convention of Meetings and the Constitution of Meetings. Thank you for your time. I will meet in our next session. We will continue to discuss issues related to meetings. Bye-bye. Hello and a warm welcome to the lesson, the platform manifested e-learning. Today we continue with the subject governance and compliance audit. The topic is peer review mechanism. We are continuing with the chapter. Today we are going to analyze the peer review mechanisms, stages. And candidates, the peer review mechanism for governance and compliance audits typically involves a structured multi-stage process to ensure thoroughness, objectivity, and adherence to professional standards. And while specific terminology and detailed steps might vary slightly depending on the administering body or the oversight body, like the Institute of Internal Auditors or the AICPA, while they may slightly be different, the core stages are generally consistent. Like we have the first stage, which is planning and engagement. Planning and engagement is always the first stage, regardless of the oversight body's standards. And just to remind you candidates, peer review, we had defined it as the objective, independent, and systematic evaluation of an audit firm's quality control system and its adherence to professional standards and ethical guidelines. Auditing firms are required to conduct their audit engagements in accordance with professional standards and certain regulations or regulatory framework. So there are times when the auditors are also subject to review by independent parties. We are calling the reviewers, peer reviewers. And peer reviewers are like the auditors of the auditor, auditing the auditors. It is briefly defined as auditing the auditors. So in this lesson, we discuss the stages, beginning with planning and engagement. Planning and engagement is the first stage. We are discussing stages in peer review mechanism. 1, planning. Let me say stage 1. Stage 1. The first stage is planning and engagement. Engagement and planning. Planning and engagement is the first stage, which may involve selection and appointment of reviewer. Selection of the reviewer. That's the first thing that happens. The firm or the internal audit function that is undergoing review, or the reviewed entity. The reviewed entity is the firm that is being reviewed, engages a qualified and independent reviewer or review team, and this selection might be from an approved list provided by the administering body. For internal audit functions, this often involves contracting with an external audit firm or an experienced internal auditor from a different and related organization. So it could just be an internal auditor from another organization or an independent external auditor. So it begins with selection and appointment of a reviewer. So the reviewed firm or entity formally engages and appoints a reviewer. That's step number one. Step number two is the initial communication and agreement. Initial and agreement. These parties must agree before the commencement. And here an engagement letter or memorandum of understanding is signed, formalizing the peer review. And this document outlines the scope and the objectives of the engagement or the review engagement or the engagement review. It also documents, this agreement documents the scope, the period to be covered by the review. It could be for the last 3 years of engagement, or it could be the last 1 year. So it depends. So they agree on the period. Then there is also agreement on the applicable professional standards. Which standards will be applied in carrying out the peer review? Is it the Institute of Internal Auditor standards, or which standards will be applied? There is also responsibilities of both the reviewer and the reviewed entity. The engagement must specify clearly the objectives of both parties, which candidates we discussed in our previous session. The responsibilities of the parties involved in peer review. We discussed some of the general objectives. That has to be part of this agreement. Responsibilities. There could also be the timeline and fees. The agreement must also be in relation to the fees. How much will the review firm pay the reviewer? There is also the kickoff meeting or the inception meeting, which may be held to introduce the teams, to discuss expectations, and also to clarify responsibilities and roles. That should be part of the agreement. That's the initial communication. After the reviewer is appointed, there ought to be an initial communication and agreement, which we explained in detail. Okay? Do you understand, candidates? We are discussing the peer review mechanism stages. Then the third stage is pre-review. We have a pre-review stage, pre-review information gathering. Pre-review information before the fieldwork. The reviewer or the reviewed entity typically completes a comprehensive questionnaire provided by the reviewer or by the administering entity. And this questionnaire covers information about the firm's functions or structure and also personnel, is quality control policies and procedures. There are also questions on listing of all governance and compliance audit engagements performed during the review period. It may also cover information on training, independence, confirmations, and also other relevant quality control documentation. The reviewed entity also provides this information to the reviewer for pre-fieldwork analysis. Pre-fieldwork analysis. Before the reviewer gets into the field, before the reviewer initially commences the review, that information must be provided, what we are calling pre-review information gathering, where the firm that is being reviewed provides information to the peer reviewer. That's step number 3, pre-review information gathering. Then we have planning, reviewers planning, reviewers 4th stage, reviewers planning. Now, based on the questionnaire and the initial discussions, the peer reviewer develops a detailed plan for the review, and this includes identifying key risk areas within the reviewed entity's quality control system. It may also include determining the sample of the governance and compliance audit engagements to be selected for detailed review, and so on. And here, the reviewer may conduct what we call planning interviews. Okay? Planning interviews. What does that mean? That means planning interviews with the key personnel of the reviewed entity, and also developing a timeline for fieldwork. Developing a timeline for the fieldwork is what comes out of the reviewer's planning stage. Okay? That's stage number 1. Then stage number 2, we have what we call fieldwork. Stage 2, fieldwork. That's the second stage. Because after being engaged and there is a engagement agreement, the reviewer gathers information from the firm that is being reviewed. Then planning is done. Then the next obvious stage is go to the fieldwork. And fieldwork may be on-site or remote review, or it could be done remotely. Remote review. The peer review team conducts its examination, which can be either on-site at the reviewed entity's premises or performed remotely through secure data exchange. And this is the core evidence gathering phase. Fieldwork is the core evidence gathering phase. That's the first thing to do when it comes to fieldwork, is to determine whether the review will be conducted on site, or be carried out remotely. Then there is review control system. Review of quality control system, and this is not just system but documentation, because every system has documentation. So the reviewer carries out review of quality control system documentation. The reviewer examines the documented policies and procedures related to all elements of quality control, for example, leadership, ethics, client acceptance, human resource, engagement performance, monitoring, and so on. Then the reviewer assesses whether these policies are suitably designed to achieve compliance with professional standards. That's what is done under fieldwork. That is the second thing, is to review the quality control system documentation. Go through the documents. Then engagement file reviews. There is number 3, engagement file reviews. What does that mean? Now, for the selected governance and compliance audit engagements, because candidates fieldwork, at the point of fieldwork, at the point of planning, the reviewer takes a sample of the audit engagements that is going to review, the engagements that were done, the governance and compliance engagements that were carried out previously by the review entity. So a sample is taken. The auditor may select, say, 5 governance and compliance audit engagements. 5. Then he takes the files for the 5 audit engagements. The selected governance and compliance audit engagements. The reviewer performs detailed walkthroughs and substantive reviews of the audit documentation. And that involves assessing adherence to the firm's own quality control policies, evaluating compliance with professional audit standards. It also may include determining if the audit conclusions and reports are appropriately supported by the work performed. It may include assessing the clarity, accuracy, and completeness of the governance and compliance audit reports that are issued. Engagement file reviews. You select several governance and audit engagements that were conducted by the reviewed entity, then go through the engagement files. Identify all the areas of the engagement, audit engagements, and so on. Engagement file reviews. Number 4, interviews. Candidates, we are discussing the peer review mechanism stages. Stage 1 is planning and engagement. Stage 2 is fieldwork. Stage 3, engagement file reviews. Stage 4, we have interviews. The peer review team conducts interviews with cross-section of personnel, including the management responsible for the managers or for the audit practice. It could be the audit director or the partner in charge. We may have engagement leaders and managers, the staff auditors, the staff auditors, and even personnel responsible for HR, for training, and independence. Here we are talking about the personnel of the audit firm because we are reviewing the work that is done by the auditor. So interviews are conducted with the staff of the audit firm. You understand? And these interviews aim to confirm understanding of policies, to assess practical application, and gather insights into the firm's culture of quality, the audit firm's culture of quality. We may also mention observation. This is a stage in peer review mechanism. In some cases, the interviewer or the reviewer might observe certain processes or meetings to gain a deep understanding of operational aspects relevant to quality control. That is step number 2. Then you have stage 3. Stage 3. The third stage is reporting and communication of findings. Reporting and communication of findings. Number 1. Stage 3 is reporting and communication of findings. Reporting and communication of findings is the third stage, which involves drafting findings and recommendations. 1. Drafting findings and recommendations. That's the first thing to do at the third stage. As work progresses, the reviewer identifies areas of non-compliance or non-conformance with the professional standards or weaknesses in the quality control systems, and these findings are documented along with the supporting evidence. Then recommendation is made for improvement. Recommendations are done what? For improvement are developed. That's the first thing you do at the reporting and communication stage. Then there is exit conference. The second thing, you have what we call exit conference or discussion of preliminary findings. Preliminary findings. Now at the reporting stage, first of all, the reviewer drafts findings and recommendations. Then after that happens, as the peer review team here candidates holds an exit conference or meeting with the reviewed entity management to discuss preliminary findings and recommendations. This is a discussion with the firm that is being reviewed. The reviewer conducts a meeting, a discussion to discuss the preliminary findings, because after drafting the findings, then these findings are discussed in a meeting with the management of the firm that is being reviewed. And this is a critical stage for the reviewed entity to understand the findings. The reviewed entity may also provide additional context or information that might clarify the issues. At this stage, they also agree, the two agree or disagree with the findings. And then they discuss the feasibility or recommendations. And these discussions helps ensure accuracy and completeness of the final report. It also avoids surprises. Before drafting the final report, the initial findings are discussed with the management of the entity that is being reviewed. Then we may have management response. Management responses. The responses from management, what we may call corrective action plan. Here, candidates, the reviewed entity is typically required to provide a written response to the peer review findings, outlining their agreement or disagreement, and importantly, detailing corrective action plan. Okay? With specific steps and timelines for addressing identified deficiencies. So I want to see the chronology, candidates, at the reporting and communication of findings. After the field work, because here the reviewer gathers evidence. After conducting the review of the quality control system, after carrying out review of various engagement files, after holding meetings with the entity that is being reviewed, after observing processes, the peer reviewer gathers enough evidence, which evidence in the third stage, the reviewer drafts the findings and recommendations. Then they hold a conference or a meeting where these findings are discussed openly, with the reviewed entity also providing additional information. Now, the reviewer may have identified deficiencies in the quality control system or even weaknesses in failure to adhere to professional standards or ethical guidelines for auditors. If that's the case, then the management is required to make responses, to respond. the management is required to come up with a corrective action plan. The reviewed entity is typically required to provide a written response to the peer review findings, outlining agreement or disagreement, and also detailing corrective action plan with specific steps and specific timelines for addressing any identified deficiencies by the reviewer. You understand? Then, of course, the next obvious stage, number 4, is preparation of peer review report. Preparation of peer review report is the 4th stage. Is the next thing to do, preparation of peer review report. The peer reviewer prepares the formal peer review report, which generally includes the scope and period of the review. The report also includes description of the methodology used. It must also have a conclusion or opinion on the design and operating effectiveness of the quality control system, and also detailed findings, observations, and recommendations, together with the reviewed entity's responses and correction plan. The report is then typically assigned what we call rating. It could be a pass, or a pass with deficiencies, or fail for system reviews, and so on. So preparation of peer review report. I've explained what should be contained in the report. I repeat, this report includes the scope and, number 1 is the scope and period of review. Number 2, description of methodology used. Number 3 is the conclusion or opinion on the design and operating effectiveness of the quality control system. And then we have the detailed findings. And lastly, the reviewed entity's response correction plan. Step number 3, stage 3. Then stage 4, let me have stage 4 here. Stage 4. Now the 4th stage is the review and acceptance of or by administrative entity. Review and acceptance by administrative entity. Now the completed review report along with the reviewed entity's response is submitted to the relevant administrative entity, and this could be an oversight body. The administrative entity could be an oversight body. And here, the body, which could be a professional accounting body or the Institute of Internal Auditors Quality Control Assurance Services, may perform an independent review of the peer review report and even reviewing the supporting documentation to ensure that the review was conducted in accordance with the peer review standards, to ensure also that the findings are adequately reported and that the conclusions are appropriate. They also check if the corrective action plan is reasonable and sufficient. After that happens, this oversight body may communicate with both the reviewer and the reviewed entity for clarification. That is the 4th stage. So the first thing to do here is to make submission. Is submission to the administering entity or oversight body. Submission to the oversight body. submission of the peer review report is made to the oversight body. The completed peer review report, along with the reviewed entity's response, is submitted to the relevant administering entity. It could be the internal audit control assurance services and so on. Then after the peer review report is submitted to this oversight body, the oversight body then carries out what we call oversight review. Oversight. So candidates, I want you to understand that the entity that is being reviewed is the audit firm. It's the audit firm or the governance and compliance audit firm. So we have the governance and compliance audit firm is reviewed. Okay, the work that is done by this audit compliance firm is reviewed by an independent reviewer, peer reviewer. The peer reviewer, we said, selects a sample, okay, of engagements that were conducted by this audit firm. It may be 5 audit engagements or 10 or whatever number, because the governance and compliance audit firm carries out governance and audit of different entities. There could be many in a year, but the peer reviewer may select a sample which the firm systematically and independently evaluates. Okay? The peer reviewer evaluates and determines if the firm has adhered to professional standards, to ethical standards, and also to check if the quality control system is in order. Okay? So the peer reviewer, at the end of the audit or at the end of the review, this peer reviewer has to prepare a peer review report. This peer review report is then submitted to an oversight body. That means that this peer reviewer, the work of the peer reviewer is again reviewed by an oversight body, because the report is submitted to the oversight body or the administrative entity, which reviews the peer review report. So the administrative entity reviews, okay, that peer review report, because this body may set up a review committee, or the staff of this body may perform an independent review of the peer review report. So the peer review report is subjected to, again, review. And the purpose is to check if the review was conducted in accordance with the peer review standards. When conducting review, this peer reviewer is required to conduct these reviews in accordance with the peer review standards. So the oversight body here, the oversight body reviews to determine whether the peer reviewer conducted the review of the governance and compliance audit firms in accordance, to check if it was conducted in accordance with the peer review standards. You understand? The oversight body also conducts this review to determine if the findings are adequately supported. Because in preparing the peer review report, the reviewer has to ensure that he has sufficient evidence to support the findings. The reviewer, furthermore, the oversight body, furthermore, carries out this review, okay, to check if the conclusions are appropriate and if the corrective action plan is reasonable and sufficient. Because you recall here that the management has to make responses. At the third stage, you recall, we did mention that after conducting the peer review, the reviewer drafts initial findings, okay, which are shared with the entity in a conference. And the reviewed entity is required to make responses, and the responses may include coming up with a corrective action to correct any deficiencies that may have been identified by the you understand? So the oversight or the administrative body checks if the conclusions are appropriate, if the corrective action is reasonable and also sufficient. Then this body, again, the administrative body, may communicate with both the peer reviewer and the reviewed entity for clarification. You understand? So we have oversight, review, then there is acceptance of report. After oversight review, there is acceptance report. What does that mean? Now, if satisfied, the oversight body formally accepts the peer review report and also the corrective action plan. So the corrective action plan is part of the report. The plan, don't forget, is developed by the firm that is being reviewed in response to the findings that are discussed or submitted to the firm by the reviewer. So there is acceptance of report by the oversight body. So the reviewed entity receives formal notification of the acceptance and its peer review rating. So that's the process, candidates, up to this stage. But we have the last stage in peer review mechanism. Here is remediation and follow-up. Yeah. Stage 5 and follow-up. Remediation and follow-up. This is the stage of implementing the corrective action. Implementation, number 1 is implementation. That is number 1. The reviewed entity implements the agreed upon corrective actions to address the deficiencies identified during the peer review. And this is crucial for realizing the benefits of the review. Because candidates, if the corrective action is not implemented, then there was no point of carrying out the review in the first place. So the firm that is being reviewed has to implement the corrective action plan. Corrective action plan is implemented. That's the first thing that happens. Then there is the follow-up by the oversight body. Follow-up, oversight body. After the action plan is implemented by the reviewed entity, then the oversight body has to make follow-up, because for significant deficiencies or fail ratings, the administrative entity will often require documented evidence of remediation, or they may conduct a follow-up review to ensure that the corrective action plan or actions have been effectively implemented. And failure to implement or to remediate deficiencies can lead to sanctions or loss of good standing with the professional body. Good standing with the professional body, because auditors candidates must adhere to professional standards. They are required to adhere to the guidelines, to the regulatory framework. And therefore, if the governance and compliance audit firm does not remediate the failings, then that may lead to sanctions or even loss of good standing with the professional body. And that's all for peer review mechanism stages. There are 5 key stages. We've discussed the 5 key stages, beginning with stage 1, planning and engagement. This is peer review mechanism stages. Stage 1 is planning and engagement, where the reviewer is selected and appointed by the firm that is being reviewed. This is the governance and compliance firm. The governance and compliance firm, the governance and compliance audit firm is the firm that is being reviewed by an independent reviewer. So this firm must, first of all, the audit firm must select and appoint a reviewer. That's the first thing to do. Then after appointing this reviewer, there has to be an initial communication and agreement. There will be an engagement letter where the two agree on the scope, the objectives, the responsibilities of each party, the standards, and everything that pertains to the engagement. Then we also have a pre-review information gathering. The reviewer here gathers information from the client. He will come up with a questionnaire where the client is supposed to fill in so that the reviewer can get information about the entity that is being reviewed. Then step number 4, under planning, is coming up with a plan. The reviewer develops a plan. Step 2 is to go to the field. Having develop the plan, then the obvious step is to go to the field work, and the reviewer should decide whether it's going to carry out this review on site or remotely. On site means visiting the reviewed audit premises and carrying out these assessments. Do you understand? There is also the review of quality control system documentation. Now this is where the reviewer begins to get evidence, to gather evidence. Then there is engagement of file reviews. Okay. The here candidate means that the reviewer selects a sample of the previous audit engagements, samples them, then reviews the files. May carry out interviews and observation. That is stage number 2. Stage number 3 is reporting and communication, which involves drafting findings and recommendations. We have exit conference or discussions of preliminary findings. Then the management is required to make responses or to develop a corrective action plan, because the purpose of carrying out this, one purpose of carrying out this review is to identify any deficiencies in the quality control system. If there are deficiencies that are identified, the management is called upon to develop a corrective action plan, which is part of the responses. Then, after which the peer review report is prepared. Then, having the peer review report being prepared, this report in stage number 4 is submitted to the oversight body or the administrative entity, which carries out again review. All right. The basis of this review is the peer review report. Then there is the acceptance report at the end of the oversight review. Then in step number 5 is remediation and follow-up, which involves implementation of corrective plan that was developed by management in the 3rd stage. Then of course there is follow-up by the oversight body. Follow-up to check if any significant deficiencies have rectified. So this is a systematic approach to peer review, which provides a mechanism for external quality assurance, which drives continuous improvement in governance and compliance audit profession. And that's all for our today's lesson on peer review mechanism stages. There are 5 stages. Thank you for attending this lesson. Bye-bye.
Now, you can look at a similar question, the previous question. You can look at a previous question. It has been tested just a few semesters back. Let's go to September 2021. September 2021. September 2021. Question who? 5B. September 2021. Question 5B. The question is saying the standard cost of certain chemical mixture is 40% material A at 20 per kg, 60% material B at 30 per kg. The standard loss of 10% is expected during production. During the month of July, the actual data was as follows. Material A used 90 kgs at a cost of 18 per kg. Material B used 110 kgs at a cost of 34. The weight produced was 182 kgs of good production. Let's start by getting our material mix, our material price variance. Our material price variance, you say it is your actual quantity, standard price minus actual price, Your actual quantity, you have 2 types of materials, A and who? B. The actual quantity you purchased was 90 kgs. The standard price per kg was 20 minus an actual price of 18. For material B, your actual quantity was 110. Standard price per kg was 30 and your actual price per kg was 34. 30 minus 34. This must be 180. That must be 400 and what? 40. The standard or the material price variance here for A, you had budgeted to buy at 20, but instead of buying at 20, you bought at what? 18. So that's good. So that is what? Favorable. B, you had budgeted to buy at 30, ended up buying at 34. So that is also what? That is adverse because you've spent an extra amount. Then you confirm what kind of variance this is, and this is 250, which is what? Adverse. 260, which is adverse. That is your material price variance. Let's get our material mix variance. And how do you get your material mix variance? You say it is your standard price, your actual quantity in standard mix minus your actual quantity in actual mix. Standard price, actual quantity in standard mix minus actual quantity in actual mix. And actual is standard price B. The standard price of A is 20, B is 30. Your actual quantity that was used is 90 for A and 110 for B. Your standard mix, the ratio of how you are using your materials is 40:60. That is 200. That is 100. Therefore, actual quantity in standard mix, you simply over 100 times 200. That is 80, and that is what? 120. All right. Your actual quantity in actual means we said, in actual mix we said is your actual quantity. So let's get your material mix variance here. Your standard price is 20. Actual quantity in standard mix is 80 minus an actual quantity of 90, 200. Standard price of 30. Actual quantity in standard mix of 120. Actual quantity in actual mix of 110. This will be adverse, favorable. So that in total, that will be 100 favorable. Okay. The next item they are asking us to determine is your material yield what? Variance. Material yield variance. We said, how do you get that? You simply take your standard material cost per unit into bracket your standard yield minus your actual yield. Standard yield minus actual yield. Let's determine our standard material cost per unit. They were saying there that the standard cost of material of a certain chemical, 40% of material B was bought at 20, 60% of material B was bought at 30. So therefore, your material cost per unit, you're going to take those percentages times the price of each. Which will be 26. That should give you 26. Let's determine our standard yield. Then now need to determine our standard yield. Now they were saying the standard cost of a certain chemical mixture is 40 and 60, and a standard loss of how much? 10% is expected during what? Production. Okay. So this is what we do here. We first identify the input materials that were introduced and the output that was done what? Produced. Okay. And here with an 100% input of materials, with an 100% input of materials, your output was 90%. Your output was what? 90%. Why? Because of a standard loss of 10%. 10%. Okay. If you introduce 200, this can ignore this percentage here. That way. If you introduce 200, how much should have been your standard yield there? Your standard yield should have been 180 units. If you are to use the material in the same way you are using according to what you budgeted, you should have produced 180 units. So your yield variance will be 26 180 minus an actual yield of 182. Your actual yield is 182. This is 52, which we are going to say is what? This is an output. This is output. So yield means output. So we are going to say it is what? Favorable. Favorable. Okay. Your material usage variance, it's going to be your material mix variance plus your material yield variance. Plus your material yield variance. Your mix variance is 100 favorable. Your yield variance is 52 favorable. So that is 162 what? Favorable. Let's determine our material cost variance, which is your material price plus your material usage variance. Your price variance is 260 adverse plus 162 what? Favorable, which means that is 98 what? Adverse. 98 adverse. And that is how you determine your what? Your advanced variances of who? Of material. Those are the advanced variances of what? Material. All right. Now that we have understood the advanced variances of material, we also should look at the advanced variances of labor, the advanced variances of fixed overheads, and also the advanced variances of sales revenue. Okay. All right. I hope that has been clearly understood. That has been clearly understood. That has been clearly understood. Right. Now, when we meet in the next lesson, we will introduce the advanced variances of what? Labor. We will introduce the advanced variances of labor, which will be in the next lesson. So from me, you can attempt a question, to give you a question that you can attempt in your own free time. You can look at August 2022 question 5B as an assignment, just for your practice. Your assignment. Please look at this question for your own practice. August 2022 question 5B. Question 5B. There is a variance of what? It is an advanced variance of materials. All right. So allow me, and on behalf of the institution, or on behalf of Manifested Publishers, we can call it a day. See you next time when we will tackle labor variances and overhead variances and sales variances that are advanced in nature. So goodbye and God bless you. See you next time.
Greetings, candidates, and welcome to the Manifested e-learning platform. The subject is Advanced Financial Management. We continue with the topic mergers and acquisitions. In our today's session, we're going to discuss the arguments for and against the use of mergers and acquisitions as tools for corporate expansion. Why would companies choose to merge? Why would a company choose to acquire another one as a tool for corporate expansion? Because by now we are aware that mergers and acquisitions are tools that companies use for corporate expansion, but these tools come with both potential benefits and significant risks, benefits and disadvantages, advantages and disadvantages. These advantages are what we are calling arguments for mergers and acquisitions. So what are the arguments for the benefits? We begin with the benefits, then we'll move on to the disadvantages. Why would companies choose to merge or companies choose to acquire other companies? One reason is to increase market share. Increase market share. One obvious benefit that may accrue to a company, increasing the market share. Acquiring or merging with a competitor can rapidly expand a company's customer base and market presence. That is one benefit. Second benefit for mergers and acquisition is the economy of scale. Economies of scale. Combining operations through merging can lead to cost savings through shared resources, bulk purchasing, and streamlined processes. That can lead to economies of scale. Access to new markets. New markets. Mergers and acquisition can provide a company access to new markets and technology. Mergers and acquisitions, in other words, can provide a quick entry into new geographical regions or access to innovative technologies that would take years to develop organically or internally. Look, a company waiting to grow organically, to grow internally, the company can choose to merge with another one so that the benefits can be enjoyed quickly. Access to new markets, technology. Number 4 benefit is diversification. Diversification. How is diversification a benefit? Now, acquiring companies in different industries can reduce risk by diversifying revenue streams. Diversification. 5 is enhanced competitive advantage. It can lead to enhanced competitive advantage. Mergers and acquisitions can lead to enhance competitive advantage by combining strengths. When companies come together, companies combine strength, that can create a stronger and more competitive advantage. 6, faster growth. Faster growth. Mergers and acquisitions can lead to faster growth. Mergers and acquisitions, in other words, can allow for rapid expansion compared to organic growth. Now, the list is not complete without mentioning synergy. Synergies. The combined company, after merging, often achieve more together than the individual companies could separately achieve. We always say two are better than one. What two companies can achieve together far much outweigh what each individual companies can achieve separately. That's what we're referring to as synergies. So these are 7 benefits. Let's discuss the disadvantages of mergers and acquisitions. Disadvantages or arguments against use of mergers and acquisitions. What are the disadvantages? One is the disadvantages or challenges. We have integration challenges. When companies merge, there is always that difficulty or challenges when it comes to integration, merging different company cultures, merging the different systems of a company, merging the processes. That can be a complex exercise, and that is one challenge that comes with mergers and acquisitions. How to merge the different corporate cultures, company cultures, the processes, the systems, and so on. 2, cultural clashes. Cultural clashes. Differences in corporate cultures can lead to conflicts. It can lead to employee dissatisfaction and also decreased productivity. Cultural clashes. 3, financial risks. There are also financial risks that are associated with mergers and acquisition transactions, which may involve significant debt. For a company to purchase another company, the acquirer or the predator may be required to seek for debt, which can lead to financial risks. So mergers and acquisition transactions often involve significant debt, and there is a risk of overpaying the target company, which may lead to financial risks. We also have challenges associated with complying with regulations. M&A deals are subject to regulatory scrutiny, particularly the competition laws, which can delay or even block transactions. Another challenge is associated with employee morale, employee morale and turnover. This is yet another challenge associated with mergers and acquisitions. Employee morale and turnover. Mergers and acquisitions can create uncertainty among employees, and that can lead to anxiety, that can lead to decreased morale, and ultimately high turnover is a challenge which the management should take note of during mergers and acquisitions. When employees are told that the company is going to be acquired, that can lead to anxiety, uncertainty, and that affects productivity, and it may increase turnover. That is disadvantage number 5. Number 6 is valuation difficulties. Valuation challenges. During mergers and acquisitions, it may be necessary for the company that's merging or the company that is being acquired to be valued. So accurately valuing a target company can be challenging, and we've seen in the past companies overpaying. That is a common risk, overpayment, because payment is based on valuation. If no proper valuation is done, then company may end up being overpaid and so on, and that can be a great challenge. 7, failure to achieve synergies. Failure to achieve synergies. One of the main reasons for merging and acquiring companies is to achieve synergies. But sometimes the anticipated benefits of mergers and acquisitions may not materialize, which may lead to financial losses. That is number 7. The 8th and last disadvantage here is disruption of core business. Disruption of core business. Disruption of core business. Mergers and acquisitions can sometimes affect the operations of an entity. They can divert the management's attention. Mergers and acquisitions can also divert resources from the company's core business, and that is a challenge. So these are 8 disadvantages or arguments for and against use of mergers as tools for corporate expansion. There are other tools that companies can use when planning expansion, like what we call developing the internal processes can also be another way to expand. You understand? What we call organic growth. A company can grow organically, or company can choose to merge or acquire another one in order to achieve corporate expansion. In our next session, we will be discussing the mergers and acquisitions versus organic growth. For now, we take a break from today's lesson, where we've discussed the arguments for and against the use of mergers and acquisitions. Thank you for attending the lesson. Bye-bye. Greetings, candidates, and welcome back to the Advanced Financial Management class. Today we continue with the topic mergers and acquisitions. So far, we've studied the nature of mergers and acquisitions. We discussed the arguments for and against the use of mergers. We went ahead to highlight some of the evaluation models, the defense tactics against hostile takeovers. Today we move on to the next subtopic, which is financing of mergers and acquisitions. Now, after the evaluation of a target, the company has to figure out which method to use to finance the acquisition. And there are various ways. The company can choose to do what we call outright purchase using cash. There could be share for share exchange, share debenture exchange, and share preference exchange. In this lesson, we're going to discuss the various methods that can be used in financing mergers and acquisitions. And the first method is outright purchase using cash. outright purchase using cash. The second method is share for share exchange. Number 3, we have the share debenture exchange. Share debenture exchange. 4 is the share preference exchange. Outright purchase using cash, number 1. Number 2, share to share exchange. Number 3, share debenture exchange. Number 4, share preference exchange. In this lesson, we're going to highlight the advantages and disadvantages of these methods. We're going to also discuss how the methods can be used. First of all, let's begin with the share purchase using outright cash. Share purchase using outright cash. After valuation of a target, the acquirer may decide to pay or to purchase the target using cash. So when discussing the financing of mergers and acquisitions, an outright purchase using cash refers to the straightforward transaction where the acquiring company pays for the target company entirely with cash. Entirely with cash. If the agreement is, say, 100 million, the acquirer pays the 100 million transaction in cash. Straightforward. Do you understand? So the target company shareholders receive immediate cash. They receive immediate cash payment for the shares. They receive immediate cash for their shares. So shareholders of the target company receive immediate cash for their shares. They receive immediate cash for their shares. So that is one feature of outright purchase using cash. It is a very simplified transaction compared to other financing methods like stock swaps or cash acquisitions, and cash acquisitions tend to be simpler compared to share, compared to share debenture exchange, compared to share preference exchange. This one is simpler. It is a simpler transaction. It's like going to a yard and just paying for a car, or going to a market and you pay for a commodity. It is simple. You pay the seller and the transaction ends there. There are very few complexities related to valuations and potential fluctuations in stock prices. Another aspect here is control and ownership. Control and ownership. The acquiring company gains full control, full and immediate control of the target company. And there is no dilution of ownership. There is no dilution of ownership for the acquiring company's existing shareholders. Control and ownership is immediate. Financial resources. This method requires financial resources. For the target company to effect this transaction, the I mean, for the acquirer to effect this transaction, then the acquirer has to have financial resources. Financial resources. The method requires the acquiring company to have substantial cash reserves, or the company should have the ability to raise significant capital. You understand? So this method comes with the advantages, what we call pros, and disadvantages, what we are calling cons. Now, the first advantage of financing of mergers and acquisitions using outright purchase using cash, is certainty for the seller. Certainty. Certainty is an advantage for the seller. The target company shareholders receive immediate and guaranteed payment. Immediate and guaranteed payment, which then eliminates uncertainties associated with stock fluctuations. There is that element of certainty. Simplicity, speed and simplicity is another advantage. Speed and simplicity. Here we say that is a simple transaction. Cash transactions tend to be quicker and less complex than those involving stock exchanges, like the share-to-share exchange, the debenture, share debenture exchange, and so on. Simple and quick. Speed and simplicity. Clear valuation.